Hi, chat. Musta said, "Why would you set your own time and be late?" Well, it starts at 9, and I had a Clyde issue. Um, well, it wasn't really Clyde. I thought one of the dogs had peed on a rug, so I had to check and make sure it wasn't pee. It turns out it was not pee. I just saw a weird shadow on the carpet. So, yes, had I not looked at that, I probably wouldn't have been late by 2 minutes. So, just to make sure it wasn't a big old pee puddle of pee pee. You wasted 3 minutes of my life. Hmm. Whoops a doodle. Anyways, hi everybody. Day 20 of the Karen Red trial. Also known as the Karen Reed trial. It's not about Karen. It's not about a woman named Karen who can't read, and we're not trying to figure that out. It's actually a woman who's named Karen Reed, and it's about whether or not she killed her boyfriend, John O'Keefe. So let's get over to the courtroom now, and we have the fan of justice still spinning, the hardest working fan in the city of Boston. Some say this fan was made by Miles Standish, one of the original signatories of the Mayflower Compact himself. But that proof has been lost to the sands of time. Really neat fact, though. Participant trophy wife says he decorated it. He did not. He decorated and everything. The fan is the star of the trial, but can Karen Reed? No, I don't know. And yes, Neo Dark Matter is correct, as the prophecy says. When the fan stops, it is the end of the Commonwealth of Massachusetts itself. So yes, the sages every day are worried about this fan. Every day they make their prayers to the machine god. It's very much like Warhammer. Every day they pray to the fan. They pray that it keeps going. They have not had to do a sacrifice to the fan yet. But someday they might, if it so desires. Oh, I hear stuff. I hear rumblings. Yes, praise the Omnissiah. Praise to him. Access, so no headlight glass pieces were found in John O'Keefe. That is correct. So here's what we know so far. Ultimately, and I'm going to mute the fan again real quick. So here's what we know so far. There were no pieces of glass found in John O'Keefe. There were some weird puncture marks all over his hoodie. He had a hoodie on. He had his shoe was found right next to him. The missing shoe. There's no damage to the back of the car. There's like a scuff. But that scuff would have been from a hard object, not a soft object like somebody. It's like a scuff from another piece of metal, another car, or a stationary hard object. I mean, there's no like those plastic bumpers would have shown some damage. I think they would have shown a lot of damage. I mean, they those crumple and crack. It's the middle of winter. That car's cold. Like you start smashing plastic, it will break. Nothing's wrong with it. And then this hair they found on the outside of the car. They found a hair that's apparently John O'Keefe's. Which, when you look at the pictures of him, it didn't look like he's got a big long hair. Like, was that one of his beard? Even his beard hair, like a long curly Q hair. Like, where did that come from on John? And then how did it stay on the car throughout the dead of winter Karen driving all over, kicking up snow everywhere. You know, it didn't get knocked off. Didn't get knocked off when it was trailered to the police station. All that fun stuff. So we have a lot of questions. We have a lot of questions, and the defense is going to continue their cross examination of the forensic people. So now we're getting to it, guys. We're getting to the stuff I told you I wanted to see. And I was reserving my judgment and my thoughts because so far this trial's been a snoozer. Now we're getting to the good stuff. Magoo says, what happened Monday? Well, we saw the pictures we covered it last night. John O'Keefe's clothes. There's some weird things about the way the blood's on this guy's clothes that don't make a lot of sense. There's a bunch of like holes in his sweater. Don't make a lot of sense. Especially not from getting run over. So. Yes, Sean, it's fan service. Yes, very funny, Fire PA 498. You're a funny guy.
You're a funny guy, Sally. I like you. That's why I'm going to kill you last.
Like I said, I promised to kill you last. Charlie's saying, did he have any broken bones in his legs? It does not sound like that, but we need to wait till the end. We need to wait till we get to the medical examiner. They fixed it with flex tape. It's foolproof. Bob says the undercarriage indicates that nobody was dragged, and I don't think anybody like that's a separate point. I'm just saying the back end of the car when people get hit, and they said they think that she hit him like over 25 miles an hour speed wise. There'd be some fucking damage. Yeah, these plastic bumpers, the paint would crack, it would break and flake. I mean, think about you guys in your own personal life. How like after a while, how is it easy to dent a car nowadays? Pretty good. Yes, they did test the hair. Rapoopsel. Oh, Rapoopsel. Let down your hair. And what as the prince climbs and he gets up to the top, he's just like picking out his teeth. Like he's like, oh, you've saved me, Prince. He's like, hold on. That's not good. That's not good, Chad. Doesn't work that way. As your night terror, the Black Dragon says, ooh, add some tits to that fan. I mean, really, if we want it, okay. Where would I put the tits? We could do like some big, some big eyes. Some big anime eyes on this thing. I'm not a big anime person, chat, so you got to work with me here. I don't have a fill option. God, this is so hard to do. But you know what? Why don't I just do a bigger brush and then erase out? That makes more sense. That makes a lot more sense, Sean. You're. Oh, well, we might have. And then it's gonna be like, oh no! It's like, ah. It's like, oh, Beverly Cadona-san, I can't fit in there. No. Oh, here we go. I assume his name's like Carl or something, because he's got to have a name like Carl.
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice W. Canoni, now sitting in the Dedham Superior Court with and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth and this good court. Thank you. You may be seated for now in session. Good morning, Your Honor.
Good morning. Thanks.
Yay.
22-117, the Commonwealth versus Karen Reed. Counselor, could I have you identify yourselves for the record?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson from the Street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also.
Good morning, Ms. Little.
Good morning, Your Honor. David Unetti for Karen.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. Good morning, jurors. So I have to ask you those same
They haven't
three
got to that
questions.
part
Were you
yet. Give
able
it
to
time.
Follow the instructions and refrain from discussing this case with anyone since we left here on Monday. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case since we were last here? Everyone said yes or no.
Just watch your step again.
Name, stand, and face the card.
You raise your hand. You solemnly swear the evidence you have recorded in jury in the case now here to the truth, the whole, and nothing but the truth, so help you God.
I do. Sure. VALLIER.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, ma'am.
Morning.
Now, Ms. Valier, when we had left off the other day, I believe you had just looked at some photos of item 7-16. Is that correct? If you recall.
It's been a few days.
That's what, Your Honor.
Yes.
And Ms. Valier, I'm going to show you a series of 6 photographs. Ask you to just review those.
All right, so I'm going to remind both of you to keep your voices up. Mr. Lally, when you're facing the witness and you're this close, I guarantee you nobody behind you can hear you.
Understood. Hey, Ms. Valier, do you recognize what's in those photographs?
Yeah.
And what do you recognize those to be?
Photos that I took of item 7-16.
May I approach the witness, Your Honor?
Yes.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibits. Can I just see them, please?
No objection.
Oh, I guarantee you she had a fucking discussion with these guys about staying on mic. Very, very much so.
Your Honor, for the record, those are exhibits 332, 333, 369, 370, 371, and 372.
Thank you.
Yes, 332 and 333, which skipped over.
Thank you.
Thank you, Your Honor. With the court's permission, may I have those published for the jury?
Yes.
And Ms. Gilman, if I could have photograph 2059.
Yeah.
And Ms. Blair, do you recognize what's up on the screen as that photograph, which is now marked as exhibit 332?
Yes.
Is that one of the items from 7-16 next to the ruler with the measurements corresponding to that item?
Yes.
And Ms. Gilman, if I could have photograph 2081. I believe 2061. I apologize.
Yes, Charlie. Did you have a good snooze at work?
Is that
I wanna know.
piece from 7-16 that's now been marked as Exhibit 369?
Yes.
Now, Ms. Weir, as far as this particular item is concerned, with reference to sort of the texture of that particular piece of plastic, what, if anything, did you note or observe in reference to that?
I'm sorry, the texture?
I'm sorry, do you have the laser pointer in front of you or no?
Oh, yes.
Now, as far as the surface area of that particular piece of plastic, how would you describe that?
I mean, there are little dots on it. They're just like dimples of a sort.
Stippling or dimples of some sort on a piece of plastic?
Yes.
And as far as those sicklings or dimples on the piece of plastic, were those flush with the rest of the plastic? Were they raised a little bit? How were they sort of configured?
I don't recall.
And Ms. Gilman, if I could have photograph 20. Forgive me, Your Honor. 064.
Sorry, Charlie. Did your
And again,
meetings
this way,
still
what's
working
up on the
keep you up?
screen has now been marked as Exhibit 371. Do you recognize that?
I do.
And that is another piece next to a ruler, essentially memorializing its measurements from item 7-16. Is that correct?
Correct.
Thank you. Your Honor, may I approach the witness?
Yes.
Ms. Lear, I'm showing you another series of 11 photographs. Ask you to look at those and look up to the finish.
Can you tell Mr. Yannetti what those are so he can look at his copies?
Counsel was shown each and every one of the photographs prior to the court coming in today. But I'm happy to give them to counsel as well.
I'm just trying to.
That doesn't matter. I still want to check them. You have the right to check those. So, I already showed them. Yeah, sorry, I don't trust you. I don't trust you as a defense attorney. And I don't blame Yannetti for not trusting him either.
Save some time.
Right, I just need to know the particular evidence numbers at the end.
Yeah.
Okay.
Just need to know what's going on.
Do you recognize those?
I do.
And what do you recognize those to be?
Photos that I took of item 7-16.
So additional items contained within item 7-16, is that correct?
Yes.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed during the course of your examination and analysis in regard to item 7-16 in this case?
Yes.
Thank you. Your Honor, the Commonwealth will seek to introduce and admit as the next 11 exhibits.
Any objection?
I'm not going to have an objection, but again, I just need to know what numbers. Can you just have a moment, Ron?
Exhibits 373 through 383, Your Honor.
Thank you.
And Your Honor, with the court's permission, if I could publish some of the photos from this packet for the jury.
Okay.
Ms. Gilman, if I could have photograph 2036. And Ms. Blair, do you recognize what's up on the screen as Exhibit 373?
That was one of the photos I just looked at.
And as far as the evidence back containing items from 7-16, is that correct?
Yes.
And Ms. Gilman, if I could have 2039. And again, Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 374?
I do.
And what do you recognize those to be?
A photo that I took of item 7-16.
And that would be the entirety of the items contained within that evidence back from the prior exhibit, is that correct?
Yes.
And Ms. Gilman, if I could have 2051. And again, Ms. Blair, do you recognize what's depicted up on the screen?
I do.
And what do you recognize that to be?
A photo I took of item 7-16.
And in particular, one of the,
Can you speak up a little, sorry,
Yeah.
a little bit
Yes.
slower? Thank you.
in particular, one of the red plastic pieces from item 7-16, is that correct?
Yes.
And for the record, Your Honor, that's Exhibit 376.
Okay.
And Ms. Gilman, if I could have photograph 2053. And again, Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 378?
I do.
What do you recognize that to be?
One of the photos that I took of item 7-16.
And lastly, from this batch, Ms. Gilman, if I could have photograph 2055. And again, Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 38?
I do.
And what do you recognize that?
It's one of the photos that I took of item 7-16.
And this particular item up here as Exhibit 380, you describe sort of color, shape, what you observed from this particular item.
That's a piece of red and clear apparent plastic.
So a piece of red plastic with a piece of clear plastic sort of within the same piece. Is that fair to say?
Within the same piece?
Yes.
Sorry.
Apparent plastic, yes.
Thank
It's actually not wrong for her to say it's apparent plastic, because at that point she's like, yeah, it's a picture. I don't know what that is technically. It looks like it's plastic. That's the actual scientific thing she should be saying there.
Now, Ms. Blair, if you could,
Especially if she didn't take the picture.
describe for the jury again, just as far as the process that
Can we
you-
put the lights on, Mr. Lally?
Yes, I'm sorry. My apologies, Your Honor.
No, it's okay. Thank you.
Ms. Blair, if you could explain to the jury again sort of the process that you undertook as far as these various pieces from these various evidence item numbers. What was the process that you undertook as far as doing your comparison?
So first of all, everything is documented. Each item is documented separately with photographs, notes. I put a label with the case number, item number, and then A, B, C, etc. If there are multiple pieces in it, a label on each piece. I look at the photos to see if there are any similarities, dissimilarities, to see if there are any potential pieces to compare. And then if I do think that there are pieces that could be compared, I'll open those items and keep them all separate, and then look at them in real time to see if it does actually look like they could be consistent before I bring them close together. And if it still looks like they could be consistent, then I'll bring them together to see if there is an actual mechanical fit, and then I'll document that and look at it under the stereo zoom.
And the device or the instrument that you're looking at, again, could you describe for the jury again what that is?
So the stereo zoom is also called a stereo microscope. It's a microscope that is on a stand, so you can put larger pieces of evidence underneath it.
Now, as far as that initial sort of looking at things together, are you doing that? How are you sort of organizing that? Is that by item number, by color, or by something else?
I did this by color because it seemed the easiest way to organize all of these pieces.
And then within the individual item number, say just randomly 7-15, for example, are you looking at that? If there's multiple pieces within an item, are you looking at the consistency within the item prior to looking sort of crossing between 715 to 716? Is that the process?
Sorry, could you repeat the question?
Very long question, very confusing, my fault. So as far as the comparison is concerned, are you looking solely within an item? So if an item has multiple pieces, are you comparing just those pieces within that item first?
As part of my initial examination, when I'm documenting that item, if there are multiple pieces, I'll compare those pieces first.
And then if there are any pieces that are consistent, are you then cross-referencing that item's pieces with pieces from a different item?
Yes.
Your Honor, may I approach?
Yes.
Ma'am, I'm showing you another series of 19 photographs. Just ask you to review those a little bit. And do you recognize what's contained in those photographs, Ms. Valaire?
I do.
And what do you recognize them?
These are photos from my case of either within the same item that had a mechanical fit that I'd then taped together, or of mechanical fits from between different items.
May I approach, Your Honor?
Yes.
Commonwealth seeks to introduce in a minute as the next.
She's for the Massachusetts State Police. She pieced together the tail light and did DNA forensics on John O'Keefe.
I was going to hand them to you after their remarks.
That's fine.
Exhibits 384, 3402. Thank you.
May I speak with counsel for 1 second?
Before you get to the photos, Ms. Valer, if I could just ask, as far as your analysis was concerned with reference to each of these items, if I could, excuse me, just ask you some questions about that. Starting first with item 3-1, that was the passenger side taillight housing, is that correct?
I believe so.
And you analyzed pieces of that along with the sort of housing unit itself, is that correct?
So, oh, do you mean like there was like the taillight and then there were smaller pieces also in the?
Correct.
Yes.
And you took measurements of the various pieces that you observed?
I did.
And did you record those within your notes?
I did.
Do you recall what those measurements were?
Not without looking at my notes.
With the court's permission, may the witness refer to our notes?
Yes.
Your witness is ready, Mr. Willoughby.
And what were those measurements?
Do you want all of them?
Just in yes. I mean, first starting with reference to the taillight housing assembly.
Okay, so the taillight I called piece A in this case, and it measured approximately 14 inches by 9 inches by 8¼ inches.
And then which of the pieces that were contained within that sort of taillight evidence bag did you compare to the taillight housing itself?
So there was a lot of like very, very small pieces that I took pictures of, but they're very, very small, so they were not suitable for comparison, so I didn't look at those. There were some larger pieces that I did that were suitable for comparison, so I did look to see if they fit in with piece A.
And with regard to that analysis of whether or not they fit in with piece A, which of those pieces did you find did fit?
So amongst item 3-1, let's see. Sorry. Yeah, sorry. Piece A and piece B fit together mechanically, and then piece A and piece F fit together mechanically.
F is in Frank.
F is in Frank, yes.
It may be pretty apparent, but if you could, Ms. Blair, just expound upon what you mean when you say they fit together mechanically.
So when things break, they break in a like unique pattern. Like it's pretty different every time. So a mechanical fit is bringing two things with broken edges together to see if they were originally part of the same item. See if they if the broken edges align. And if they do, then that's a mechanical fit.
Now, turning your attention to item 7-5, you looked at those various pieces together as well, is that correct?
I believe so.
And were there any 3 pieces in total from 7-5, so A, B, and C, is that correct as well?
May I look at my notes? Yes.
And what, if any, match did you find with within item 7-5?
There were no mechanical fits amongst those three items, or three pieces of the item.
And with reference to item 7-6, there were two pieces, A and B, within that. Is that correct?
You
May
can
I?
look.
Okay. Yes.
And were there any physical matches within those two pieces of item 7-6?
No.
Now, turning your attention to item 7-8, do you recall how many pieces were contained within that?
If I may look at my. There were 14 pieces.
And of those 14 pieces, they were each compared to each other. Is that correct?
Correct.
And what, if any, mechanical fit did you find between the pieces contained within 7-8?
So pieces C and D were found to fit together mechanically, and then pieces E and F were found to fit together mechanically.
Your Honor, may we approach, please?
You.
Oh, we got a sidebar. Here we go. Oh, we caught up too, all the way in chat. We caught up. Hello. It's so glorious. All these pieces were non-binary. All right. Real quick. Yes. Unhung Hero says, I'm going to come. Watch this blog. And then a couple more from Unhung Hero. Says, they, them seems uncomfortable. Cross will be rough. Well, it's rough doing this. The biggest trial of her life.
Ms. Valer, turning your attention to item 7-9, you analyzed three pieces from that. Is that correct?
Go ahead and look.
Okay.
You know what, Mix Valaire, you can just look the whole time.
Okay. Sorry, could you repeat your question?
How many pieces were contained again within item 7-9?
7-9.
Yes.
Three pieces.
And what, if any, physical matches did you find contained within that item 7-9?
There were no mechanical fits.
And with reference to 7-10, how many pieces?
One piece.
And with reference to item 7-11, how many pieces contained within that?
6 pieces.
And what, if any, physical matches did you find contained within 7-11?
There were none.
In 7-11, how many different colors of pieces were contained within 7-11?
There was black, red, and colorless apparent plastic.
Now, with reference to item 7-12, how many pieces were contained within that?
There were 14 pieces.
And of those pieces, again, how many different colors or how many different colors of pieces were within 7-12?
They were all colorless.
And from those, what, if any, mechanical fits did you observe or did you find within item 7-12?
Okay. So there were 3. Do you want me to say all the pieces that fit together?
Please.
Okay. So pieces B, C, D, F, and K all fit together. Pieces E and I fit together. And pieces M and N fit together.
Now, turning your attention to item 7-13, how many pieces were contained within item 7-13?
3 pieces.
And how many different colors of items were contained within 7-13?
It was red and black apparent plastic.
What, if any, physical matches did you find within item 7-13?
There were none.
Turning your attention to item 7-14, how many pieces were contained within that?
There was 1 piece.
And what color was that one piece?
It was colorless.
And turning your attention to item 7-15, how many pieces were contained within that?
There were 8 pieces.
And as far as those 8 pieces, how many items were of different color? What color were they?
They were red and colorless apparent plastic.
And of those 8 pieces, what, if any, mechanical fits did you find within them?
So piece F and piece H were found to fit together.
And turning your attention to item 7-16, how many pieces were contained within 7-16?
There were 7 pieces.
And of those 7 pieces, what, if any, differences in color were the 7 pieces within 7-16?
It was red and colorless apparent plastic.
And of those pieces, what, if any, mechanical fits did you find within 7-16?
So pieces A, C, and D fit together mechanically.
Now, with reference to those pieces, once you did those inspection from or analysis from the individual items, what, if anything, did you do with those individual items with reference to the taillight housing?
So before even comparing it to the taillight, I compared all of the questioned items to each other. So that's the 7-5 to 7-19 to see if any of those pieces would fit together. And amongst those, I was able to make 5 larger pieces that I called piece 1 through piece 5.
And of those larger pieces, which of those larger pieces were you able to mechanically fit together prior to comparing them to the taillight housing?
Sorry, can you?
From your analysis of those larger pieces and analyzing them together with other larger pieces, what, if any, opinions did you draw? What, if any, conclusions did you come to as far as your analysis of those pieces?
So for the larger pieces amongst the different items that fit together mechanically, I can see that those items were once a part of the same unit.
And so I guess what I'm asking, Ms. Valier, is with reference to, say, item 7-6 or 7-5, or the items in and of themselves, which of those items were you, if any, were you able to find mechanically?
We'll explain why, Lois.
Amongst sorry, are you asking me which specific items made up piece 1?
Correct.
Okay. I can. Okay. Okay, so piece 1 contained pieces from items 7-5, 7-8, 7-10, 7-11, 7-13, 7-15, and 7-16.
And then, so based on their mechanical fit, what, if any, conclusion did you draw in reference to those several items?
That those specific pieces from all of those items were at one time together as part of a larger unit.
And then what, if any, comparison or analysis did you do of items between item 7-15 and item 7-16?
So pieces from item 7-15 and 7-16 were part of piece 1. I could look through my notes and see if they're a part of any of the other pieces that I fit together.
With the court's permission.
Okay.
Okay, so piece 2 consisted of pieces from item 7-15 and 7-16.
And then with reference to item 7-6 and 7-11, what, if any, what, if anything, did you observe between the pieces of those?
Okay. So piece 3 consisted of pieces from item 7-6 and 7-11.
And similar to what you had described before with 7-15 and 16, as far as them mechanically fitting together, and now I'm talking about 7-6 and 7-11. What, if any, conclusions did you draw in regard to that?
That those pieces from item 7-6 and item 7-11 were at one time together as a larger unit.
And then as far as item 7-8, 7-9, and part of 7-16, what, if anything, were you able to do with reference to those?
So piece number 4 consisted of pieces from item 7-8, 7-9, and 7-16.
And as far as mechanically fitting those pieces together, again, what, if any, conclusions did you come to in reference to those items 7-8, 7-9, and 7-16?
That those pieces from item 7-8, 7-9, and 7-16 were at one time together as a larger unit.
Now, lastly, with reference to this, in reference to item 7-12 and 7-14, what, if any, analysis did you do with reference to pieces from those items?
Sorry, which item?
7-12 and 7-14.
I have item 7-11 and 7-12 that fit together for piece number 5.
And Your Honor, with what's now been marked as exhibits 384 through 402, if I could ask to publish some of those to the jury.
Yes.
Ms. Gilman, if I could have photograph 2069. And Ms. Blair, do you recognize what's up on the screen as now exhibit 384?
I do.
And what are we looking at here?
Within item 7-16, those are pieces that were mechanically fit together.
And Ms. Gilman, if I could have 2096. And Ms. Blair, do you recognize what's now been marked as exhibit 386?
I do.
And what do you recognize that to be?
So that is what I called piece 1. So the piece that is made up of apparent plastic pieces from many of the different items.
And Ms. Gilman, if I could ask you to just zoom in a little onto the middle of that photograph.
What exhibit number is this, Mr. Lally?
Yes, Your Honor, this is 386. And from sort of this zoomed in version of 386, Ms. Blair, are you able to now see some of the stickers or the evidence stickers that you would put labeling each of these pieces?
Yes.
If you could just use the laser pointer, draw the jury's attention where those would be in this photograph.
So these labels right here are the labels that I put on each piece individually when I initially examine it. So all of the little white labels.
And Ms. Gilman, if I could have 2097. Ms. Blair, do you recognize what's up on the screen, what has now been marked as exhibit 387?
I do.
What do you recognize that to be?
That's still piece 1. It's just from a different angle.
Ms. Gilman, if I could have 2101. And Ms. Blair, you recognize what's up on the screen now that has been marked as exhibit 390?
I do.
What are we looking at here?
That's still piece 1 from another photo taken from another angle.
And Ms. Gilman, if I could have 2103. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as exhibit 392?
I do.
What are we looking at as exhibit 392?
That is another angle of piece 1.
Ms. Gilman, if I could have photograph 2107. Ms. Blair, do you recognize what's up on the screen, which has now been marked as exhibit 395?
I do.
And what are we looking at in exhibit 395?
May I look at my notes?
Sure.
Okay. So, okay. So that is piece 2.
And Ms. Gilman, if I could add 2110. Ms. Gilman, if you could just zoom in a little bit on the stickers on this photograph. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 398?
I do.
What do you recognize that?
That is piece 3.
And Ms. Gilman, if I could have photograph 2111. And Ms. Gilman, if you could zoom into the stickers. Thank you. Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 399?
I do.
And what do you recognize that to be?
That is piece 4.
And Ms. Gilman, if I could have photograph 2113. Again, if you could zoom in just a little. And Ms. Blair, do you recognize what's up on the screen now that's been marked as Exhibit 401?
I do.
And what do you recognize that?
That is piece 5.
Thank you. Your Honor, may I approach?
Yes.
So, Ms. Blair, earlier I'd put before you another 23 photographs. Do you recognize what's depicted in those 23 photographs?
I do.
What do you recognize that to be?
That's comparisons between item 3-1 and piece 1.
And item 3-1 again was the tail light. Is that correct?
Correct.
Your Honor, with the court's Commonwealth will seek to introduce and admit as the next exhibits.
Okay.
Exhibits 403 through 434, Your Honor. Thank you.
Thank you. Your Honor, with the court's permission, if I may publish some of these photographs for the jury.
Yes.
Ms. Gilman, if I could have photograph 2156. Blair, do you recognize what's now up on the screen that's been marked as Exhibit 403?
I do.
And what do you recognize that to be?
That's one of the photos comparing item 3-1 and piece 1.
Ms. Gilman, if I could have photograph 2125. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 411?
I do.
And what do you recognize that to be?
That's the contents of item 3-1.
And that's prior to you. At what stage of this analysis or comparison process is that?
So that's when I initially looked at item 3-1.
Thank you. Sorry, if I may have a moment.
Yes.
Now, science people, can you bring something up or check my math on this? Things break a certain way. Like that light, if you smash it, generally is going to break in a certain way in a certain pattern every time. The idea that every time it's completely different. I mean, I'm sure you could accomplish the same fracture patterns generally with the same results every time, as long as you did it the same way. So I don't know if her math adds up there. That seems a little weird to me. But check me on that, because I was doing a little research, and apparently that, gets you, like, I guess, like a little bit of chaos and string theory, but the idea that you can break something the same way every time. I know there's science people out there. Tell me, am I right or wrong?
Ms. Gilman, if I could have photograph 2150. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 431?
I do.
And what are we looking at in 431?
So on the left is item 3-1, piece A, and then on the right is piece 1.
And Ms. Gilman, if I could have 2151. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 432?
I do.
What are we looking at in 432?
That is piece 1 on top of item 3-1 in a mechanical fit.
Is that the mechanical fit that you were talking about earlier in your testimony?
Yes.
Thank you. Ms. Gilman, you can take that down. Thank you, ma'am. Ms. Valer, in reference to those items that you testified to earlier in item 3-1, the taillight housing, what, if any, conclusions regarding those items as far as a physical match? What, if any, conclusions did you come to?
That item 3-1 and the pieces that make up piece 1 were at one time together as a larger unit.
Thank you very much. I have no further questions.
May we approach Ron?
All right, so they're gonna have a sidebar. Let's see here. Yes, I agree. The temperature is gonna make these plastics brittle. I mean, they're gonna shatter like glass if they've been freezing all night. Yeah, I know you would need to test some OEM tail lights in the exact conditions. Would they shatter under compression or break as a molding? I think well, I don't even know. Somebody was here was saying they think it was from a downward trajectory. I don't know if you can even tell that unless you could find like a bowed in top piece. I mean, it looks like it just smashed. David, how are you doing, man? If you want a link, I could send you one. I don't know if you're having an office day like me today. Although some of you are thinking your office looks like your studio. It is. My office got demolished. I need to find a new one. I would have 3 questions. 1, did you receive the items to the crime scene? 2, did you fit these items together? 3, do they match the other to the tail light? Thank you. We passed the witness. I understand, David, but they're going to start showing all of these pieces, so they're being they could have cut this down by actually having the evidence bags and like, yep, is this one? Boom, 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 boom. But they have pictures of everything, which is a fucking mess. Oh, here we go. Here's Yannetti. Here's cross chat.
You have testified that when evidence comes into the crime lab, it's given crime lab evidence or item numbers, correct?
It's given a case number, and then each piece of evidence gets its own individual item number.
Okay, and if you can just keep your voice up because we want to make sure that the last jurors here can hear you. Consistent with that policy, the evidence that your lab received in this case was also given those item numbers, correct?
Correct.
So I'd like to ask you about one particular item number in this case, 7-18.18. Would you agree with me, and feel free to check your records, but would you agree with me that that was the item number given to, quote, debris from orange t-shirt and gray long sleeve shirt, end quote?
You can go ahead.
Okay.
And again, it's 718.18.
Debris from orange t-shirt 7-17 and gray long sleeve shirt 7-18-JO.
Terrific. Item 7-18.18 did not include the orange t-shirt itself, correct?
No.
Believe that you just testified that was given a different item number, which was 7-17?
I believe so.
And 7-18-18 also did not include the gray long sleeve shirt either, correct?
I didn't look at 7-17 or 7-18. I only received the debris from.
Okay, well, yeah, that's my point. So with regard to the orange t-shirt and the gray long sleeve shirt, those were given separate item numbers, and you examined what was the debris allegedly from those shirts, right? 7-18.18, correct?
Correct.
And that debris consisted of different categories, did it not?
There were different pieces of, there were different things inside of it, yes.
Yes, different categories of things, correct?
I'm sure.
All right, so one category was dirt and debris, correct?
Yes.
You did not test the dirt and debris, correct?
Correct.
Another category was, or were, I should say, several apparent hairs.
Yes.
And you did not test those hairs, correct?
Correct.
And another category, I believe you've already testified to, consisted of several pieces of red apparent plastic and one piece of clear apparent plastic that measured 1/8 of an inch by 1/16 of an inch. Is that accurate?
Okay, so there were several pieces of red apparent plastic and then one piece of clear apparent plastic measuring approximately 1/8 of an inch by 1/16 of an inch. Yes.
Okay. And I apologize for continually reminding you, but I'm just mindful that everybody needs to hear you. So to the best you can, if you can just keep your voice up, I'll try to do the same. So when those several pieces of apparent red plastic and one piece of apparent clear plastic came into your possession, those pieces were obviously not embedded in either shirt when you examined them, correct?
I don't know. I didn't examine the shirt.
Well, so to my question, the pieces that you saw were not embedded in a shirt when you examined them, correct?
Correct.
And again, that's because you never took possession of any shirt in this case, correct?
Correct.
The pieces were loose and they were not embedded in anything, correct?
The pieces were, well, I examined the debris from the shirt. I don't know what the person who packaged it did to collect that.
Okay. And so it goes without saying that you never saw those pieces on either the orange shirt or the gray long sleeve shirt, correct?
I did not.
And you obviously had no control over how the evidence was handled before it came into your possession, correct?
We have a chain of custody in the laboratory, but I did not follow the evidence as it went through the chain.
Okay, and we'll talk about the chain of custody in a minute. Before this evidence came into your possession, you did not witness who seized it, correct?
Correct.
You did not witness who handled it, correct?
Correct.
Before it came into your possession, you don't know who had access to that evidence, correct?
So all of our evidence is stored in locked facilities.
Right, but I guess let me modify that question. Before it came to your lab, you don't know who had access to that evidence, correct?
Correct.
You also don't know, before it came to your lab, whether the shirts in question were at all times kept separate from the red or clear plastic pieces of, well, I said pieces of plastic that were in the possession of certain members of the state police, correct?
Correct.
The chain of custody at the crime lab started with noting the state trooper who actually delivered the evidence to your lab, along with the date, correct?
Sorry, could you repeat the question?
Sure. The chain of custody at the crime lab starts with noting which state trooper delivered the evidence to your lab and the date that he or she delivered it, correct?
Or a crime scene responder, but the person who drops off the evidence to the laboratory, yes.
Okay. And in this case, which particular state trooper delivered the orange t-shirt and gray long sleeve shirt to your crime lab?
I don't know.
Okay. Well, which state trooper delivered the pieces of red and clear plastic pieces, I should say, that you just testified about?
The item 7-5 to 7-19?
Right. The several pieces of red apparent plastic and one piece of clear apparent plastic measuring 1/8 of an inch by 1/16 of an inch. That's what I'm referring to.
Wait, sorry, could you repeat the question?
Yes. You understand what I'm talking about, right? In terms of the several pieces of red apparent plastic and then the one piece of clear plastic that you have the measurements for?
You're talking about the apparent plastic that I noted in the debris of 7-18.18?
Correct. Which state trooper was it that delivered that?
Do you know?
Sorry, that's that's an odd question.
I'm sorry.
I don't know if you want her to repeat it, Ms. Giannetti. Go ahead. You have to repeat that, please.
So evidence is submitted
No,
to
what you just said that he missed.
Oh, I said that's kind of an odd question.
Oh, not for me.
So
Do you have a record of that?
a record of what?
A record of which state trooper delivered that debris to the lab?
So it wouldn't be delivered as like debris. It would be delivered as the individual piece of clothing, which then got assigned item 7-18, I believe. And then as someone analyzes it, each offshoot of that piece of evidence gets a 7-18 point something. So the debris collected from that shirt is 7-18.18.
Okay, all right. Listen, when those several, actually, let me strike that. Get to where I was.
Take your time, Mr. Yannetti.
Okay, so I want to confirm with you that when you were assigned to this case, you were aware that the date of the incident was January 29th of 2022, correct?
Yes.
All right. And it's your testimony that you don't know which state trooper delivered the shirts to the lab, correct?
I could look at my notes because I have a printed chain of custody.
Sure, if you would check your notes for that, please.
Okay. So. Okay. Okay, so submission 7, which is everything that's item 7- in this case, was submitted by Trooper Michael Proctor, I believe.
Oh, that was the answer to my
Okay.
last question. Thank you. How long after January 29th of 2022, according to your records, did Michael Proctor deliver that clothing to the crime lab?
It was delivered on March 14th, 2022.
Okay, so about 6 weeks or so after January 29th, is that accurate?
Sure.
Given that your lab received this evidence on March 14th of 2022, you can't testify to the chain of custody of the clothing or the pieces of plastic prior to March 14th of 2022, correct?
Correct.
And except for the tail light housing that was seized by Maureen Hartnett, except for that, your chain of custody at the lab for the 2 shirts plus the pieces of plastic in 7-18.18, that began on March 14th of 2022, correct?
Correct.
So between January 29th of 2022 and March 14th of 2022, you do not know what Michael Proctor did or didn't do with the orange t-shirt and gray long sleeve shirt, correct?
Objection.
I'll allow it.
I don't know.
Okay. Now, I'd like to discuss with you, if I might, Michael Proctor's submissions of the pieces of plastic that you've testified about. Your lab received from Michael Proctor several different evidence bags containing red, clear, and black pieces of plastic, correct?
Correct.
Some of those evidence bags contain relatively small pieces of plastic in them, correct?
Correct.
And some of those evidence bags contained larger pieces, right?
Correct.
The evidence bags that you received listed the dates of recovery of those pieces of plastic, did they not?
I believe so.
And the evidence bags that you received also listed the officer who recovered the plastic pieces, right?
I believe so.
And again, when you receive those evidence bags, whatever numbers are on them, your lab assigns them your item number, correct?
Correct.
So I'd like to ask you first about item number 7-8. Do you have a record of that?
Yes.
Now, that evidence bag, item number 7-8, contained multiple pieces of red, black, and clear pieces of plastic, correct?
Okay.
Sure.
Okay, thanks. Okay. Contained 14 pieces of red, black, colorless, and silver-colored apparent plastic, yes.
Okay. And the date of collection was February 3rd of 2022?
Go right ahead.
Okay. Item 7-8,
Yes.
February 3rd, 2022.
Okay, and that was, if you have that in front of you, that was also collected by a trooper named DeChico, correct?
Oh, yes, correct.
I may approach, Your Honor?
Yes.
So I show you a photograph. Can you identify what that is?
Yes.
What is that?
That is the handwritten label on item 7-8.
That would have been the evidence bag that your lab received and gave item number 7-8 to it, correct?
Correct.
And that appears to be an exact, photograph.
I don't think
of the
there's an
actual bag.
objection to it, so we
Yeah,
can
that's
just put
true.
it in.
Okay. May I offer that, Your Honor?
Sure.
Exhibit 435.
May I display that for the jury, Your Honor?
Okay.
And this is that is what I just showed you on the screen, correct?
Correct.
That's where it's indicated what the date of collection was and which trooper collected it, correct?
Correct.
All right, we can turn the lights on for a minute. And you would agree with me that that date, February 3rd of 2022, was only 5 days after the January 29th blizzard, correct?
I don't recall the dates of blizzards, but
Oh, okay. Well,
sorry.
let's put it the date of the incident. You would have
Okay.
previously testified that was January 29th, correct?
correct.
All right. And February 3rd was 5 days after that, right?
Yes.
All right. I'd like to show Exhibit 279, please, which is 3 days.
Okay.
Now, Exhibit 279, which is displayed on the screen now, this is one of the photos taken of some of the contents of item 7-8, is it not?
That's the entirety of the contents of item 7-8.
Okay. You would agree with me that those were the pieces that were inside that evidence bag, labeled February 3rd as the date of recovery, 5 days after January 29th, correct?
Correct.
Okay. And you see that there are some relatively small pieces that were allegedly found on February 3rd, correct?
Correct.
All right. Now, Your Honor, I'm continually showing photographs. We can turn the lights on and off, whatever the court's preference
So
is.
you can just tell the court officer when you want the lights turned.
Okay, all right. So they get turned on for like a question or two, and then I turn them back off. But
However you want to do it.
that's fine. All right, so I'd like to contrast some of those pieces with some of the pieces that were found days and weeks later by Michael Proctor. And I'd like to start first with item 7-13. This is, I'd like to display Exhibit 343, which, Mr. Bates, is item 5. Okay, all right. You were previously asked about Exhibit 343, which is now displayed on the screen.
Yes.
And that is the first evidence bag submitted by Trooper Proctor, is it not?
So in mine, sorry.
And you know, let me rephrase that. He submitted evidence bags all at one time, correct?
Yes.
All on 3/14. So when I said the first evidence bag, I meant the earliest date of collection. I should have asked it that way. February 8th of 2022.
Sure. I don't know all of the dates that each item was collected on.
Okay. But in any case, those, according to the evidence bag that you received, the contents of that bag, which were, again, pieces of plastic, correct?
Pieces of apparent plastic.
Pieces of apparent plastic. Those were found 5 days after the pieces that you previously testified were found by the Chico, right, on February 3rd?
Correct.
All right. And February 8th was now 10 days after January 29th, correct?
Correct.
Can I have displayed Exhibit 346, which is 5A? Okay, looking at Exhibit 346, you will agree with me that this particular piece found on February 8th by Trooper Proctor was quite a bit larger than many of the plastic pieces that had been found by Trooper DeChico 5 days earlier on February 3rd, correct?
I mean, there were a variety of sizes of pieces on the other one, but that is a, what is that, approximately 4-ish inches?
Right, but my point is, Exhibit 346, what's displayed, that plastic piece, is quite a bit bigger than the small pieces that were contained in DeChico's collection, correct?
Then some of those pieces, yes.
Okay. Now I'd like to move on to item 7-15, and if I could show Exhibit 352, please, which is item 8, Mr. Bates. Okay, item 7-15, the evidence bag that supports that lists the law enforcement officer who recovered the plastic pieces as Trooper Michael Proctor, correct?
Correct.
And the date of recovery of those pieces was February 11th of 2022, correct?
Correct.
And again, hearkening back to DeChico's evidence bag from February 3rd, this is now 8 days later that these pieces are found, correct?
Correct.
And it's now almost 2 weeks that these pieces are found after January 29th, right? 13 days?
Correct.
All right, if I could show Exhibit 355, which is 8A, Mr. Bates. You would agree with me that this particular piece found by Trooper Proctor on February 11th is also quite a bit larger than those small pieces that were contained in Trooper DeChico's evidence collection, correct, on February 3rd?
Correct.
All right. I'd like to move on to item 7-16, which is number 9, Mr. Bates.
What exhibit number is this, Mr. Chairman?
And this has not yet been introduced, so I'm about to introduce it. And in fact, why don't I do that first?
Okay.
If I can approach the witness.
Sure. And there's no objection to this, Mr. Lally?
No, Your Honor.
Okay.
I'll just have the witness identify it and then offer it. Do you recognize what that photo depicts that I've handed to you?
I do.
What is it?
The handwritten label from item 7-16.
Okay. I would offer that, Your Honor.
Okay.
Exhibit 436.
Thank you.
Okay, so if I can display Exhibit 436, which is number 9.
Sure.
And again, you just identified that as the bag supporting item 7-16, correct?
Correct.
That also lists the law enforcement officer who recovered the plastic pieces as Trooper Michael Proctor, correct?
Correct.
And the date of recovery of those plastic pieces was February 18th of 2022, correct?
Correct.
Trooper Proctor is now finding these pieces over 2 weeks after the smaller pieces were found by Trooper DeChico, correct?
Objection.
Sustained.
February 18th is nearly 3 weeks after January 29th, is it not?
Correct.
All right. If I could show Exhibit 380, which is 9A, Mr. Bates.
That's a very big problem. Why is it that late afterwards? That is not a good thing, chat. Why is it that late? Where did this come from? What the fuck is Trooper Proctor doing? Yeah. It's odd. This is not good. So let's keep going though.
You would agree with me that this particular piece found by Trooper Proctor on February 18th is also quite a bit larger than those smaller
It's a
plastic
monstrous
pieces
shard.
found by Trooper DeChico on February 3rd, correct?
Correct.
This one appears to be about 11 centimeters long, approximately.
Sure.
All right. If I could show Exhibit 376, which is 9B, Mr. Bates. Okay. And you would agree with me that this particular piece found by Trooper Proctor on February 18th is also quite a bit larger than those smaller plastic pieces found by Trooper DeChico back on February 3rd, correct?
Correct.
In fact, that appears to be larger than the piece that you just identified in Exhibit 380, correct?
The one that was just on the screen?
Right.
Yes.
This one appears to be maybe about 18 centimeters long. Does that seem accurate?
I mean, it's longer than the ruler.
Okay, yeah. Finally, if we could show Exhibit 378, which is 9C, Mr. Bates. You would agree with me that this particular piece found by Trooper Proctor on February 18th is even larger than the last one that we just saw, correct?
In length, yes.
Okay. This appears to be about 19 centimeters long.
I mean, longer than the ruler that's up there.
Okay.
But I have the actual measurement in my notes.
Sure. Well, and the precise measurement's not important. I'm just getting at the relative comparison. This one's certainly quite a bit larger than the smaller pieces found by Trooper DeChico back on February 3rd, correct?
Correct.
This larger piece of red plastic, like the previous two that you just identified, were all found on February 18th, about 3 weeks after January 29th, correct, according to your records?
Correct.
And regarding these last three evidence bags, labeled item number 713, 715, and 716 in February of 2022, from February 8th to the 18th, those were all plastic pieces collected by Michael Proctor, correct?
Correct.
And in addition to collecting those pieces,
You turn the lights on, Ms. Giannetti?
yes, I'm sorry,
Okay. And we can take that down, please?
yes. In addition to collecting those plastic pieces on all those different days, Michael Proctor was also the person to hand deliver those last three evidence bags, all on March 14th of 2022, correct?
Correct.
And you do not know what Michael Proctor did or didn't do with those evidence bags of pieces of taillight prior to March 14th of 2022 when your lab received them, correct?
Objection.
I'm going to sustain it. We've already asked that.
Now, the taillight of that Lexus sits in the housing of the Lexus, the taillight housing, such that part of the taillight faces the rear of the car and part of the taillight loops around and faces the passenger's side of the car, correct?
Sure.
Right, because it's on the corner.
Sure, yeah.
You'd agree with me that once you received the final pieces of taillight from Michael Proctor on March 14th, and once your lab received that, you were then able to piece together a majority of the taillight, correct?
So I wasn't assigned this case until later, once everything had already been submitted to the laboratory.
Right. So it was true that after Michael Proctor submitted these pieces of taillight on March 14th, it was after that that you were able to do the reconstruction that you testified about, correct?
Correct.
If I could have exhibit 432 displayed, which is image 2151, Mr. Bates. That is the reconstruction, the final reconstruction that you were able to do, correct? You would agree with me that there's one section of that taillight that was missing completely, correct?
Correct.
That's pretty damn close. Wow.
Correct.
And that missing section is noticeably visible in your reconstruction, is it not?
Yes,
And do you still have that laser pointer there?
I do.
Would you please point to the section of taillight that's missing? Okay. Appears to be a hole on the upper left side of that exhibit.
Is that a question?
Yes, it actually was. I
Okay.
should have said right or correct, but I didn't.
Yes.
Okay. And you would agree with me, and if we could zoom back out, Mr. Bates, you would agree with me that the portion of taillight that you did not have was strictly on the rear side of the taillight, if I can call it that.
I am not sure what orientation that goes on to a car.
Okay. But in any case, to this day, you do not know where the pieces that make up that hole are or what happened to them, correct?
I do not.
I may have a moment.
Okay,
No further questions. Thank you.
all right, Mr. Lally.
Thank you, Your Honor. Now, Mixed Valeric, in reference to items 7-17 and 18, the orange T-shirt and the gray sweatshirt, fair to say you never actually physically saw those items, correct?
The clothing? No, I did not.
Now, the debris that was provided, are you familiar with how that process or who got those debris items from those clothing items?
I can look at my notes and tell you who submitted it or who transferred it to our unit.
If you could.
Your witness is ready, Mr. Lally.
I'm sorry. And from your review, who was that person?
Maureen Hartnett.
Now, as far as the 1/8 of an inch by 1/16 of an inch red and clear apparent plastic pieces that you observed within that debris, that was mixed in with other debris as far as dirt, fibers, things of that nature. Is that correct?
Yes.
And the 1/8 of an inch by 1/16 of an inch pieces that were contained within that debris, was that something that you observed visually or microscopically or both?
So visually, I take overall pictures of the debris, and then I'll look through the stereo zoom to see if there's any anything that looks different, and then I'll take a picture of that. So that is what I did. I looked through the stereo zoom.
Now, as far as the collection of evidence, fair to say you don't know who was a trooper, who was there when they were collected, how many troopers were there when it was collected, when it was collected, anything to do with that, fair to say?
Yes.
And as far as the pieces that you testified to, as far as fitting them mechanically together, all of those pieces then fit mechanically onto the taillight housing taken from the defendant's vehicle, correct?
Correct.
Nothing further.
Nothing on that.
All right, Mix Valaire, you are all set. Thank you
Thank you.
very much. All right. Joyce, do you want to take your morning break now? Or wait? Yeah, people are saying yes, so we'll take the morning break now.
All rise for the court, please.
So I'll see counsel for a second at sidebar, please.
So it's still in session.
Hey, chat, we're on break. What are you guys thinking so far? Call your twin and see if she's okay. We got some more super chats to get through here quick. Unhung Hero says her pronouns are on. Unhung Hero then says, Sean, they them stole your hairstyle and color. I know, I'm very offended. Very offended. Kevin Dorr for $5. Kevin, good to see you. Is saying the DA knows they're not going to win. Stalin dragged the trial out, suck more money out of the Reed family. This is just vindictive and PR prosecution. Oh no, we're not to that point yet. I think like I still think they think they can convict her. I still think they think they could convict her. 10KV says if J-Rock was here, he would have tried to convert Mix Valaire back to Team Her. Reformed Comic says the cut with the nut cup on her face must be deaf, considering the person testifying is 5 feet away. And why is she having to do evidence? Can't she keep up normally? So it's not that she's sitting next to the person, but those earphones listen to everybody. Those earphones are not just for the witness, but for like the far podiums, the defense tables, everywhere. She has to be able to hear all of that. And typically the court reporter is in charge of organizing and keeping track of the exhibits. So if there's a trial that's ongoing in many courtrooms, the court reporter, once exhibits have been offered, they kind of keep them in a pile on their desk. And at the end of the day, if there's more stuff, they hold them for the night and they have a special place they can put stuff that gets locked up. But yeah, I've seen trials involving guns and things like that. The court reporter's got she has a little cart and she put the guns and all the other evidence in their cart and pushed it in and locked it up, had it locked up in a closet where her and one of the court deputies only had access to it, and brought it back out in the morning. And before the jury came in, she wheeled her cart back out and laid out all the evidence in piles that was ready for us to use. So Neo Dark Matter saying, oh my God, has he been shining his bald spot? Yes, I don't know about Lally. Also, let's see, is our boy in there? Nope, no, I don't see no Aiden Carney. I don't see no turtled boy. No turtled boys allowed. Apparently. And there's Karen Reed. Forever alone. All by myself. Karen doesn't want to be all by herself. All right. Obscure is saying, thank you for doing this for us, Sean. Well, you're welcome. Of course. I'm enjoying this. It's actually getting better now because we're getting to the real stuff, which is hard to do. JSD says, Sean has solid C cup, witness A cup. Yes. I know. Karen don't have the boobs. Alone again naturally. Lowest thing, Bev made a remark, all the evidence, making the reporter's job twice hard. On top of that,
You are
yes.
unmuted.
On top of that, yes. Well, let's hear what they're talking about. Listen, you can hear Lally just...
All right.
You are muted.
All right, chattel. We are on break again. No breaks. All gas, no brakes, chat. We ain't stopping. God, it's humid as hell outside. I am keeping the window closed. It's like hotter than ball sack out there. Ugh. And yes, and for them it was like, and scene. Stop muting me. Well, you've been muted. You have to suffer. Because you must take it. Just take it. No talking back. Just take it. Does Karen only give birthday blowjobs? I wonder if she does. Real Hydra says, what is this legal mindsets chat nutting on people? Yes. All right. So we're on a break for a couple of minutes. We're not the lunch break. But yes, all hail the fan. We have returned. We have returned. Yes. Ew. 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 But yes, we'll redraw the fan. We got time for the fan. No, we were saying that Karen only does that. That's all Karen does. It's like Karen's cold. Go powder my nose. Yeah, I could do that. Why is this? Oh, I forgot because I doubt. Oh, because it doesn't do the 1080p. I don't have the 1080p access anymore. But still feels like it's like not zoomed in right. Oh well, whatever. Oh, fan name is Nick Rotella. Well, just like Nikki spins in circles all the time. Makes no progress. Marlena says, these trials trees remind me of someone. What's that YouTuber's name again? I know. Makes you wonder. Makes you think. Makes you think. Ron A says, howdy, Sean. Howdy, chat. Well, hello. Well, guys, if you have questions, please send them in. We've got a little bit of time here to kill. So, when it comes to lunch, guys, I'm probably going to take like a full break, and we'll start back up in the afternoon just because I do have some things I need to take care of and some phone calls to make where I will be gone after a while. What does my mug say? My mug. My mug says, oh, hold on here. I'm going to bring this up. I got to get the other thing ready. Okay, so my mug itself says, on one side, it's got me and my face and my name. Then on the other side, it says, just because you did it doesn't mean you're guilty. And if you want to see where you can find them, you can go to Teespring, and it should be in the link below for merch. And you can find that along with other things that are down there, including the Canton Police Evidence Collection Kit. You can get it like that. You can get it as a steel cup, a camping cup. There's ways you can get it. You can also get from the George Kelly trial, Meemaw Shark, the angriest grandma around, and other things, including the defendant being an experienced bondage master and an homage to our the best bondage master in all of Florida. You guys get some great stuff that's Clyde approved because he's such a good boy. He's such a good boy. You can also get a being known as the fat guy Nick Ricada yelled at, and then yes, that you can also find if you keep reload some more, you can find all the good stuff. Nobody talks, everybody walks. Oh, hold on, I need to make that bigger. Then Sarah Boone's possible defenses. And then you can also get this wonderful one. You can get it with the back. So yes, these two can be yours. And I will warn you guys, if you guys are curious, the Daryl Brooks collection, and that is really pretty much this. It's a couple other things like it on the website. I'm just telling everybody now. Just telling everyone now, we are going to be discontinuing the Daryl Brooks stuff. So if you guys would like something from the Brooks Coffee Company out of Waukesha, Wisconsin, serving relevant ground since 2022, they are about to go away. We are about to discontinue those. So, yes, the best anime blogger. Yes, I may have to work on that one. Make one where you wear a crown because you're a king. Maybe someday, chat. Okay, says I need Clyde on my boobs ASAP. Well, if you ordered, it should be coming out. I think you said you ordered, Katie. Hopefully it's there soon. Send that Nobody Talks, Everybody Walks merch to Ricada, please. God, that would be funny. Robert says no train themed merch. No. When am I going to start selling custom 80% lowers? My face on them. That'd be great. It's safe. It could be Fifth Amendment. Fire could be Second Amendment. Yes. You know what? Saying wholesale fertilizer consumer. I'll work on that. Sean should not cry so much about being a blogger. We got to call him a newsletter writer. Oof. Or a chain email generator. That would be even worse. You remember getting those back in the day? Like, make sure you send this out or bad things will happen. Like, ooh. Learn to blog. Yeah. Baldo lowers, that'd be funny. Although with 3D printing, you're making them out of non-ferrous metals anyway. Well, aluminum's not ferrous, but you get the point. Send this email to 100 people, you will die, or send this people email where all your dreams will come true. Everything will happen. Yes. Even Ralph came in. Katie, I'll fill you up from all angles. I'm the best lover in all Merida, Mexico. Salute to Katie's grandpa. Oh. All right, guys. So yeah, I'll need to work on messing with some more merch coming up. Send out emails. Just Sonichu medallion is the Sonichu medallion is getting sent to me. I told you, and they're not accepting it. Not accepting it, Chad. I'm not accepting it. Katie says, "Sorry, I've been MIA the last week." Well, you have nothing to be sorry about. We're fucking around here on the internet. There is no obligation to us. The only obligation is my obligation to you guys. That I agree to cover this stuff, and I promise to do it, and I need to uphold it. That's the only obligation that's here. A mug with a red Solo cup on it. I tried that. It didn't come out very well. That was really hard to do. It didn't come out very good. But yes, you have to fly. So I have to fly to Maine tomorrow. Oof. Maine is very rural. So, like, if you guys haven't been to Maine, like when you're at the cities, it's great. But like, you could be an hour away and you're in like it's Alaska level wilderness. You'll drive to Boston and go to court. That would be hilarious. Luckily, you're not flying on a Boeing. It's Sonichu. It's not Shanichu. I'm not going to get a Shanichu medallion. I mean, we can start cursing people. I treat my women like the queens they are. The best cure for grief is making love. Tom says, I'm in York, Maine for the summer. Oh, good. Tom's good to see you, by the way, guys. Tom Gillis, Golf Instruction. Guys, he does have a YouTube channel down below. Or, well, actually not down below, but if you click around on Tom's thing, you can find it. A lot of good tips out there. Some nice little shorts will help you. Shave off. You know what? Here. Tom didn't tell me this, but I know it's true. I know it's true. If you follow everything Tom does, you're going to have like a Kim Jong-il golf round. You're going to have 13 hole-in-ones on your round of golf. Guaranteed. Guaranteed. Guaranteed 13 holes in one, chat. You'll be buying drinks for everybody at the bar the whole summer. Yes, under 18 under every round. Exactly. Exactly. Chat is thirsty today. Yeah, they are. They're thirstier than a man in the desert. Duncan, Idaho, good to see you today, saying, I think these trials are boring and lame. When are you going to invite Dick Masterson onto your stream? Fucking never. Oh. And then Stephen Cooper for $2 says Sean at you is less of a threat than Sean eating you. Yes. It's not like you sent a super chat. Everything's been fucking weird today. I tried to send out a DM to somebody over on Twitter and it didn't fucking work. So shit's all weird today. You know, what if you've been through the desert on a horse with no name? I mean, would it really feel good to be out of the rain? Because that's you immediately go from being out in the rain to being in the desert. I'm like, I think you'd want to be in the rain a lot quicker again. But you know, some people might not want you to be. If I had my Clyde shirt, I would take it sightseeing on the top of mountains and shit. Oh my God, Clyde would love that. Check your DM for Florida Man RJ. Oh, I will. I'll check. See if I got an email. Oh. Oh my God, those are spiffy. Very nice looking. Thank you. Unhunker is saying YouTube is fucked up. It talks like a fag and its shit's all retarded. Yes. Well, I saw you guys did the coins, but those shirts look nice. I just said maybe I'll send you one of these boat sales. I mean, sorry, not boat sales. I mean, it's probably made out of the same. They probably made them on the same machine they were making boat sales out of when they made my shirts. So the ocean is a desert with its life under. Duncan says, "Why come no tattoo?" I am not a filthy inky. I am not an inky. I will not be getting a tattoo, good sir. I am not an inky. I'm sorry. I am a pure skin. I'm a blank skin. You're going to go stalk Tucker Carlson. There you go. There you go. I was going to send you a shirt, but I don't know your size. There's a lot of X's in there, so yeah. Did you how much a puss to get a tattoo? Call me a pussy all you want, but I'll be walking around with unblemished skin going, "Hey, what's up, guys?" You know, I don't understand what is with you guys being tattoos. I think there's more people with a tattoo these days than without. Yes. Yes. But a perfect shirt for me, it's a Hemeyer construction shirt. Well, here's the deal. If it doesn't fit, I can cut it out and like safety pin it to my other shirts. Pure skin, pure blood. What are we alluding to? I don't know. What are we alluding to? Your stash isn't a tattoo? No. And I know some like women out there, sometimes they'll get like their eyebrows partially tattooed in and shit. Nope. None of that. None of that. Whoosh. The sound of Duncan Idaho's Idiocracy reference flying past my head. I guess. God, it's been a long time. It's been like 20 years since I've seen Idiocracy. Thomas says, I've seen fat people. Your skin is blemished. Fair enough. Fair enough. It's called microblading. Is that where you take the hair and you're like, you take the like the dental floss and like you use it like a hair trimmer? I should get a barge trap stamp. That'd be funny. There's not enough ink for you and myself. That's the other issue too, guys. There'll be you'll have to do that. Like I'll take up all the tattoo ink. Those have to keep trucking it in to make a tattoo. They're like, where's it going? It's just getting absorbed. They'll run on tattoo needles. They just get all gooed up. Nick went to a tattoo convention for 3 days in the Twin Cities with his wife. I don't think it was for the tattoos. Yes, I why would you think that? Why would you think that, man?
You are unmuted.
You are unmuted. Why don't you talk to me about what's unmuted here, boss? Bossa Nova. Bossa Nova.
Thank you. May proceed to
Make a
court.
tattoo on the ass. This is come on in.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, the Commonwealth called Ms. Christina Hanley to the stand.
I saw that. We'll talk about that tomorrow night. Christina Henley, like Don's daughter. Do you know about the Boys of Summer?
Step right up there. Just watch your step for me.
You solemnly swear the evidence given to the court and jury the case down here to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can take the stand.
It's on the lowest setting.
I really need you to keep your voice up.
Okay.
All right. Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Could you please state your name and spell your last name for the jury?
Sure. It's Christina Hanley. Hanley is spelled Hanley.
And what do you do for work, ma'am?
I am a forensic scientist at the Massachusetts State Police Crime Laboratory.
And how long have you been at the Massachusetts State Police Crime Laboratory?
I have been there for approximately 16 years.
Now, ma'am, if I could ask you just a little bit about your educational background, starting with where did you go and what, if any, degree did you receive regard to your undergraduate?
Sure. I have a Bachelor of Science in Chemistry with a concentration in Forensics from Merrimack College.
And then after receiving those degrees from Merrimack, where did you go from there?
I began working at the Massachusetts State Police Crime Lab in 2008.
And from your work there in 2008, what did you do next?
So I began as a chemist 1 in the drug identification unit. Once I completed my training in there, I was promoted to a chemist 2. In 2009, I transferred into the trace unit as a chemist 2, which is the equivalent of a forensic scientist 2 currently. And in 2017, I was promoted to a forensic scientist 3 in the trace, arson, and explosives unit.
And if you could describe for the jury sort of the difference between a forensic scientist or a chemist 1, forensic scientist 2, forensic scientist 3 within your lab.
Sure. So forensic scientist 2 is considered like a bench analyst working on casework.
Hey, Ms. Hanley, I'm going to ask you to keep your voice up really loud, okay?
A forensic scientist 3 is a unit supervisor, and I also perform casework.
And how long is it you've been a forensic scientist 3 or a supervisor within the trace unit?
I have been a supervisor since 2017 for approximately 7 years.
Keep your voice up, please.
Now, Ms. Hanley, with reference to starting in general terms with the trace unit, if you could describe to the jury what is the trace unit and what type of analyses are done within that unit.
Sure. So the type of examination that we do in the trace, arson, and explosives unit, I examine and compare trace evidence such as paint, fibers, hair, glass, tape, miscellaneous items, and I also do physical match examinations as well as serial number restorations on firearms.
What type of training did you receive at the lab?
So I received in-house training as well as some external training. The in-house training consisted of required readings, exercises, observing other analysts working on casework in the lab,
I was required to successfully complete a written exam, a competency test, and a mock trial.
And if you could describe to the juries sort of what your duties and responsibilities are with your current position at the lab.
Sure. So I'm responsible for the daily operations in the unit, training other new analysts in the unit. I perform technical and administrative reviews of case files. I also work on casework, like I had mentioned, examining trace evidence such as paint, fibers, hairs, glass, tape, miscellaneous items, and physical match examinations and serial number restorations on firearms.
And was your lab, the Massachusetts State Police Crime Lab, is that accredited somehow?
Yes, it is.
And can you describe to the jury what that accreditation means, essentially?
Sure. So an accreditation, it's a formal recognition that the lab is in compliance with certain accreditation requirements.
She's so damn loud.
And is the lab that you work for, is that currently up to code or up to speed with regard to accreditation?
Yes.
Now, as far as you mentioned that you work as a supervisor and review other people's casework, is that correct?
Yes, that's correct.
Now, when it comes to this specific area, as far as trace analysis or comparison of items, who, if anyone, reviews your work?
I'm sorry, I didn't hear the end of that.
When it comes to this type of analysis, as far as comparison of items, who is it that reviews your work?
So depending on the type of case, currently we do have an external technical reviewer who is authorized to perform that technical review.
And is that external review, is that essentially as a result of there is no one else at the lab that can do what you do?
With some of the disciplines that I perform casework in, I am the only one. So when I do those types of cases, we utilize an external technical reviewer.
Now, are you familiar with the proficiency test?
Yes.
Can you explain to the jury what that is and how that plays into either your work at the lab or the accreditation process that the lab goes through?
Sure. So a proficiency test monitors an analyst's performance. It's a quality assurance process, and I am required to complete at least one external PT annually. Due to the multiple subdisciplines in trace, I do typically perform or complete more than one proficiency test per year.
And are the proficiency tests that you take, are they required by the accrediting body, ANAP?
Yes.
And have you passed each of those proficiency tests that you've undertaken over the years?
I have successfully completed my proficiency tests.
Now, turning your attention to this case, at some point, did you become involved in an analysis in reference to a lab case number 22-02184?
Yes.
And the name of the suspect on that is Karen Reed, is that correct?
Correct.
And if you could describe to the jury, again, just in a general sense, in any sort of case, when items come into your possession at the lab, how is that done, and sort of what do you do with those items when you first receive them?
Sure. So evidence is submitted to the lab through the evidence unit. It's assigned a unique lab number and barcode. The information for the case is input into our LIMS system, which stands for Laboratory Information Management System. And a chain of custody of the items is tracked in that LIMS system. When I take an item into my custody, I then document it with photos and notes. And then I proceed with sampling and microscopic examination and instrumental analysis.
Now, specifically when it comes to you mentioned you have a variety of sort of sub-disciplines or different types of testing or casework that you do, is that correct?
Yes.
Specifically as it applies to an analysis or an examination of items of glass, what, if any, experience or what types of cases would it be that you've looked at those types of items in the past?
So I have examined glass numerous times from a variety of different types of cases. For example, a hit and run or a B&E.
And as far as the types of, are there different types of glass that you've performed examinations on in the past as well?
Yes, I mean, there could be a variety of type of glass that I could come across for examination.
And with respect to examination of glass, what are some of the steps, or what is the process, or what, if any, instrumentality are you using to conduct your examination?
Sure. So when I examine an item that is glass, I document it with photos and notes, making general observations of appearance, color. I examine a portion microscopically and observe certain optical properties. And then I will also check to see if it fluoresces under UV light. And I also will sample it for analytical analysis using a GRIM, which stands for Glass Refractive Index Measurement.
If you could explain to the jury the GRIM device, how does that work?
Sure. So it measures the refractive index. Your refractive index. Your sample is placed into an oil of a known refractive index, and that then gets placed onto a hot stage of the microscope of the GRIM instrument. And it goes through a process of cooling and heating, and it looks for the match point temperature. And from that match point temperature, we're able to determine the refractive index of the glass sample.
Now, as far as that determination of the refractive index of a glass sample, how is that? Is that something that you're viewing, and how are you viewing it? What are you viewing on?
It's viewed through the software that the GRIM instrument uses.
And how does that appear as far as visually when you're looking at it?
So it essentially, you watch the cooling and heating process of this sample, like I had mentioned, and it determines the match point temperatures, and it takes an average, and it then calculates the refractive index for the sample.
Now, is there another device that you utilize in the lab called an FTIR?
Yes.
And can you explain, first of all, what that term stands for?
Sure. It stands for Fourier Transform Infrared Spectrometer. Sorry.
And what is that device, and how is that used in your examination?
So it's an analytical technique that's used for certain types of analysis. Basically, your sample is exposed to infrared light.
Well, John, law is done by lawyers. That's your legal thing.
And it reacts in a certain way. And what's produced is what we call a spectrum or a graph. And it's
knows
just a
all about
series of
spectrums.
peaks and valleys that are representative of the sample.
Now, turning your attention back to this case, 22-02184, starting with, were there some glass pieces that you examined in reference to that case?
Yes.
And what were the item numbers associated with the glass pieces that you examined in this case?
Sure. So the item numbers it was item 3-2, 3-3, 7-12, and 7-14.
And if you recall, as far as starting with item 3-2, was there any other sort of label associated with that beyond just item 3-2?
3-2 was a clear, apparent drinking glass.
And item 3-3?
Item 3-3, I believe, was the clear, apparent glass pieces recovered from the bumper of the vehicle.
And then item 7-12?
That was some clear, apparent glass that was recovered. It was recovered from the ground.
In the ground at 34 Fairview Road, is that correct?
Yes.
And lastly, item 7-14?
7-14 was also a clear, apparent piece of glass that was recovered from the road.
Now, with reference to item 3-2, the drinking glass, what, if any, observations did you make or did you note during the course of your examination of that?
Sure. So it appeared to have broken, irregular edges. And that was all I had noted at that point.
Did you take measurements as far as height and width?
I did.
Do you recall what those were?
I would need to refer to my notes for that.
Yes, you can use your notes.
Inches. Approximately 2 3/4 inches, and it measured approximately 2.5 inches in height.
In addition to the measurements that you took, what, if anything else, did you note as far as the interior and the exterior of that glass cup?
That there was some dirt debris material noted on the exterior and interior of that item.
Now, as far as item 3-3, the apparent glass on the rear bumper of the vehicle, what, if any, observations or measurements did you take in reference to that, or how many pieces were there?
Sure. So it consisted of 5 clear pieces of apparent glass with broken irregular edges. The largest piece measured approximately 7/8 of an inch by 5/16 of an inch. And the smallest piece measured approximately 3/16 of an inch by 1/8 of an inch.
Now, within those 5 pieces in items 3-3, were they then given each of those pieces respectively an additional label or marker?
Yes.
And was that an alphabetical one, essentially A through E?
Yes, I labeled them A through E.
Now, with regard to piece E from item 3-3, what, if anything, in addition, did you do with regard to that piece?
So what I labeled as piece E, I also used the Grimm instrument for analytical instrumentation.
Now, with regard to item 7-12, or the 14 pieces of glass and clear plastic. What, if anything, did you observe in your initial observations or initial examination of those pieces individually?
So in item 7-12, it consisted of 5 pieces of clear apparent plastic and 9 pieces of clear apparent glass, all with broken irregular edges.
Now, specific to the 9 pieces of broken glass, what, if any, examination did you do of them initially?
So the 9 pieces of apparent glass were examined microscopically.
Now, lastly, with regard to item 7-14, the pieces of glass recovered from 34 Fairview Road, what, if anything, did you note during your initial examination of them and observations did you make in regard to that?
Sure. So item 7-14 consisted of 1 clear piece of apparent glass with broken irregular edges.
Now, as far as the microscopic appearance, so when you're putting something under the microscope and you're looking at what kind of things are you looking for? What kind of characteristics are you looking for when you're examining something microscopically?
So I look at several things. So initially, I look at the color, whether there are like flat, smooth surfaces to the glass, whether it's flat or curvature. And then I may sample some more to examine under a polarized light microscope and check to see if there are certain optical properties under a polarized light microscope that are characteristic of glass.
And in addition to looking at each of these items individually, then what, if any, comparison did you do between those various items 3-2, 3-3, 7-12, and 7-14?
So between those items, I first examined them to see if there was a physical match between item 3-2 and item 7-12 and 7-14. And then I also did a comparison of 3-2 to item 3-3. And then I also compared item 3-3 to 7-14 for possible physical match. And in addition, I also sampled some pieces for use for examination on the Grimm instrument.
Let me ask you, just as far as classification goes, are you familiar with the terms as far as a class characteristic versus an individual characteristic?
Yes.
Can you explain what those terms mean and how they relate to each other within your specific forensic field?
Sure. So a class characteristic is when a material can be associated with a group of items that share characteristics. Like for example, fibers or tape. An individual characteristic is when a material can be associated with a single source, for example, a physical match.
Now, With reference to your analysis between items 3-2 and 7-12, what, if any, conclusions were you able to draw from your examination or comparison of those items?
Sure. So, right, there are several items that I'll just have to refer to my conclusion, if that's okay, on my report.
Yes, you can go ahead and look at your notes.
Yes. So item 3-2 was found to have a physical match with 6 of the pieces of clear apparent glass from 7-12. But there was no physical match with the 3 other pieces from 7-12.
Based on that physical match that you determined, what, if any, conclusions can you come to with regard to those items that were physical match?
Sure. So item 3-2 and the 6 pieces from 7-12 were at one time together as one unit. So then item 3-2 and all 9 pieces from item 7-12 were examined microscopically. However, there was no physical match found with the piece of clear glass from 7-14. Item 3-2 and all 9 pieces of clear apparent glass from 7-12 were examined microscopically, but no physical match was found with 2 of the pieces from the clear apparent glass from item 3-3.
Now, with reference to item 3-3 and item 7-14, what, if any, comparison examination were you able to do in reference to that?
Sure. So item 3- so 2 of the clear glass pieces from 3-3 were examined microscopically. No physical match was found with the piece of clear glass from item 7-14. One of the pieces that I had labeled as piece E from item 3-3 was found to be consistent in physical and instrumental properties with examined portions of the piece of clear glass from item 7-14. So accordingly, the examined portion of the piece of clear glass that I labeled as E from item 3-3 could have originated from the examined portion of the piece of clear glass from item 7-14 or from another source with the same characteristics.
Now, Ms. Hanley, you used a term in there as far as instrumental properties. Can you explain to the jury what that term means and how it relates to your examination in this case?
So the instrumental properties, that's referring to the Grimm analysis that I did. So in comparing the refractive index from 3-3 versus 7-14.
So the clear apparent glass from item 3-2 that was recovered from the scene was a physical match for 6 pieces from 7-12, which were additional glass pieces found from the scene, correct?
I'm sorry, say that again?
Sure. So the the drinking glass from item 3-2 was a physical match for 6 of the pieces from item 7-12, which was glass recovered from the scene, correct?
Correct.
And then the 2 of the pieces from item 3-3, or one of the pieces, excuse me, piece E from 3-3, which was from the bumper of the defendant's vehicle, was consistent with a piece of clear glass from 7-14, which was found on the ground, correct?
Correct.
Now, Ms. Hanley, in addition to that trace analysis that you performed with regard to the glass pieces, what, if any, other, excuse me, additional examination did you do with regard to items of debris?
Sure. So I also examined item 3-1 and 7-18.18.
Now, starting with item 7-18.18, what, if any, other description did you have as far as what that item was or where it came from?
So 7-18.18 is scrapings, trace material recovered from the victim's clothing.
And that would be both an orange T-shirt and a gray long sleeve shirt, is that correct?
Correct.
And those particular items, as far as the debris, that was provided to your unit within the lab by whom?
I believe it was Maureen that did the scraping of the clothing and had those scrapings transferred to our unit for further examination.
And that would be Maureen Hartnett, is that correct?
Yes.
And then as far as what, if any, items, the other item was 3-1, is that correct?
Correct.
That was the actual sort of taillight housing from the vehicle, is that correct?
Yes, that's correct.
And according to your notes, who, if anyone, provided that piece of evidence to your unit or to your lab for that comparison purpose?
I would have to double check who, I believe it was Maureen, but I'm not, I would have to double check in my.
Go ahead, you can go ahead.
Okay. Oh, okay. I'm sorry. It was Trooper Christopher Moore that had that item delivered to the lab.
Now, with reference to item 3-1, the passenger side taillight from the vehicle, what, if any, observations or things did you note in regard to your sort of initial examination of the taillight?
So I did notice that there were portions of the taillight, portions that were clear and red that had broken irregular edges. It appeared to be that there was damage to it.
Now, with reference to your examination just of the taillight now, what, if any, instruments did you utilize in the course of your examination of the taillight?
Sure. So during my examination, a polarized light microscope, a comparison microscope, as well as a FTIR with a microscope attachment and a microspectrophotometer, also known as a microspec.
Now, the Graham and the FTIR, I believe you've already discussed in your testimony. As far as the microspec is concerned, can you explain to the jury sort of what that instrument is and how it's used and how you used it in this examination specifically?
Sure. So a microspec is used to examine items that have color. So essentially, your sample is exposed to visible light, reacts in a certain way. Some of the light gets absorbed, some of it gets transmitted, and we get a spectrum, and it's representative of the dye or pigment in the sample.
Now, with reference to item 7-18.18, that being the debris from the victim's clothing, what, if any, observations or measurements did you take in reference to that particular item?
Sure. So I noted that there was some clear plastic material, as well as some red plastic material. And I would have to refer to my report for exact measurements of those items.
You can go ahead and do that.
Thank you, Your Honor.
So the piece of clear plastic measured approximately 1/8 of an inch by 1/16 of an inch. And the largest piece of one of the red plastic pieces measured approximately 1/16 of an inch by less than 1/16 of an inch. And the smallest piece from that measured approximately less than 1/16 of an inch by less than 1/16 of an inch.
As far as measurements go, as far as your examination, as far as the lab is concerned, is 1/16 of an inch sort of the bottom row as far as measurements go?
Yes.
So if something is less than that, it's just sort of noted as less than 1/16 of an inch. Is that correct?
Yes.
And with regard to that debris, the clear and red plastic from the debris, what, if any, examination or what, if any, instruments did you use to conduct your examination just of those pieces?
So I examined a portion of the clear plastic as well as one of the pieces of the red plastic. I examined them microscopically, and I analyzed portions instrumentally using an FTIR and a microspec.
And based on those examinations, starting with the clear plastic material that you observed, what, if any, conclusions did you come to with reference to comparison of the clear plastic material to the taillight housing?
So the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the examined portion of the clear plastic from the taillight. So accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 taillight or from another source with the same characteristics.
Now, similarly, with from your examination of the red pieces of plastic in the taillight versus the red pieces of plastic contained within the debris, what, if any, conclusion were you come from your examination of comparison of those items?
Sure. So the examined portions of the red plastic from item 7-18.18 was found to be consistent in color, microscopic appearance, instrumental properties with the examined portions of the red plastic from the taillight, item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1, the taillight, or from another source with the same characteristics.
Thank you. May I have one moment, Charlie?
Yes.
Thank you very much, ma'am. I have no further questions, John.
Right. Actually, Mr. Jackson, before you begin, why don't I see you both at sidebar votes? Actually, Jim, I guess I'll take it back.
Your may I approach the court magistrate for just a moment to get VP for identification?
Which one?
Victor. May I inquire?
Yes.
Thank you. Good morning, Ms. Well, almost afternoon, Ms. Hanley.
Good morning.
I'd like to show you a document just to begin our conversation this morning, if I may. May I approach?
Yes.
This has been previously identified as EV, as in Victor. And I'd like to ask you, first of all, to take a look at that and tell me if you generally recognize what that document is.
Yes, it appears to be a chain of custody of several items.
Okay, and is that a chain of custody document reflective of the crime lab's case number in this case? Sort of a clumsy question. Do you understand what my question is?
It is the chain of custody for 22-02184.
And is that the case number that the Massachusetts State Crime Lab, Massachusetts State Police Crime Lab assigned to this case that you're testifying about today?
Yes, that's correct.
And you've seen reports like this before, correct?
Yes.
They're routinely used in the crime lab to track evidence and maintain chain of custody, at least at the crime lab. Is that right?
That's correct.
And the information contained in the report is entered at or near the time of the event that's memorialized?
Yes.
Okay. And it's relied on generally by the crime lab as a business record, correct? As a record of the events memorialized?
Yes, it's a record of the chain of custody of items within the lab.
Okay. And my question is it relied on by the lab for truth and accuracy as best you can maintain it to track items of evidence within the lab?
Yes, it does track items.
And the information contained in the report is presumed by you and other supervisors at the lab to be accurate. Is that right?
Yes.
Your Honor, I would move for the admission of BB as an exhibit.
Objection.
See that, we'll see you inside.
Brittany's saying, did we get the chain of custody of Proctor yet? No, we have not. This is the beginning of kind of how you're laying out chain of custody, guys. So that's all coming here. Like it's all part of the process. So, and also, guys, I apologize. I have why is there an objection there? I don't know specifically, and I apologize. I've been in the middle of working on some stuff, so been taking up a little more time than I thought it was gonna be. So, but yeah, I don't know the specific reason why there's a sidebar there, but it's happening like that. Yes, Duncan Idaho says, I'm going to have to remind you this courtroom is in the shed in my backyard. And the window unit is very loud, so you need to yell at all times, Miss Hanley. Yes, the Massachusetts Crime Lab tech uses the drugs for personal use. Yep. There's a documentary about that on
Netflix.
Netflix.
My request at sidebar.
Yes.
May I inquire?
Yes.
Ms. Hanley, I want to draw your attention specifically to the glass pieces that Mr. Lally asked you about. Would you agree that there's a lot of numbers that were discussed, correct?
A lot of
I compared 3-2 to 7-12 and sub A, B, C, and D of 712 were compared with 3-2 and 3-3. A lot of numbers, right?
Yes, there are a lot of numbers, items.
Okay. I want to try, if I can, see how well it goes, to clear that up and categorize those.
Sure.
Perhaps, would you agree that we could put the items that you compared and examined in your analysis in 4 categories: 3-2, the cup or the glass; 3-3, the bumper glass; 7-12, the 9 pieces of glass recovered by a trooper named Buchnick at the scene; and 7-14, a single piece of glass recovered by a trooper named Proctor at the scene. Would you agree that those 4 categories are basically what you analyzed between and among each other?
Yes, there's 4 total items.
Okay. And within those items, there were some subcategories of items in some of those, correct?
Yes, because some of the items had multiple pieces, so they were labeled just to keep track of the pieces.
Okay. So if I could ask you to take those one at a time, pardon me, 3-2, under that column visually, that would be a single item, just the cup, correct?
Correct.
3-3, under that single item, the bumper, there would be 5 sub-items, A, B, C, and D, and E.
Yes, that's correct.
Public school education. Under 7-12, the third column, there's 9 pieces, correct? A, B, C, D, E, F as in Frank, I, K, and L are the 9 glass pieces, correct?
Correct.
They're close to being alphabetical, not quite toward the end, right?
Correct. I would have to look at my report for the exact letters, but
Sure, go ahead and look at your report.
Yeah, guys, this is just them. He's really piecing this together now.
so the 9 pieces of clear apparent glass were labeled as A, B, C, D, E, F, I, K, and L.
Okay. And then, of course, the last category would be 7-14. That's a single piece of glass that was recovered at the scene by Trooper Proctor, correct?
Correct.
All right.
Objection, Your Honor, just
So I'm going to see counsel at sidebar for just a minute on this.
I don't know what the objection is here, guys. How can they object to the evidence gathering facts? Just how the questions are being asked and whether it's the right person to ask the question.
You are unmuted.
So, Lally's not floundering yet, guys.
Yes.
Not yet at all.
So the last category we were talking about, 7-14, that was a single piece of glass, correct?
That's correct.
Okay. First of all, I'm going to ask you to take your comparisons one at a time, if I can. You compared the cup in 3-2 to the 9 pieces recovered at the scene. A, B, C, D, E, F, I, K, and L, correct?
Is that 7-12 you're talking about?
7-12. Thank you.
Sorry, can you say the letters again? I just don't know if I heard all of them.
A, B, C, D, E, F, I, K, L.
Yes, that's correct.
Of those pieces that I just mentioned, the cup was a match to A, B, C, D, F, and K, correct?
Yes, that's correct.
Pieces E and I were compared to each other, and you matched them, correct?
So I believe I'd have to look further in my notes, but I believe E and I were found to fit together by
Physical properties, meaning mechanical properties.
yes, but I would have to check my notes, but I believe it was the previous analyst that looked at 7-12 that found the physical match between E and I.
But that wasn't you?
Is it okay if I look at my notes?
Sure, I don't want to get bogged down, but yes, please.
Okay, so item 7-12 was previously examined by another analyst in the trace unit. Specifically, E and I received, when I opened this item for examination, E and I were taped together because they were found to have a physical match by the analyst who previously examined the item.
Great. Importantly, E, I, and L, however, were not found to match the cup in 3-2, correct?
That's correct.
All right. You also compared the cup in 3-2 to the 5 items recovered on the bumper in 3-3, correct?
I'm sorry, say that again.
You also analyzed the cup in 3-2 against the 5 items, A, B, C, D, and E, in 3-3, the bumper glass, correct?
Hi, Philly. Hi, Miss Tilly. I think that's what he's trying to get to. Don't know, though. We'll find out.
I did examine I compared item 3-2 to two of the pieces marked as A and B from item 3-3,
And those
which
were
was
deemed not to match the cut, correct?
correct.
And you did not analyze C and D, correct? I'm assuming that's because of size.
So the rest of the items were not used for physical match examination due to size and condition.
So as you sit here, none of the items on the bumper were deemed to match the cup, correct?
Correct.
All right. So you did end up analyzing one of the items on the bumper, item E as an echo, and you analyze that against the single piece of glass found at the scene in 7-14, correct?
Correct.
And you used both, well, you used a variety, it sounds like, of analyses, including microscopy, UV light, the glass refractive index, GRIM process, correct?
That's correct.
You also use the FTIR, is that right? Infrared spectrometry?
That's incorrect.
Okay, you did not use FTIR in this analysis?
I did not.
Okay, but in the analysis that you did use, you found that there was a match between item E on the bumper and the single piece of glass in 714, correct?
They were found to be consistent. They are found to be consistent in physical and instrumental properties.
Okay, so importantly, you also compared the single piece of glass in our sort of visual column 4, 714, that single piece of glass to the cup. We found that it didn't match, correct?
Correct.
All right. So lastly, you tested the single piece of glass found in the fourth column, 714, against the 9 pieces of glass found in 712, A, B, C, D, E, F, I, K, and L, correct?
I did compare item 714 to item 3-2 and the 9 pieces in item 7-12.
So another way to put that would be you analyze column 4 against column 3 now, correct?
I examined them for a possible physical match.
And they did not match, correct?
There was no physical match to item 714.
Okay. Your Honor, may I approach briefly?
Okay. Want to show Mr. Lally what you have?
Sure. I'm looking for the one that was already labeled. I don't have it. May I approach the clerk magistrate and ask if he's got WW by chance?
No, I do.
Can I borrow that from the court? Thank you. I'd like you to take a look at that document. Just glance it over for a second and let me know when you've had an opportunity to study that.
Okay.
You've taken a look at that single page document?
Yes.
Does that appear to accurately reflect in sort of a visual manner what you just testified to about your analysis of each of these pieces, irrespective of the text on the item, just the analysis of the items specified in that document?
I'm not quite sure what I've never seen this before. I'm not quite sure what
I think you have to move along, Mr. Jackson, for all the reasons we talked about at sidebar.
I understand. My question is a relatively simple one. Is this and if you don't understand something on the document, just say so. Is this a visual representation, an accurate visual representation of what you just testified to in terms of what matched and what didn't match? Where the green matches, the circle with the red through it doesn't match?
I would need to go through my conclusion and compare to confirm.
Fair enough. It is accurate to say, we'll use a cheat sheet for a second. It is accurate to say that the cup was not found to match any items that were found on the bumper. That's correct, correct?
That is correct.
Okay. Also, it's fair to say that the piece recovered under 714, the single piece of glass recovered under 714, does not match either the cup, nor does that piece match any of the 9 pieces in 712, correct?
And you can look at your notes if that's easier for you. We just want the right answer, Mr. Jackson, right?
Of course.
So
That's all I want.
take your time with your notes if that's easier for you.
So I'm sorry, can you just repeat the last question that you asked for?
The single piece of glass under 714 neither matches the cup, nor does it match any of the 9 pieces found in 712. In other words, it stands alone.
So that's correct. So
Okay.
714, there was no physical match between 714 and 3-2 or any of the pieces in 7-12.
Thank you for that. And then my final question is, the only piece of material, glass material, that was recovered from the bumper, item E, the only thing that any piece on that bumper matched was the single piece of glass found in 714. Correct?
So piece E from item 3-3 was the piece that I examined microscopically and instrumentally. It was found to be consistent in physical and instrumental properties with 7-14.
And that's the only piece of material on that bumper in that section, in other words, in 3-3, that matched anything else in your analysis. The piece that was found singularly at under 714, correct? The only match.
Yes, it was found to be consistent.
That's all I have. Thank you, Your Honor.
Okay. Mr. Lally?
Just briefly, Your Honor. Ms. Hanley, within item 7-12, there were 9 pieces of glass and 5 pieces of plastic, correct?
Correct.
And as far as the comparison analysis that you're conducting is concerned, why is it, as far as the pieces of plastic are concerned, why is that not part of the comparative analysis?
I did not examine the plastic pieces for physical match because there were no other plastic pieces for comparison for physical match. So I examined the glass pieces for possible physical match.
What are some of the differences between, from an elemental standpoint, as far as plastic versus glass?
Plastic is it's a type of polymer. A different type of analysis would be conducted if I was examining plastic versus glass. Something like a plastic, something that we refer to as anisotropic, or glass is isotropic. So they are different types of material.
Now, as far as characteristically speaking, from plastic and or glass, what are some of the commonalities of those items as they're found in general?
Objection.
Beyond the scope?
Yes.
Sustained.
Now, again, from the drinking glass that was recovered on scene, that was a match for 6 of the pieces of glass that were found on the roadway or on the ground at 34 Fairview Road, correct?
I believe it was 6. I just would have to confirm in my report.
Go ahead and you can go ahead and look at your notes.
Yes, it was 6 pieces from 7-12.
And then it was piece E from item 3-3 from the bumper of the defendant's vehicle that was found to be consistent with clear glass that was found on the ground at 34 Fairview Road, correct?
Yes, that's correct.
Nothing further.
Anything?
Nothing further, Your Honor.
All right, thank you very much, Ms. Hanley. You are all set.
Nope, that can stay with you. Jim, the one with all the Post-its on it. Nope, that you give me that. You give me that. Yeah, that's good. Thank you.
Your next witness, Mr. Lally?
Your Honor, may we approach?
Okay.
Yes, Your Honor. The Commonwealth calls Sergeant Yuri Buchanan to the stand.
Okay. And I do
You are
have that
unmuted.
envelope, Mr. Lally. I have
Thank
that.
Step for me. May stand in front of the clerk.
You solemnly swear the evidence you give the court and jury in the case out here should be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Whenever you're ready, Mr. Lally.
Thank you. Good afternoon, sir.
Good afternoon.
Would you please state your name and spell your last name for the jury?
Yes, sir. My name is Yuri Buchanan, spelled Y-U-R-I-Y, last of B-U-K-H-E-N-I-K.
And how are you employed, sir?
I'm employed by the Massachusetts State Police.
And how long have you been a trooper with the state police?
I've been a trooper since 2012.
And prior to being employed as a trooper with the state police, excuse me, what, if any, other employment or background do you have as far as law enforcement is concerned?
My law enforcement career began in 2003 when I graduated from the military police school in Fort Leonard, Missouri, while I was enlisted in the United States Marine Corps. From there, I was stationed at Quantico, Virginia, with the Marine Corps Presidential Helicopter Squadron. I provided security for the presidential helicopter and assets, attaining a top secret Yankee White clearance. I was promoted meritoriously to corporal and sergeant and had a platoon of 44 Marines. From there, I was stationed in Camp Pendleton, California, where I was a patrol supervisor on base as a military police officer. Once my enlistment ended, I decided to come home and pursue a law enforcement career here in Massachusetts in the communities that I grew up in. I first worked for the VA Hospital Police, where I attained a secret clearance, which was a requirement of the employment. After that, I worked at the Attleboro Police Department in uniform patrol, as well as the SWAT team with Attleboro, Massachusetts Police Department. In 2011, I applied for the Massachusetts State Police, graduated, and worked at the Sturbridge Barracks, Millbury Barracks, and Foxborough Barracks. In 2015, I was selected to come to the Norfolk District Attorney's Office with the detective unit and worked homicide cases as a trooper. 2021, December, I was promoted and took on a supervisory role within the unit.
Now, with respect to your work within the unit of the detective unit at the Norfolk District Attorney's Office, what, if any, specialized training did you receive in regard to your work there?
I've attended numerous homicide conferences, training in various aspects of digital device analysis and investigations in major crimes, homicides, drug investigations, and so forth.
Now, were you working in that capacity with the State Police Detective Unit on January 29th, 2022?
I was.
And were you on call that day?
I was on call as a supervisor.
Now, can you explain to the jury as far as the on-call system within the detective units? Well, let me ask you this first. What, if any, duties or responsibilities do you have as a sergeant or as a supervisor with reference to on-call duty and sort of how that works?
As a supervisor on call, responsibilities include answering the detective that's on call, any questions that might arise. Obviously, we don't all have the same experience, so we put our heads together, and if it's a situation or case, a scene that they have not been exposed to before, they call the supervisor for guidance, suggestion, or bounce questions off of them in order to help them navigate that case.
And who was the on-call detective on this particular date of January 29th?
January 29th, the morning hours up until 7 a.m., it was Trooper Michael Proctor.
And do you know Trooper Proctor?
I do.
And how long have you known Trooper Proctor?
Since he came into the office in 2019, I believe it was September, October 2019.
And have you supervised Trooper Proctor sort of throughout his work within the office?
I have supervised him throughout my supervisory position. So his entire time in the office, while I was a supervisor, I've supervised him directly, yes.
And as far as that on-call system or that on-call rotation is concerned, how is that determined, or how does that sort of come into existence?
The on-call system is formulated, it's compiled the month prior. So for example, if it was December, beginning of December, the troopers in the office would submit their days requesting not to be on call due to trials, training, personal reasons, or vacations they had planned. Those days are submitted in the beginning of the month, and then if it's in the beginning of December, for example, the on-call schedule for January is then compiled a month in advance, really.
So these are generated well in advance of whatever specific date a trooper is on call, correct?
That's correct.
And as far as the detective unit within the Norfolk County District Attorney's Office, who, if anyone, is your supervisor?
Currently, my supervisor is Lieutenant Fanning, and the unit commander is Detective Lieutenant Brian Tully.
And that sort of pecking order, if you will, was that the way that it was set up in January of 2022 as well?
Yes, it was.
Now, on this morning of January 29th, 2022, at some point, do you get a call in the morning, and from whom do you initially get a call?
I received the call approximately 6:44 in the morning or so from the H Troop headquarters, which is the field headquarters for the Metro Boston area, which also covers our county. And they advised me that there was a body in the snowbank in Canton. I asked for further details and advised them that I was not on call, but I would call the on-call trooper and let them know that there was a call out requesting their assistance. So that's what I did. I called Trooper Proctor and advised them to contact Canton Police.
And following that initial contact that you had from the H Troop and then your call to Trooper Proctor, what happened then?
Trooper Proctor began making phone calls, gathering information.
Sustained. Next question.
What was the next thing that happened as far as your involvement was concerned?
I was advised of the circumstances under which the body was located and what was transpiring. And I told Trooper Proctor that I would start shoveling out during the blizzard and then proceed to meet him in Canton to begin our investigation.
And where was it that you and Trooper Proctor first met up on that particular morning?
We met at the Canton Police Department.
And do you recall approximately what time it was that you arrived at the Canton Police Department?
It was approximately 9:15. Due to the amount of snow that was on the ground, the time that it took me to shovel out the main roads, actually no roads were plowed at the time during my track. So I decided to drive my personal truck to Canton Police Department because it was a 4-wheel drive and meet Trooper Proctor there.
Now, as far as your personal truck versus you have a work vehicle as well?
That's correct.
And you mentioned that the truck is 4-wheel drive. What is the difference between your personal truck and its capabilities in weather versus the work vehicle?
Well, at the time, there was approximately 10, 15 inches of snow that had accumulated already. My work vehicle is a sedan, low to the ground, low clearance, front-wheel drive. It would not be able to navigate the road conditions at the time. My 4-wheel drive vehicle is higher clearance from the roadway and was able to navigate the conditions at the time.
And sir, when you arrived, so at approximately 8:22 in the morning or so, where is it that you were at that point in time, if you know?
At 8:22, I would say I was still blowing the snow out of my driveway, clearing the path for my truck to leave the driveway.
And when you arrived at the Canton Police Station, you mentioned that you met Trooper Proctor there. Do you recall who arrived first?
Trooper Proctor was in the parking lot in his vehicle, and I pulled in, backed in next to his, and we walked in together into the police department, I believe.
And when you walked into the Canton Police Station on that morning, sometime after 9 a.m., where is it that you went? Who, if anyone, did you talk to when you first got there?
We walked into the police department, were guided to the detective department division of the PD, and we met with the detectives from Canton and Sergeant Good, who was the uniform patrol sergeant and having been the first responder to the scene as well.
Now, without reference to anything that was communicated between the two of you, at some point prior to getting to the Canton Police Station, did you have conversations with Trooper Proctor?
Yes, I did.
And did Trooper Proctor make you aware of conversations that he had had with other people prior to getting to the Canton Police Station?
Objection.
You literally
Well, I'll
saw
allow
me
that.
on the
That's a
phone,
yes or
Chad.
no.
Yes.
And so you get to the Canton Police Station, you and Trooper Proctor then proceed to talk to Sergeant Good, is that correct?
That's correct.
And again, without any reference to what was said to you by Sergeant Good, he relayed some information to you as well?
That's correct.
No, I'll allow that.
That's correct.
And if you know about how long was the period of the conversation that you had with Sergeant Good at the Canton Police Station?
The conversation with Sergeant Good was probably 25 to 30 minutes. He walked us through his...
Next question, please, Mr. Lally. I'm going to stop you from answering that, Sergeant.
Yes, Your Honor.
So, Sergeant Mechanic, in reference to, at some point, did you learn the name of the body or the person that was found on the lawn on Fairview Road?
Yes, I did.
Who did you learn him to be?
Mr. John O'Keefe.
And in reference to where Mr. O'Keefe's body was at that point, what, if any, information did you receive about that?
Objection.
I'll allow that.
We learned that Mr. O'Keefe's body was transported to the hospital, Good Samaritan Hospital in Brockton.
And in reference to the Good Samaritan Hospital in Brockton, who, if anyone else, were you told had been taken to that facility as well in relation to your response that morning?
Objection.
I'll allow that.
The defendant.
And just to be clear, at some points over the course of your investigation, have you had interactions with Karen Reed?
Yes, I have.
And to be clear, when we say, as far as Karen Reed, the defendant, you see her in the courtroom today.
Yes, I do.
Can you identify just as to where she's seated or an article of clothing that she's wearing?
She's seated between her legal defense team wearing the white blouse.
Your Honor, that's the record reflect identification of the defendant.
Yes.
So upon having that conversation with Sergeant Good at the Canton Police Station, where is it that you and Trooper Proctor went next?
From the Canton Police Department, we proceeded to the McCabe residence.
And that was over on Country Lane, is that correct?
That's correct, number 12, Country Lane.
And when you arrived there, as far as transportation to that, is it you and Trooper Proctor in the same vehicle?
Yes, I made the decision to drive us. That way we only take one vehicle. In addition to Trooper Proctor being able to make phone calls and facilitate other logistics as necessary, allowed him that freedom to do so while I operated the vehicle in the dangerous snow conditions.
And the snow conditions that you were talking about as far as clearing out your driveway, the drive to the Canton Police Station, did those conditions persist throughout the day of the 29th?
Yes, they did.
And so you make your way over to the McCabe residence, again, without anything that was said. Who, if anyone, did you speak with at the McCabe residence that morning?
We first spoke with Miss Jennifer McCabe. We then spoke with Mr. Matt McCabe, and then we spoke with Mr. Brian Albert.
And with reference to each of those conversations, were they done collectively or separately, or how were those interviews conducted?
Each interview was conducted separately. We first interviewed Ms. Jennifer McCabe with request of Mr. McCabe to give us privacy. He proceeded upstairs. Once we were done with that interview, Mr. McCabe came downstairs, and Ms. McCabe gave us the same courtesy. And once that interview was over, Mr. Brian Albert had arrived, and we interviewed him briefly.
Is that sort of the typical process of how at least your unit conducts interviews with respect to civilians?
Yes, with cooperating civilians, we typically advise them that we schedule an interview. We proceed to their location of convenience and separate them and get their version of recollection of events that we are inquiring about.
Now, after you spoke with those three individuals, yourself and Trooper Proctor at the McCabe residence, where is it that you and Trooper Proctor went next?
We proceeded to the Good Samaritan Hospital in Brockton.
And where within the Good Samaritan Hospital did you go?
We went to the emergency department.
And within the emergency department, were you led to a specific room?
Yes, we were.
And what, if anything, did you observe when you were in that room?
Once in the room, we observed Mr. O'Keefe's body on the medical bed or gurney, and his clothing, which had been cut off of him, were on the floor at the foot of the bed, a couple of feet away at the foot of the bed.
Now, first, with regard to the clothing, what, if anything, did you do with regard to that?
After viewing Mr. O'Keefe's body, we proceeded to identify the clothing items and bag them into evidence bags, notating which item and a brief description about each item of clothing.
So let me ask you just a little bit about that as far as that process is concerned. So when an item of evidence is collected by you or by your units during the course of an investigation, is there sort of a policy or a protocol, or how are things, what do you do with things when you collect them and take them into custody and evidence?
If we deem an item to be of evidentiary value, we identify the item, we take a brief description of it, and we label the evidence bag with that description. We notate who is taking the item into custody, typically who located the item, the time that it's located, and the location from which it was seized or taken or collected.
And with regard to items of clothing, is that something that would be placed in just one big bag of clothes, or like how would those be packaged in evidence bag?
Mr. O'Keefe's clothing, which was already in one big pile on the floor, we packaged all.
Okay, jurors, feel free to stand up and stretch.
So yes, guys, we've got the great Sergeant Bukaki on the stand. Thrilling testimony so far, chat. Thrilling testimony. So, just the most obnoxious of all the accents so far. Sergeant Buchanan has the most obnoxious of accents so far. I think we can all agree. So, in your face, Sean. Yes. That's what happens. Sergeant Bukaki shows up and he's like, pow, right in your face. Oh, I'm sure at his job now in the office, I'm sure in the office they said, hey, what's up, Sergeant Bukaki? I'm sure that's his nickname now. It's going to be his name till he retires. I mean, hell, if he's got kids, they're probably referred to as Bukaki now. If you're outside of a house, it's the floor. If you're inside, it's called the floor, not the ground. Yeah, well, these people are retarded. They're from Massachusetts. Sorry, Charlie. Suffer, Charlie, suffer. Hey, not all of us from Massachusetts are dummies. Maybe not all of you, but most of you. Range says, show us your YouTube history report. I get that reference.
And so I'm sorry, Sergeant Buchanan, when you come into the hospital room where Mr. O'Keefe's body was, there's clothing items that are on the floor, is that correct?
That's correct.
And do you recall how those clothing items were in relation to each other, in relation to the floor?
They were positioned on the floor in a pile stacked on top of each other, and they were in the condition of being soaking wet.
And with respect to those clothing items, do you recall what those clothing items were individually?
Yes, sir.
And what were
They were a plaid pair of boxer underwear. It was a orange colored design print t-shirt. It was a blue pair of Lucky brand jeans, a belt, two-tone gray, light, thin, hooded sweatshirt, and a right sneaker, black in color with white design and a Nike brand.
And how many sneakers were there contained within that property?
One right sneaker.
And what, if any, observations did you make of the condition beyond them being soaking wet?
I also recognized, due to the aroma and visual observations, traces of vomit on the clothing.
And with regard to those items that you observed on the floor, what, if anything, did you and or Trooper Proctor do with reference to those clothing items? Objection.
I'll allow that.
Once we went through the clothing, we collected each item and put it into a large evidence bag. We double bagged it due to the wetness of the clothing, so it would not seep through. We also identified the fact that there was only one sneaker. So I requested that Trooper Proctor contact the paramedics that transported Mr. O'Keefe from 34 Fairview to the hospital and have them once again check their ambulance to see if there was another sneaker inadvertently left behind in the ambulance vehicle.
Now, prior to sort of physically touching this or any other piece of evidence, what, if any, other sort of precautions do you take prior to handling, tactile handling any piece of evidence?
Anytime we handle evidence, which obviously we take great caution not to destroy, alter, or discard any evidence, we also put on gloves in order to help preserve that item.
And in reference to these items or items of anything of evidentiary value that you seize as evidence, once you take it and secure it into an evidence bag, what happens to it from there?
Once it's secure in the evidence bag, it is sealed and logged into our evidence storage facility at the office. And then as necessary, it is signed out, shipped off for processing, review, or court proceedings.
And as far as that sealing is concerned, how are bags or boxes of items of evidentiary value, how are they sealed?
Once the bag is...
I'll allow it. I'll allow it.
Thank you, Your Honor. Once the bag is sealed, we utilize tape, typically red or yellow tape. Once it's secured, we initial and date the tape on the edge. That procedure helps identify the time and date it was sealed and by who with the initials.
And then once that bag or box is sealed, if that bag or box is subsequently opened at a later time, what if any notation or what if any recordation of that is made?
Anytime a piece of evidence is signed out for review, it's logged in the tracking system. In addition, anytime a piece of evidence is open, with a container being a bag or a box is open and the tape is cut, it is then resealed, reinitialed, and dated by the trooper or an individual who's signing that evidence out and then returning it.
As far as the evidence bag or box is concerned, when it's been opened, is that something that is noticeable based on the sealing and resealing of that particular receptacle?
Yes, sir. It is definitely noticeable, and it's noted in the systems.
Now, with regard to, you mentioned or made some mention earlier in the testimony in regard to evidence storage facilities at your office.
Yes.
Can you describe what those are and who, if anyone, has access to those evidence storage areas?
Within our office, we have 2 troopers that are designated as evidence officers. Those individuals have access to the secure rooms designated strictly for evidence storage. Those rooms are inventoried and kept under not just lock and key, but also digital access control and alarm systems. They are the only ones that have access to those facilities, in addition to our unit commander. But I'll tell you that our unit commander does not access that room without the evidence officers. I myself, even as a supervisor, do not have access to that room.
You don't have access to that evidence room, is that correct?
That's correct.
Is Trooper Proctor, is he one of those evidence officers? Did he have access to that room?
He does not.
As far as at the time in January of 2022, who were the troopers within your office who did have access to that?
In January 2022, that would be Trooper Jeff Kakowski and Trooper David DeChico.
And that would be in addition to Lieutenant Tully, is that correct?
Detective Lieutenant Tully, I believe, has access to it, but I cannot speak to that. I just believe that he does, as a unit commander, to facilitate any next assignment.
Now, with reference to any items that you were physically present for that were taken into custody or taken into evidence, including that clothing from the hospital on January 29th and any other items throughout the course of this investigation, when they were taped and sealed, what happened with each of those items once they were taken back to your office?
Objection.
I'll allow it.
Each item that was sealed, it was processed in, it was logged in, and then it was stored. After processing, it was stored in the evidence room.
Now, returning back to the Good Samaritan Hospital, within that hospital room, you made mention that you secured items and that you made observations of Mr. O'Keefe. Is that correct?
That's correct.
And can you describe for the jury, as far as Mr. O'Keefe's body, what were those observations that you made?
Mr. O'Keefe's body was laying on his back. The observations I made were of bruising to the eyelids of his face. Based on my experience and having cases with head trauma, I can tell you that during subdural hematoma,
Yeah, I'll sustain the objection. You can build a foundation if you can, Mr. Lally.
Over the course of your work with this unit in particular, if you know about how many homicide or let me step into it this way. As far as your work within this unit, as far as it's concerned, what, if any, jurisdiction does the State Police Detective Unit of the District Attorney's Office have with reference to not only homicide, but death investigations within Norfolk County?
By statute, Chapter 38, Section 4, each county, the district attorney's office is provided jurisdiction over all death investigations. As a result, the law enforcement entities that are assigned to that Norfolk or that district attorney perform the investigations. In Norfolk County, those individuals are members of the Massachusetts State Police assigned to the State Police Detective Unit within our office.
And so as far as death investigations, what exactly or what type of investigations would that encompass?
Death investigations that we have jurisdiction over are all unattended deaths. Unattended death means that a physician, a doctor, is not overseeing the individual that passes. Those deaths would be suicides, homicides, overdose type deaths, natural deaths, accidental deaths, and so forth. Any type of death that is not overseen by a doctor at a medical facility or in a hospice type situation.
So as a result of your assignment to this unit and that sort of exclusivity of jurisdiction over unattended deaths within Norfolk County, if you know approximately how many death investigations have you been a part of over the course of your work with the State Police Detective? Excuse me.
Over the last 9 years, I would venture to say it's over 500 death investigations that I was a part of.
And Sergeant, over the course of your involvement within those investigations, if you know, how many of those investigations involved some indication or some type of head trauma?
Scores of investigations that involved some sort of head trauma.
And through the course of your investigations, in those cases that have involved scores of head trauma, have you been privy to information as far as medical findings, autopsy reports, things of that nature in relation to those prior investigations?
Yes, sir, I have been.
Now, with regard to your observations of Mr. O'Keefe, with regard to his eyelids, what if any observations did you make, and what if any? Well, let me start just with the physical observations. What if any physical observations did you make of Mr. O'Keefe's face and body in general?
His face, I observed the swelling and the discoloration being produced through the blood pooling in the eyelids.
Yep, so just your observation, so the swelling and discoloration.
Move to strike.
I'll strike the remainder of what you've said.
I also observed a cut to his nostril and an eyelid, which was very small in size, which would have been produced by a...
Objection.
Yeah, so we'll leave it at that. Next question, Mr. Lally.
Based on your training and experience, what if any conclusions or what if any opinions that you have in regard to the swelling around the eyes?
Objection.
Yeah, I'll see you at sidebar here.
Did.
He is very, very smug, guys. And yeah, I
Yes.
would argue it's a medical
Sergeant
conclusion
Mechanic, with
too.
reference to your prior death investigations, have you had occasion to make observations of bodies that there was a later determination of some sort of subdural hemorrhage?
Yes.
I'll allow that. Have you made those observations? Have you been
David,
part
you're
of
always
those
welcome on, man.
investigations?
Yes, Your Honor. Yes.
And what you observed in regard to Mr. O'Keefe, was that consistent or inconsistent with what you had observed on those prior investigations?
Objection.
That I'll allow.
It was consistent.
Now, in addition to the injuries that you observed to Mr. O'Keefe's face, What, if any, injuries did you observe to his extremities?
His extremities produced abrasions to his upper forearm and lower bicep area on his right arm.
And just as you use that term, I'm not asking for any sort of medical definition, but as far as you use that term abrasions, what do you understand that term to be?
I understand that term to be a injury sustained through blunt force trauma or friction to the epidermis of the skin, where a crushing of the vascular system occurs and produces that type of sign on the skin.
And from your observation of the injuries to Mr. O'Keefe's arm, which arm was this again?
It was his right arm.
And as far as your observation of those injuries to his right arm, what, if any, as far as the consistency of those injuries, what, if anything, did you note or observe in reference to those?
Objection.
Consistency with what? With the,
Let me rephrase this.
Yeah.
How were the abrasions that you're describing positioned in relation to each other?
Each abrasion appeared to me to be linear and concentrated in a specific location on the arm. It didn't go any further north of a point and did not go any further south of a point. So it was concentrated in the elbow, a few inches below the elbow, a few inches above the elbow on the right arm.
Now, while you were at the Good Samaritan Hospital, did you endeavor to speak with Ms. Reed?
We did attempt to, yes.
And was she present at the hospital at that time?
No, she was not.
And at some point subsequent to that, did you receive, or what, if any, information did you receive as to her whereabouts?
We were made aware that she was located at 345 Country Hill Drive in Dayton at her parents' home.
And where did you go from the Good Samaritan Hospital once you left from there?
We proceeded to that location.
Now, sir, with reference to the items of clothing that you recovered from the Good Samaritan of Mr. O'Keefe's, do you have those items of clothing with you here today in court?
Yes, I do.
Your Honor, with the court's permission, I would ask that the witness be allowed to retrieve those items and display those items.
okay, are they in the courtroom?
I believe so, yes.
Okay, yes,
May I approach?
yes. How many items are we talking about? Okay.
All right, chat. Now we're getting to the fun stuff.
Jurors, if we go a little past 1, my intention would be to still just take a half-hour lunch today and come back. So I'd rather just
Half
go
hour
through this if we
lunch.
could.
Gee.
Sergeant,
Yes.
presenting you with this item, do you recognize that?
Yes, I do.
And what do you recognize that to be?
The sweatshirt from the hospital room where Mr. O'Keefe was located.
And Your Honor, the call will seek to introduce and admit that as the next exhibit.
Okay, any objection, Mr. Jackson?
Sort of need to see what's in the bag before I can object, but on
So,
principle, no.
okay, all right, so you've received photos of all of this, right?
I assume what's in the bag is what's been photographed, but until I see it, I won't know.
All right, so let's go ahead and open it.
With the court's permission?
Yes.
It's full of solo cups, cat. Proctor's gonna grab the bag like it's China. God, that is 8 up, chat. That is fucking 8 up.
No objection.
So Lally, why don't you come take the bag? Yes.
Put it back in the bag.
It's in evidence, and we'll put that back in the bag. Okay.
May I approach, Your Honor?
Yes.
I need you another item, sir. Do you recognize that item?
Yes, I do.
And what do you recognize that to be?
Says it's a one orange T-shirt.
And Your Honor, with the court's permission, if the witness could remove that item and display it for the jury as well.
Yes.
No objection.
Okay.
Exhibit 438.
Your Honor, may I approach?
Yes, the infamous
Yes.
shirts.
Another item, sir. Do you recognize that?
Yes, it's the right sneaker recovered from the hospital room.
Your Honor, with the court's permission, if the witness could remove that item from
Yes.
the bag. Display it for the jury.
Also, guys, remember we talked about how you do things? This is what evidence that's collected should look like. Sealed and protected, not in a fucking Kroger bag.
May we approach briefly?
Okay.
Benjamin, no, he's not bringing in his own evidence. That's evidence that's there. They already give it to, the state has it, and they give it to him to open. There's a couple of comments here. Oh, Obscure Outdoor Destination saying, thanks for looking at the tweets. Of course. Yes, he's going to run away like the guy in Taiwan. Proctor's going to run out with it. Now, great success is what relevance has showing this? Well, they don't have the body to wave around, so they wave around the bloody clothes. It's prejudicial, but it's relevant evidence to show that he died. So it's evidence. You're waving the bloody shirt to show, you know, it's just like it's like Mark Antony waving around Caesar's bloody cloak. It's to stir up emotions. So yes, now it's like the Shroud of Turin. Will we see the body? We'll see the body with the medical examiner. Casey, did the EMTs testify that they ripped his clothes off? No, but they took him off pretty forcefully to check him. But even the cutting guys, I'm saying overall, those things look really ratty anyway. That's a third brown bag. He's terrible at identifying things. Yeah, but you're going to read it just to make sure. Because if you say it's the left foot, but it's the right shoe on the bag, means the feds are going to be like, oh my God, Officer Bukaki, do you know what you're saying? So no, they're just doing it by the numbers. You go through and identify everything. So Charlie's saying stop and Charlie's like, actually, Stop and Shop is a good supermarket. I was watching a YouTube video that had the same logo as SNS, but a different name. Had to be owned by the same company. Did O'Keefe put on clean underwear that day? Yeah. Good point about the gloves. He's not even handling evidence properly. Well, most of these guys, courtrooms are awful at it, so. After a while, the gloves really don't make sense. They don't, and everything gets cross-contaminated all the time in courts. I think until something happens, in a court case where evidence gets cross-contaminated, then there's like a new trial. I don't think you're going to see major changes to the way police handle stuff. Star Market is Stop and Shop too. Ah, good old Star Market.
Sergeant.
You are unmuted.
All right, Mr. Lally.
Yes, thank you, sir. If you could return that to the back, please. Introduce in minutes.
Yes, I'm going to.
No objection.
Thank you.
May I approach one last time? My apologies.
Your Honor, I guess I should have said no objection with what we discussed.
I understand.
Thank you.
Your Honor, may I approach the witness again?
Yes.
Anything with last item from that set, do you recognize that?
Yes, it's a bag containing a blue jeans, black belt, and plaid boxer shorts.
And Your Honor, with the court's permission, may the witness remove just the jeans and the belt from the back?
Yes.
Thank you, sir. You can return that to the back, sir. Your Honor, call Malta seek to introduce and admit as the next exhibit.
Okay.
No objection, Your Honor.
Thank you. So are you not displaying the third item, but it's going into evidence? Or is it just the jeans and the belt going into evidence?
The jeans and the belt into evidence, Your Honor, with the court's permission.
So we can mark the bag and we'll remove the third item during a break. Thank you. All right, so Sergeant, you'll be with us this afternoon. Why don't we take our lunch and recess? It's only going to be about a half an hour.
Thank you, Your Honor.
All right, so folks, we'll see you back here, let's say no later than 1:40, okay?
Court, all rise for the jury.
You are muted.
So, all right, guys. So we are all set now for lunch. And see, everything stays with the court reporter. If you guys just rewind it, everything stays with the court reporter because now it's an open exhibit. So we're breaking for lunch. Apparently, it's only going to be a half hour. What's for lunch? Some things. I have to take care of some stuff. So, do you guys want to hang out in here for a little while, or do you want me to start a new chat or a new stream? Because I can do that. The court reporter has a bag lunch. They're not coming back at 2. Apparently, we're coming back at 1:30. So that's the thing. They're only taking a half hour lunch. I have to poop. Well, leave it open. All right, yeah. We're coming back at 30-minute lunches. No, government lunch would be 2.5 hours long, and you can take a nap afterwards. That's a government lunch. So, all right, guys, I will be back shortly. I will put up. Well, I don't know what can we watch. Well, are we having lunch together? No, guys, and I have to make some I got to make some calls. I just got to call for somebody I need to. So, Sean's going to order from Denny's. Well, Denny's actually runs like a burger shop. It's called Burger Den. It's actually pretty good. You guys want some Kino Casino? All right, we'll watch some Kino Casino if you guys want to. You guys want to watch United's opening statement? All right, you know what? We'll do that. Hold on here. All right. Stop sharing. Excuse me. Jeez. The playlist. Do they have a Karen Red playlist? All right, Kieran Reed. Let's see if we can find day 1. Opening statement. All right, I got Yannetti. You guys are gonna watch this opening statement here while I take care of stuff. All right. Let's see here.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. Good morning again, ladies and gentlemen. As I previously told you, my name is David Yannetti. I'm an attorney with an office in Boston. Together with attorneys Alan Jackson and Elizabeth Little, it is truly my privilege and my honor to represent Karen Reed during this trial.
Hi. So, Ms. Doherty,
From a very early juncture in this
court
case,
tomorrow?
you will question the Commonwealth's theory of the case.
Yeah, what's
You will
Sal,
question
right?
the quality of the Commonwealth's
Yeah.
evidence.
Do you have any
You will
questions for
question
me?
the veracity of the
Because I
Commonwealth's
just want you to understand, you
witnesses.
don't have to talk to me
And
right
you
now.
will question their
You
shoddy
understand that?
and biased investigation.
You know, do you like?
A
Do you have
faulty
any questions for me?
investigation that
I
led
mean, it sounds like
Karen
you since you
Reed
called.
sitting here today. You will learn, in short, that the police did no real investigation of this case, and you will question why. You'll question
We're good,
why
guys. We're good. We're
the
good. We're good.
investigators had such tunnel vision. You will question why they focused solely on Karen Reed, someone with no ties to the Canton Police Department, as opposed to the well-known and well-connected Albert family of Canton, a family that was never treated as suspects by the investigators in this case. Boston police officer John O'Keefe was found mortally injured on Brian Albert's front lawn. His body was in full view and almost right below Brian Albert's bedroom window on his front lawn. He was found wearing only one sneaker. You'll learn that Brian Albert was a Boston police officer as well, and that he was a trained first responder. Brian Albert was notified that another police officer was injured and unresponsive on his front lawn, and Brian Albert did nothing. His sister-in-law, Jennifer McCabe, and other civilians were on his property that morning after John O'Keefe's body was found. Police, EMTs, firefighters, police cruisers, an ambulance, fire truck, lights flashing, and first responder Brian Albert never came out of his house. Equally important for you will be the fact that the lead homicide investigators never went inside the Albert home that night. You'll learn that Brian Albert's brother, Kevin Albert, is a Canton police officer. It was obvious very early on that the Canton police should not be investigating the death of a man found on the property of the brother of a Canton police officer. So it was decided just about from the start that the Massachusetts State Police should take complete control of this investigation because the Canton police were conflicted out. Now, that sounded good at the time, but you'll learn that two major problems arose. First, despite the fact that they obviously had a conflict of interest, the evidence will show that the Canton police still had their hands in this investigation. You will find it astounding, but Canton police officer Kevin Albert, the reason for the conflict of interest in the first place, was continually updated about the status of this investigation while it was going on. Second, and equally troubling, is that the lead state police detective who was assigned to this case was a man named Michael Proctor. Michael Proctor, you will learn, is one of the many people in Canton with deep ties to the Albert family. Michael Proctor's own mother refers to the Alberts as the Proctor's second family. His own sister's wedding, Michael Proctor was in the wedding party with Colin Albert. And he sat at the head table of that wedding with members of the Albert family. That's the man who was chosen to lead the investigation into the suspicious death on the property of Brian Albert. That's the man who gave updates to Canton police officer Kevin Albert, while the state police were supposed to be investigating what had occurred at his brother Brian Albert's house. You'll learn that right from the jump, Michael Proctor predetermined the outcome of this case. Never stepped foot inside the Albert home on January 29th, 2022. Never checked out whether there were any signs of struggle inside that home. He never called for crime scene technicians and other specialists to look for blood or other trace evidence within the home. He never asked Brian Albert for permission to go in the home and take a look around. Michael Proctor never applied for a search warrant to go in that home. Instead, he focused immediately and exclusively on Karen Reed, the outsider. You will learn that no one in the Proctor family has ever called the Reed family their second family. No one in the Proctor family had been in a wedding party with anyone from the Reed family. Karen Reed was a convenient outsider. She was most definitely not from Canton. So how did Michael Proctor feel about her? How did he treat somebody he was investigating at a point in time when he should have been keeping an open mind and focusing on obtaining all possible evidence so that he didn't miss anything? Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone. He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing and what he was saying. And he was revealing his true thoughts about Karen Reed to his friends, not what he put in his sanitized police reports, his true feelings to his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself. He told his friends that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe. You will learn that one of Michael Proctor's high school friends commented to him that with a dead body on the front lawn, the homeowner in this case is surely going to catch a lot of grief. And do you know what Michael Proctor's response to that was? One word. Nope. And he explained why. Michael Proctor assured his buddies that the homeowner would not catch a lot of grief because, quote, the homeowner's a Boston cop too, end quote. That one sentence, ladies and gentlemen, in Michael Proctor's own words, will explain a lot to you about how this investigation was conducted. You will be able to evaluate whether Trooper Michael Proctor treated Brian Albert and his family differently because of who they are and their relationships between his family and theirs. You will evaluate whether this investigation was on the up and up. You will decide, as a result, how valuable or worthless the prosecution's DNA evidence is or is not, in light of who controlled that evidence. You will learn that Michael Proctor's fingerprints are figuratively all over this case. His fingerprints are all over the Commonwealth's evidence. You will learn that Michael Proctor showed up at Karen Reed's parents' house in Dighton to interview her during the afternoon of January 29th, only hours after John O'Keefe's body was found dead on Brian Albert's front lawn. You'll learn that Michael Proctor had her Lexus SUV towed from her parents' home. But you'll also learn that he wrote a search warrant in which he falsified the time that he took that SUV. He swore under oath that the vehicle wasn't towed until 5:30 p.m. But you'll learn that we obtained surveillance footage that he didn't know we would get. And that surveillance footage exposed that Michael Proctor's words in that sworn affidavit were a lie. Michael Proctor had that vehicle for about 90 minutes before he claimed to have taken it. And folks, you will learn that the timing is important, very important. Because when John O'Keefe was first found on Brian Albert's front lawn, the police thoroughly searched that yard for potential evidence. And it wasn't just one officer, or two, or three. There were at least 4 officers that searched that front lawn. And that morning was the beginning of a snowstorm, but there wasn't yet much snow on the ground when they were searching that lawn. It was light out by the time they did the search, and it was getting lighter. And during that thorough search of Brian Albert's front lawn, the number of pieces of taillight that were found by a minimum of 4 officers looking for evidence was 0. It was only later in the day, when the snow was really starting to accumulate, that the police miraculously started to find pieces of taillight on the property. The police only started to find pieces of taillight after Michael Proctor had seized Karen Reed's car. They only started to find pieces of taillight after Michael Proctor had possession of her taillight. You'll learn that Trooper Michael Proctor then kept going back to the Albert residence after that day, and he claims to have kept finding pieces of taillight on multiple occasions on multiple different days. And in addition, a good week after John O'Keefe's death, Canton Police Chief Kenneth Berkowitz, an older officer on the brink of retirement with probably not the best eyesight, he supposedly was driving, happened to be driving past Brian Albert's house. And by the way, Brian Albert is someone with whom Chief Berkowitz is also good friends. And this older man allegedly spotted yet another piece of taillight from his moving vehicle. This was yet another piece of taillight that was somehow missed by the trained specialists who had previously and thoroughly searched the property. Another piece of taillight that Proctor supposedly missed in the many times he went back to the property. Michael Proctor claims that he kept finding pieces of taillight right up until February 18th of 2022, which was nearly 3 weeks after John O'Keefe was found dead on Brian Albert's lawn. You will learn that there is no competent evidence that Karen Reed's taillight shattered at Brian Albert's property in the early morning hours of January 29th of 2022. To the contrary, you'll learn that when Karen left John at Brian Albert's house, she drove back to John's house on Meadows Ave across town in Canton. At John's home, where he lived with his 2 adopted children, Karen was drifting in and out of sleep, but she woke up for good in a panic sometime around 4 a.m. because John hadn't come home. And that was not like him at all. He had never done that before. Karen had a sinking feeling that something was wrong. Something was seriously wrong. So she got back into her Lexus and she backed up out of the garage to leave the driveway. And when she did, the right rear taillight of her Lexus struck John's parked vehicle in the driveway and her taillight cracked. That was the same taillight that the prosecution now claims was broken outside the Albert residence hours earlier at 12:30 a.m. But we have video evidence that the taillight was actually broken at 5 a.m., many hours after the prosecution needs that taillight to have been broken. There is, of course, no video of the taillight being broken at Brian Albert's house. You will eventually conclude that that's because the taillight was not broken there. Importantly, you will learn that there was an eyewitness who arrived at 34 Fairview after Karen got there with John O'Keefe in the early morning hours of January 29th. And that eyewitness, Brian Nagel, who's the brother of Julie Nagel, who was at the after-hours party that night. He had a clear view of Karen's SUV. Ryan Nagel confirms that there was no damage to her taillight at that time. Karen was sitting in the driver's seat with her hands at 10 and 2. And Ryan Nagel confirms that while Karen was inside the car, John O'Keefe was not. John O'Keefe was also not outside the car at that time. You will ultimately conclude there's only one other place he could have been. Now, going back to that 5 a.m. video from John's driveway, you will see Karen back up her Lexus and strike John's car at about 5 a.m. when she was leaving John's house to go out to look for him. And you will know that she struck his car at 5 a.m. because you will watch that video closely. You will witness that the wheels and the hubcaps on John's car are jostled and moved by Karen's SUV. And you will conclude that that video depicts exactly when Karen's taillight was cracked, long after she dropped off John that night at 34 Fairview. And you will learn that part of the reason that Karen's Lexus hit John's car was that Karen was panicked at that time. Where is John? Why didn't he come home? What happened to him? And you will learn that she was racking her brain for what possibly could have happened. And like many of us, was worried about the worst. Did I hit him? Could I have hit him? That was what she was saying, both to herself and to other people later that morning when she went back to 34 Fairview. She couldn't think of anything else that made sense. She certainly didn't consider in a million years that someone from within the Albert home could have beaten up John and left him to die on the front lawn. Now, that was over 2 years ago. Karen didn't know then what you will learn during this trial. Karen didn't know that Brian Albert's sister-in-law, Jennifer McCabe, left the after-hours party at Brian Albert's house sometime after Karen pulled away. She didn't know that after Jennifer McCabe dropped off some people elsewhere, she returned to her own home. Karen didn't know that Jennifer McCabe climbed some stairs in her home and eventually made it into her bedroom with her cell phone. Karen didn't know that Jennifer McCabe settled in at 2:27 in the morning on January 29th, 2022, and typed a Google search that she would later delete. 2:27 in the morning was over 3 hours before John O'Keefe's body was found on Brian Albert's lawn. 2:27 was over 3 hours before anyone knew or suspected that John O'Keefe was missing or hurt or in trouble. And at 2:27 in the morning, you will learn that with no one watching her, thinking she was alone with her thoughts, not worrying that anyone would know what she was doing, Jennifer McCabe typed in the following Google search: how long to die in the cold? Now, she misspelled the first word, so the actual search was "how long to die in the cold," but you'll get the point. You will ask yourself, why would somebody Google how long does it take for someone to die in the cold, unless that person knew someone who either was in that situation or would be in that situation? You will question during this trial, who was it who actually did die in the cold at some point that night, sometime after Jen McCabe was asking Google for an answer to her question? And you'll learn that the answer to that question was John O'Keefe. The medical examiner in this case will testify that one of the causes of John O'Keefe's death was hypothermia. John O'Keefe died in part because he was left to die in the cold. Now, the Commonwealth will try to dispute the timing of that Google search. They'll try to claim that there were only 2 Google searches at 6:23 and 6:24 a.m. after John's body was found. But one problem for the Commonwealth will be that we have retained Richard Green, one of the leading computer forensic experts in the country. Rick Green has forensically analyzed Jennifer McCabe's phone, both manually and using every appropriate type of computer software to solve this issue. Rick Green will confirm for you that Jennifer McCabe did indeed make that search at 2:27 a.m. And another problem for the Commonwealth is that you will hear and see other evidence that will confirm that Jennifer McCabe is lying when she denies making that Google search at 2:27 a.m. You will conclude that before she went to bed, if she went to bed that night, Jennifer McCabe wanted to know just how long it would take for someone to die in the cold. And a big question in this trial for you will be, when was John O'Keefe left to die in the cold? I expect the Commonwealth will try to persuade you that he was left there sometime around 12:30 a.m. because they're going to try to prove to you that Karen Reed hit him and that his body stayed there the entire night until first responders arrived at 6 a.m. and his body was taken to the hospital. But you will learn that there are big problems with the Commonwealth's theory of this case. You will learn that there were 6 people at that after-hours party at Brian Albert's house, all of whom left by the front door and would have been confronted by John O'Keefe's lifeless body on that lawn if he was actually there at that time. Those 6 people walked out the front door to 34 Fairview, walked to their cars, either in the driveway or parked in front of the house. Brian Albert's sister-in-law, Jennifer McCabe, was there. Her husband, Matthew McCabe, was there. ATF federal agent Brian Higgins was there, who was also Brian Albert's friend. Sarah Levinson, a friend of Brian Albert Jr., was there. Julie Nagel, another friend of Brian Albert Jr., was there. And Caitlin Albert, Brian Albert's daughter, was also there. All of them leaving the residence. Each of those people left 34 Fairview in Canton, where Brian Albert lived. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2", nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe laying. Not one. And you know who else saw no one laying outside in the early morning hours of January 29th? The snowplow driver in charge of plowing the street for the city of Canton. And this is another big problem for the Commonwealth. You will learn that Michael Proctor, here's that name again, wrote a report where he claimed that the DPW supervisor had told him that Fairview Road had not been plowed that night. Proctor's total investigation on this issue consisted of one phone call and no follow-up. He just submitted his report that simply said the road hadn't been plowed that night, and perhaps thinking that no one else would follow up either. But you'll learn that when it came to finding out the truth, it's not that Proctor couldn't find the truth, it's that he wouldn't. But fortunately, you'll learn that we would, and we did. You'll learn that within weeks after January 29th, we sent our investigator, a former Medford police officer named Paul Makowski, to the Canton DPW to try to get to the bottom of this. Paul Makowski talked to the same supervisor at the DPW, a man named Michael Trotta, whom Proctor claimed had told him that the street hadn't been plowed that night. You'll learn that Paul Makowski found out that Michael Proctor was not telling the truth. You'll learn that Michael Trotta from the DPW told Paul Makowski, our investigator, that the street was indeed plowed that night, and that the name of the plow driver was Brian Loughran. So Paul Makowski tracked down Brian Loughran. He asked Mr. Loughran if the state police or any investigators had ever spoken to him. And the answer came back, no. You will then learn what Brian Loughran had to say about what he saw and didn't see that night, and you will be shocked. Brian Loughran told Paul Makowski that he was driving a big snowplow in Canton that night. You'll learn that the nickname for it at the DPW was Frankenstein because it had a lot of spare parts and it had been around forever. Brian Loughran told Paul Makowski that when he plows the streets of Canton in Frankenstein, he's very careful. He makes sure to check not only the roads in front of him, but also the yards to the side of his plow. He makes sure not to hit a fire hydrant or a tree or an animal, or heaven forbid, a person lying in the snow. He's always on the lookout. You'll learn that Brian Loughran passed by 34 Fairview in his plow, traveling right by Brian Albert's front lawn at 2:30 in the morning. You'll learn that Brian Loughran confirms that at about 2:30, when he went by that house, John O'Keefe was not on that front lawn. So you'll learn that about 2 hours after the Commonwealth claims that Karen Reed somehow incapacitated John O'Keefe, an eyewitness confirms that not only could it not have happened, but it didn't happen. But you'll learn that Brian Loughran also provides some other troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 in the morning and seeing no body, he showed up again at the entrance to Fairview Road, intending to make another pass down it with his plow. This time, however, at about 3:30 in the morning, he looked down the street and he saw that parked right next to Brian Albert's front lawn, right in the very area where John O'Keefe's body was later found at 6 a.m., Brian Loughran saw a Ford Edge parked on the side of the road. You will learn that the police have done zero investigation to discover whose Ford Edge that was. You'll learn that members of the Albert family drove Ford Edges. You'll learn that the police to this day claim not to know who was parked right next to the area where John O'Keefe's body was later found. You will learn that while investigators on this case, including Michael Proctor, completely ignored the snowplow driver who went right by the Albert residence, the defense not only tracked him down and interviewed him, but the plow driver actually took our investigator on a ride back past the residence to explain the precise route that he had taken on January 29th. You'll learn that some other curious things were going on in the early morning hours of January 29th. Curious things that the police in this case utterly failed to investigate. For example, after people left the after-hours party at Brian Albert's house on January 29, Brian Albert claimed that he had no contact with anyone but his wife until he was woken up in the morning. But you will learn that he was ultimately confronted by the fact that his phone records revealed that he had actually placed a phone call to ATF agent Brian Higgins, his friend, the same friend who had been at his house earlier that night. And that was at 2:22 in the morning. You'll learn that Brian Higgins called him back 17 seconds later, and they connected 22 seconds on their cell phones. You'll be asked to consider just how long 22 seconds is and what could be said and discussed during that long of a phone call. You will consider that phone call in the context of the other curious things that were going on during the early morning hours of January 29th. You will learn about the following in chronological order. 2:12 a.m.
I know for a fact they're not back because live right now, chat, is just the fan. They've been gone now for 35 minutes. Don't worry, I know they're not there.
Jennifer McCabe arrives at her home. 2:22 a.m. Brian Albert calls Brian Higgins. 2:22 a.m., 17 seconds later, Higgins calls him back. And Brian Albert and Brian Higgins are on the phone together for 22 seconds. 2:23 a.m., Jennifer McCabe climbs the stairs to her bedroom. 2:27 a.m., Jennifer McCabe searches on Google how long to die in the cold. 2:30 a.m., plow driver Brian Loughran confirms there was no body on Brian Albert's front lawn. 3:30 a.m., Brian Loughran confirms that a Ford Edge was parked right where John O'Keefe's body was later found. The Commonwealth will not be able to successfully dispute any of those facts, yet I expect that they will persist in asking you to convict Karen Reed anyway. You will learn that there are other major problems with the Commonwealth's theory. You'll learn that when John O'Keefe was found, he did not look like he had been hit by a car. You'll learn that he looked to have been attacked and beaten up. You'll learn that John O'Keefe was a large 6'2" man who, if positioned behind a Lexus SUV, would have had his torso completely exposed to the rear of that vehicle, including to the taillight. You'll learn that no part of his torso was injured. There was no bruising, no ridges, no scratches, no punctures. You'll learn that his chest and hips and legs were pristine, despite the Commonwealth's contention that he was hit by a 6,000-pound vehicle. The evidence will show that what was not pristine was his right arm. You will take one look at that arm, and you will conclude that a car did not cause those injuries. The injuries to John O'Keefe's arm appear to be consistent with scratch marks and claw marks, marks that make it look as though an animal had attacked his arm. But you won't have to rely just on your common sense when you look at those photos. You'll hear from an expert forensic pathologist who is world-renowned, who has personally conducted thousands of autopsies. And he will testify that those marks are consistent with scratch and claw marks and bite marks from an animal, including a German Shepherd. You'll learn that on January 29th of 2022, Brian Albert's family dog, Chloe, was a German Shepherd. You'll learn that Brian Albert has admitted that this dog is not good around strangers. You'll learn that on January 29th of 2022, John O'Keefe would have been a stranger to that dog. And you'll learn that Chloe had been the beloved family dog for the Alberts for 7 years. The Albert family loved Chloe. But strangely, as we discuss this dog today, the Albert family doesn't have its beloved Chloe anymore. You'll learn that Brian Albert was called to testify before the grand jury regarding this matter in April of 2022, and that he did testify about his German Shepherd, Chloe, during that grand jury testimony. And you'll learn that not long after that testimony, Brian Albert and his family rehomed their beloved family dog. They gave away their family dog. And Chloe, the German Shepherd, is therefore now gone. Now, the Commonwealth will try to take your attention away from all of these troubling facts and try to persuade you not to consider their shocking lack of investigation of anyone else, not to consider John O'Keefe's injuries, not to consider the fact that multiple people left the residence and saw no body, not to consider the fact that the snowplow driver was specifically looking at 2:30 a.m. and there was no body there, not to consider the fact that two people in the house were communicating at 2:22 a.m., but denied speaking to each other for 22 seconds. And not to consider the fact that one of their witnesses, who was also present at the home, was unusually curious at 2:27 a.m. about how long it would take for someone to die in the cold. The Commonwealth will instead try to persuade you that Karen Reed supposedly had a motive to kill John O'Keefe because they were not getting along. You'll hear about their trip to Aruba over New Year's Eve and that Karen was upset that John had been flirting with another woman. And you will hear that Karen considered exploring her options after that trip, which led her to a get-together at one point with ATF federal agent Brian Higgins, although that never went anywhere. But you'll also hear that in January of 2022, after the Aruba trip, and not long before January 28th and 29th, John O'Keefe was making long-term plans with Karen, including a family trip with her and the kids, and also another trip with Karen and another couple for months into the future. And you'll see video of how John and Karen were interacting on the night in question. You'll see for yourself how they looked at each other. from the video at the waterfall that night. Nobody who saw them that night saw anything wrong. There was nothing wrong. I mean, like any couples, occasionally they would bicker or disagree. But you will hear zero evidence of any domestic violence in that home whatsoever. John never raised a hand in anger toward Karen, and Karen never raised a hand in anger toward John. That simply wasn't who they are. You will conclude the notion that Karen Reed chose the start of a snowstorm to suddenly become violent out of the blue for the first time and intentionally kill her boyfriend by hitting him with her car and leaving him there with a house full of people inside is patently ridiculous. You will also learn that what's not ridiculous is that someone, not Karen Reed, ambushed John O'Keefe. Somebody probably didn't mean to kill him, but somebody went too far. You'll learn that Trooper Proctor failed to investigate motives that other people had to harm John O'Keefe. You'll learn that Proctor failed to investigate anything or anyone who was in the Albert residence that night. You'll learn that he failed to investigate the antagonistic relationship between members of the Albert family and John O'Keefe. You'll learn that apparently nobody investigates the Albert family of Canton. Remember, on day one, Trooper Proctor was asked whether the homeowner, Brian Albert, would catch a lot of grief. And Trooper Proctor himself said it. Nope. Homeowner's a Boston cop too. So folks, the trial is now about to start and the witnesses are about to start testifying. On behalf of Karen Reed, I ask that you do two things during this trial. First, I ask that you pay attention to all of the evidence. The way trials work, the prosecution gets to present its case first. They conduct their direct examinations first. So we respectfully ask that you wait for us. We will get to cross-examine their witnesses, and you will find that cross-examination is the key that unlocks the truth. Wait for us. You'll be glad that you did. Second, I ask that you keep your eye on the ball.
Thank you. May be seated. Quarterback in session. Witnesses are-
I told you guys I was watching. Judge was not back
All
yet.
All right, Mr. Lally.
May we approach this briefly?
Okay.
1 ton is 2,000 pounds. Guys, 1 ton is, oh my God. God, it's going to be me being science. 1 ton is 2,000 pounds. That's known as a short ton. A metric ton is 2,200 pounds. It's known as a long ton. You got long tons and short tons. But yes, a U.S. ton is 2,000 pounds, not 2,500. And I'm pretty sure that Lexus is a Lexus 550 GX. The weight on that thing, even if it's a 2021 like she had. What are its specs? Its weight. How much does the Lexus 570 weigh? Yeah, you guys are saying like it doesn't weigh 5,000 pounds. A 2024 Lexus LX 570 is almost 7,500 pounds. These are big fucking cars, chat. These are big fucking vehicles. I mean, these are massive. The curb weight on a 2024 model is almost 7,485 pounds. So it's over 3 tons. You guys are saying it's under 2 tons. There's like no way in hell. Yeah, these things are heavy. These things are fucking heavy. It's like a Suburban. You know? A Chevy Suburban's weight. A 2024 Chevy Suburban out of the factory, 6,000 pounds. These are big fucking cars. Chevy Suburban, 6,000 pounds. Big cars. That's right. Yeah, it's a Land Cruiser, but it's big. They're huge and they're heavy.
Okay, you can go ahead, Mr. Lally.
Yes, thank you, Your Honor. Sergeant Mechanic, those items, as far as the clothing items that you displayed for the jury just prior to the recess, those were the same clothing items that you recovered from the hospital room of the Good Samaritan on January 29th, is that correct?
Yes, sir.
Now, you had mentioned earlier in your testimony that those items had been placed into one bag initially. What, if anything, happened with those items as far as their keeping or their bagging once you got back to the office or to your where the evidence room is?
Due to the condition of those items after they arrived at the office, the items were laid out on butcher's paper that we utilize for evidence viewing and allowed to dry naturally because they were soaking wet.
And as far as when they were done with that sort of drying process, how were they packaged from there?
They were packaged in the bags, sealed up, and stored for transport and processing.
And so those would be bags individual for each clothing item, is that correct?
Each item, the way that it was packaged, the pants with the belt and the boxers, and then so on and so forth with the sweatshirt and sneakers.
And get to this a little bit more in a moment, but at some point there were pieces of plastic, red and clear plastic, that were recovered by you and other troopers from Fairview Road, is that correct?
That's correct.
At any point in time, were pieces of clear and red plastic that were recovered from 34 Fairview Road ever placed inside the same evidence bag as any piece of clothing that you recovered from this bag?
No, absolutely not.
Now, with reference to the hospital of Good Samaritan, in addition to yourself and Trooper Proctor, were there other members of the state police or other units of the state police that arrived at the hospital at some point?
Yes, sir. Lieutenant Mello came to the hospital to document the victim and the clothing, and he's assigned to the state police crime scene services section.
Now, as far as the crime scene services section, or CSSS, what, if any, role do they have with relation to your investigation in this case, or your investigations in general as far as documentation is concerned?
Crime scene services section assists us in documenting scenes through video and photographs. They also assist in collecting latent prints, fingerprints. They assist in collecting impressions, like foot impressions in mud or soil, and those types of missions.
Now, there are a number of different troopers that are assigned to that particular unit, is that correct?
That's correct.
And as far as over the course of this investigation, how many occasions approximately were there that a member of the crime scene services section responded to memorialize or photograph different scenes or different areas throughout the course of your investigation in this case?
Just off the top of my head, there would be 4, 5, maybe 6 instances where a trooper or sergeant from crime scene services responded to the scene to assist us in this investigation.
Now, at any point in time over the course of the investigation, when crime scene services troopers responded to document anything, was it ever the same trooper more than once?
No, it was not.
And so with regard to January 29th, back at the Good Samaritan Hospital, there were Sergeant Mello arrived to document or photograph Mr. O'Keefe, correct?
That's correct.
And Your Honor, may I approach the witness?
Yes.
Mr. Lally, do you want me to give my instruction now or in a few minutes?
Just about 30 seconds.
Okay.
So Sergeant Mechanic just placed 3 photographs before you. Do you recognize what's depicted in those 3 photographs?
I do.
And what do you recognize those to be?
That is Mr. John O'Keefe.
And what's contained within those photographs is that a fair and accurate portrayal of what you saw of Mr. O'Keefe's body at the Good Samaritan Hospital on January 29th.
Yes, it is.
Your Honor, may I approach again?
Yes.
Your Honor, the Commonwealth seeks to introduce in the mid.
All right. So there's no objection, right? All right. So, folks, the Commonwealth is introducing into evidence through this witness certain photographs that are not pleasant and may be considered graphic photos. Sometimes evidence is presented that creates an emotional reaction in jurors. For example, it's natural and understandable to feel sympathy and empathy when you hear about a person who was injured in some serious way or suffered in some way or who has passed away. But as jurors, you've taken an oath to follow the law, and I instruct you that you must separate any emotional reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony, and you must find the facts in this case based only on the evidence. You can't find facts or base your decision on sympathy, anger, passion, or prejudice or pity for or against either side in this case. Rather, your verdict must be based solely on the evidence and my instructions on the law. All right, with that, Mr. Lally, those photos will be in evidence.
Thank you. Your Honor, with the court's permission, may publish just briefly each of the 3 respective photographs.
Yes. Thank you.
And Ms. Gilman, if I could have photograph 2866. And Sergeant, direct your attention.
We're not
to the
gonna
screen,
see,
Is that what's displayed on there now has been marked as Exhibit 441? Do you recognize that?
Yes, I do.
And using the laser pointer on the desk before you, if you could draw the jury's attention. to
Sorry,
what
chat.
significance you observed in this particular photograph of Mr. O'Keefe.
I observed the swelling of the eyelids, slight laceration
are we gonna
of the
see that?
nostril and the eyelid, the blood pooling on the bed, and that depiction of Mr. O'Keefe.
Ms. Gilman, can I have photograph 2857? Again, Sergeant, do you recognize what's up on the screen and is now marked as Exhibit 442?
I do.
And similar to the prior exhibit, if you could, using the laser pointer, direct the jury's attention to what, if anything, is significant you observed in this photograph.
I observed the parallel lacerations, abrasions, and markings on the skin of Mr. O'Keefe, limited between that point there and that point there, as I described earlier in my testimony.
And Ms. Gilman, if I could have 2859. And again, Sergeant, do you recognize what's up on the screen? It has now been marked as Exhibit 443.
I do.
And this is, what do you see in this photograph?
It's the same abrasions to Mr. O'Keefe's right arm, just further up on the bicep, tricep, shoulder area.
Thank you, sir. Ms. Gilman, you can take that. Now, Sergeant, taking you back to January 29th, 2022, after you left the Good Samaritan Hospital, where is it that you went?
Went to 345 Country Hill Drive in Dayton.
And that was the residence of Ms. Reed's parents, is that correct?
That is correct.
Now, on your way from the Good Samaritan in Brockton to the residence in Dayton, what, if any, communication did either you or Trooper Proctor have with regard to the Dayton police?
I advised Trooper Proctor to contact Dayton Police Dispatch and advised them that we would be responding to the location, 345 Country Hill Drive, and seizing a vehicle. And we were requesting uniformed patrols to assist us in that mission.
And why was that request made of the local PD?
We were going into their jurisdiction. There was a blizzard going on. We were considerate of the circumstance and wanted to be courteous to the Reed residents and not just show up without any uniform presence. We have never met the Reed family. They have never met us. And with the clothing that we were wearing, it would be difficult for them to see that we were law enforcement.
And so as you arrive in that area of the residence in Dayton, where did you position yourselves and when did you arrive in relation to the marked unit from Dayton?
We called them while we were still on the highway and gave them an approximate time of arrival. GPS was not accurate due to the conditions at the time on the roadways.
Chad, I don't know what's happened. It's frozen on my end too. Hold on here. Uh-oh.
Would be
See if that fixes it.
responding to.
Frozen on their end too. Let's see long crime.
Arrived, where did you then point did you learn the name of at least one of those officers that arrived at the residence with you?
At the time I did, yes.
And was that an Officer Barrows?
Yes, it was.
And so when Officer Barrows arrived, where did you then proceed with Officer Barrows upon his arrival?
Well, the road was only plowed the width of one vehicle. So even though he and his partner were in a F-150 or 250 marked police cruiser, we could only travel in single line. We traveled up to the cul-de-sac, turned around and positioned our vehicles facing back out to the way that we entered the roadway or that street. We parked on the roadway since the driveway was not plowed, and we waded through the snow to the front door of the residence.
When you say the driveway was not plowed or you waded through the snow, can you describe to the jury sort of the condition of the driveway as you made your way from the street to the house?
With the blowing winds and the drifting snow, there were locations along our walk to the property with snow varying from knee-high to up to my waist. For reference, I'm 6'1", so it was quite deep in some locations.
And as you made your way to the home, what, if anything, did you observe in the driveway?
As we walked up to the driveway in front of the garage, we observed a large Lexus black in color SUV bearing Massachusetts registration 3GC684.
And subsequently, did you come to find out whose vehicle that was?
Yes, once we queried the plate, we learned that the vehicle was registered to the defendant.
And as you're going by this vehicle, what, if any, observations did you make of the vehicle as you were walking past it toward the home?
I observed a damaged rear right taillight fixture on the vehicle. From my vantage point, I also told Trooper Proctor to approach the vehicle closer and confirm what I was seeing, which he did.
And as far as that damage to the right passenger taillight area, can you describe sort of what it was that you saw during that initial phase?
Absolutely. During the initial phase, I observed snow compacted and caked onto portions of the taillight casing. There were pieces missing, and I knew that because the left side taillight was intact. Glass storm door, unable to open due to the level of snow on the ground and on the front steps.
And so where were you directed to enter the home from?
Mr. Reed directed us to the garage door, at which point it opened up and Trooper Proctor and I entered the garage. We were once again greeted by Mr. Reed and invited into the home.
And Officer Barrows, where did he remain when you and Trooper Proctor went into the home?
He remained outside with the vehicle. During our time in the home, Officer Barrows came in and asked what the plan was and offered to have DPW plow out the driveway because the tow truck was not able to maneuver into the driveway in order to retrieve that vehicle.
Now, as far as during any time that you were on scene or at this residence in Dighton, did you yourself or did you observe Trooper Proctor touch that vehicle at any point in any way while you were there?
No.
And did you observe Officer Barrows or any other personnel beyond the tow truck driver touch the vehicle in any way?
No.
And as far as the tow truck driver was concerned, did you observe that individual touch anywhere in the rear passenger side area of that vehicle at any time that you were there?
No.
So then you proceed inside the home, and when you get inside the home, where did you go and who, if anyone, did you speak to?
We were directed by Mr. Reed to the living room where the defendant was seated on the couch. She had her laptop on her lap and her phone resting on the right armrest of the couch.
Now, in addition to the defendant and her father, who, if anyone else, was present when you talked to Ms. Reed?
The defendant's mother, Mrs. Reed, was also present in the home.
And the defendant's mother and the defendant's father, were they present throughout the course of your interview or your discussion with Ms. Reed?
Yes, they were.
And at any point in time, did you ask them to leave or anything like that?
I did not know.
Now, with respect to, can you describe sort of the demeanor or the tone of the conversation that you had with Ms. Reed that afternoon?
It was polite, courteous. She had just went through a traumatic event, so we were considerate of her losing her boyfriend. And we had a normal tone conversation. We were in the information gathering, fact-finding portion of the investigation. We simply wanted to collect her recollection of events that she remembered.
And so throughout the course of this interview, how are you standing? Are you seated? Or how are you positioned in relation to Ms. Reed, and how is she positioned in relation to you?
She was sitting on the couch. We were standing across the room. I don't recall if there was a coffee table, but if there was a coffee table, we would be standing on the opposite side of that coffee table if there was one present. I do not remember if there was one present, but that's the distance approximately from me to the defense table.
And if you could describe to the jury sort of how did that interview or how did that conversation begin? What was said?
First things first, we introduce ourselves, advise the individual we're speaking with who we are, where we work, and what we're looking to find out. The defendant was advised that we're looking to get a recollection of the events, what happened, what she observed, what she remembers from the night before, and to walk us through the last 24 hours or so of activity.
And
Do I need to give an instruction, Mr. Lally? I'm not sure exactly. Why don't I see counsel at sidebar for a minute?
Let's see what happens there, chat. But this is, yeah. Oh, he bites his lips so much he gave it up. So she was sectioned, yeah. Mm-hmm. And they were sniffing the glue. Jeez. Yeah, this is just. Well. Oh, wow, they're gone for a bit here. It's kind of so-so at this point. Tuck Tech, the mouthpiece. Well, talk about this again. It's called a steno mask. She speaks into it. She's the court reporter. So everything you say, she's speaking out into a shorthand to create a record. Hmm. 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 Will the defense call Proctor to the stand? I don't know. If the state
All
doesn't,
right, so I
surely.
interrupted you, Sergeant, and I'm going to instruct you jurors, okay? We're about to hear testimony about statements allegedly made by the defendant, Karen Reed, allegedly concerning the crimes that are charged in this case. Before you may even consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether any statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or questioning by the police, and the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor. You must consider the totality of the surrounding circumstances. I'll instruct you about this again at the end of the case, but for purposes of, as you hear the testimony, that's the lens that you have to sort of hear it through. All right, with that, Mr. Lally?
Thank you, Your Honor. Now, Sergeant Mechanic, when you began to speak to the defendant, prior to any sort of substantive conversation, what, if any, conversation did you have with her about the conversation you were going to have?
I just asked her to recount any events and the history between the actions that were taking place.
And how did she initially respond to that?
She stated that she's willing to answer our questions. She just doesn't want to go into too much detail about what transpired. And given the circumstances that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went, can you describe that conversation or the contents of that conversation to the jury?
Absolutely. The conversation was normal tone of voice like I am speaking to you right now. Ms. Reed responded in the same tone of voice, answered questions. The content of the conversation began with her saying that, as I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast, or what they had for breakfast. She went on to say that she met Mr. O'Keefe at C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking, consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's, facing northbound. So the vehicle was on the side of Waterfall Bar and Grill. We went on through the conversation, the interview, to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or a container from that establishment, to which point she stated that she did not. She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. He did not get into any verbal or physical altercations with anyone to have sustained those injuries. She stated that once at the Waterfall, they stayed for approximately an hour, hanging out with acquaintances. And then they left the Waterfall. She drove them to, after they were invited to a residence, she drove them to a location in Canton, where she dropped Mr. O'Keefe off. She was asked if she saw Mr. O'Keefe walk into the home at 34 Fairview, and she stated she did not. She stated that she made a 3-point turn after dropping him off and left. She was asked whether or not Mr. O'Keefe, excuse me, let me back up. She was asked if she knew, how she found out about the damage to her vehicle, to which she stated, quote, "I don't know, it happened last night," end quote.
Now, at some point earlier in the interview, what, if any, indication did she give as to who Mr. O'Keefe was with when she arrived at C.F. McCarthy's, and sort of how long he had been with those respective people?
She indicated that Mr. O'Keefe was with Mr. Camarano, Kurt Roberts, at which point she was asked to provide contact information, meaning phone numbers for those individuals, at which time she picked up the phone on the right armrest of the couch, manipulated the device, entering a passcode, and provided that phone number to Trooper Proctor and I.
At any point in time in the conversation or interview you had with her, what, if anything, did the defendant say in regard to why she had not gone into the residence at Fairview Road herself?
The defendant stated that she was having stomach issues and did not want to enter the residence.
Now, what, if anything, did she tell you about the later on that morning of the 29th?
She stated that when she woke up, she began looking for Mr. O'Keefe. And when she found him in the snow, she began CPR on Mr. O'Keefe.
And what, if anything, did she say to you about any observations she made of Mr. O'Keefe later on that morning, as far as any injuries to Mr. O'Keefe?
The defendant stated that while she was performing CPR, Mr. O'Keefe had sustained injuries and was bleeding from the nose and the mouth.
And if you recall, what, if anything, did she say about Mr. O'Keefe's eyes at that time?
The defendant stated that Mr. O'Keefe's eyes were swollen.
Is that both eyes? Is that correct?
That's correct.
Now, as the interview progressed, at some point, did you ask questions seeking further details?
Yes, I did.
And details about what specifically were you asking?
Once we got to the point in time where the defendant told me she did a 3-point turn, I asked her to walk through step by step of her operating the vehicle and exactly what she did. Prior to that, I asked her, so she was asked to give a step-by-step recollection of how she, what she did in manipulating the vehicle and leaving the scene.
And at that point, was the interview terminated?
Yes, it was.
Now, once the interview concluded or was terminated, what, if anything, did you do with reference to Ms. Reed's phone and the defendant's vehicle?
Once the interview was terminated, I advised Ms. Reed that her phone was going to be seized as evidence and her vehicle was going to be seized as evidence as well.
And did you subsequently seize both of those items, sir?
Yes, we did.
And similar to the clothing of Mr. O'Keefe, as far as evidence was concerned, was that packaged and taped and transported back to the office in a similar fashion?
The vehicle was transported via tow truck that was dispatched by Dighton PD on our request.
And so when you get back outside of the residence after the conclusion of your interview with the defendant, what, if anything, did you observe going on with regard to the driveway and or any other vehicles that weren't there when you went into the house?
During our interview, I glanced out the window and I saw flashing amber lights and a tow truck plowing the driveway. So the driveway was plowed and the tow truck was, plow truck was plowing the driveway, not the tow truck. And the tow truck was loading the vehicle onto the flatbed.
And at any point in time when you were outside of the residence, what, if any, observations did you make as far as cameras or anything like that on the exterior of the home?
I did not see cameras on the exterior of the home at that point in time.
Subsequent to that date, did you become aware that there were exterior cameras that record on the exterior of the home in Dighton?
Subsequently, yes, we learned that there was video recording of the residence and the driveway.
Your Honor, may I approach?
Yes.
I'm showing you a disc. Do you recognize that, sir?
Yes.
And what do you recognize that to be?
I recognize it to be Dighton videos as it relates to the location where the interview and the vehicle was seized from.
And what's contained on that, as far as the video is concerned, is that a fair and accurate portrayal of what you observed as far as the defendant's vehicle being loaded onto a tow truck?
Yes, it is.
Thank you. Can I approach again, Your Honor?
Yes.
I'll move to seek to introduce and admit as an exhibit.
No objection.
And Your Honor, with the court's permission, if I could publish those 2 short clips for the jury?
Yes.
Just come in if you could, click on it and then pause when it is. You could press on my.
Still, you need to keep your voice up.
Yes. You pause right there, please. Now, the Sergeant Mechanic, from this particular point of the video, do you recognize the vehicle that has just pulled into the driveway?
Yes, I do.
Is that the same driveway that you had walked up from the street to the house in Dighton on that morning?
Yes, it is.
As far as the vehicle is concerned, what do you recognize that vehicle to be?
That would be the Lexus SUV owned by the defendant, Bear, Massachusetts, registration 3 GC 684.
I'm going to take a press play from there. This moment, if you could pause right there. Two individuals just exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are, as far as who they are and from what part of the vehicle they exited from?
Yes, the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
That'd be the defendant's father, is that correct?
That's correct.
This gentleman, if you could explain this to the end. Now, Sergeant, towards the end of that video, did you observe the defendant and her father in any specific area in relation to that vehicle?
Yes, I observed the defendant and her father at the rear right taillight, gesturing or signaling towards the affected, damaged, and missing parts of the taillight.
Hold on, I don't know.
I'll allow just the direction that they were signaling out.
I don't agree with that.
Okay?
As far as that vehicle's position within the driveway, is that essentially?
Let's rewatch that. Hold on, chat.
Do you recognize the vehicle that is just pulled into the driveway?
Yes, I do.
Is that the same driveway that you had walked up from the street to?
Matt.
I will say, look at all that fucking snow, but
This moment, if you could pause right there. Two individuals just exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are, as far as who they are and from what part of the vehicle they exited from?
Yes, the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
That'd be the defendant's father, is that correct?
That's correct.
This gentleman, if you could explain this to the end. Now, Sergeant, towards the end of that video, did you observe the defendant and her father in any specific area in relation to that vehicle?
Yes, I
you can't see a damn thing of what's going on there.
observed the defendant and her father at the rear right taillight, gesturing or signaling towards the affected, damaged, and missing parts of the taillight.
Objection.
I'll allow just the direction that they were signaling out.
Move to strike the remainder.
Okay?
As far as that vehicle's position within the driveway, is that essentially the position that you observed it in when you and Trooper Proctor and Officer Barrows were walking up the driveway to the home?
Yes, it was.
And Ms. Gilman, if I got a second of those two videos. If you could pause it there, please. Again, Sergeant Mechanic, if you could describe to the jury what you observed of significance within this particular video.
This video captures the vehicle being moved into position to be loaded up onto the flatbed for transport from the scene.
Gentlemen, if you could play for me. Pause right there.
I'm sorry.
I just asked her to pause right there.
Yeah, you really have to keep your voice up.
Yes, sir. Sergeant Mechanic, from this still image from this video, what, if anything, of significance do you observe in relation to the vehicle at this time that is being loaded onto the tow truck?
The rear taillight is illuminated. You could see a white light coming from that taillight.
If you could, using that laser pointer you have before you, just direct the jury's attention to the specific area you're talking about.
Right there.
Okay. Ms. Gilman, if you could play this through to the. Ms. Gilman, you can take that down. Now, Sergeant Mechanic, as far as when you left the residence in Dayton, where is it that you went?
Can we turn the lights on, Mr. Lally?
Yes, my apologies.
Once we left the residence in Dayton, we proceeded following the tow truck back to the Canton Police Department.
And was there anywhere else that either you or the tow truck went between Dayton and the Canton Police Department?
No, sir.
And when you say we, it's yourself and Trooper Proctor, is that correct?
That's correct.
Now, once you arrived at the Canton Police Department, where did the vehicle go?
The vehicle was unloaded and put into a heated sally port located at the Canton Police Department.
And in reference to the Canton Police Department and putting it in the sally port, why was it that it was taken to that location?
It's a location that serves as a storage for a vehicle that would suffice for the size of the vehicle. The location is, as it related to the crime that took place was investigated, was in that town. So we utilized their facility. It was also a heated facility accumulating on the vehicle.
And at some point, well, as far as some point subsequent to this, did you learn that there are exterior cameras of the Canton Police Department as well as cameras within the Sally Port garage area?
Yes, I did.
And have you reviewed each of those respective cameras prior to your testimony here today?
Yes, I have.
May I approach, Your Honor?
Yes.
So I'm showing you a disc, just have to look at that, look up and finish. You recognize that, sir?
Yes, I do.
And what do you recognize that to be?
The Canton Police Department driveway with video.
And what's contained on that is that fair and accurate portrayal of yourself and the tow truck pulling into the Canton Police Department driveway on that afternoon or early evening of January 29th.
Yes, it is.
May I approach, Your Honor?
Yes.
Almost seek to introduce the minutes of that exhibit.
They have just a moment, Council.
Okay.
My- Thank you for that, Your Honor. No objection.
Okay.
And Your Honor, with the court's permission, may publish that video to your aid this time.
Okay.
Pause there, Ms. Newman. And just for reference points, in regard to this view of this camera, Sergeant, you're familiar with the Canton Police Station?
Yes, I am.
And so where is this camera view in relation to the Canton Police Department and the Sally Port garage where the vehicle eventually goes?
This camera is capturing the driveway entrance to the Canton Police Department. As viewed from Washington Street, that driveway there is on the left side of the structure. The camera itself is pointing towards the entrance of the driveway to the Canton Police Department. As you can see, the brake light illuminated in the shot. That is a Canton Police cruiser sitting at the edge of the driveway right by Washington Street.
So for orientation purposes, as far as the tow truck and your vehicle, is that coming from the top of the screen to the bottom or the bottom to the top?
It's coming from the top left to the bottom right of the screen towards the rear of the building where the Sally Port is located.
Thank you, Ms. Gilman, if you could. Pause there, Ms. Gilman. Now, as far as what's depicted in this still shot of this video, Sergeant, what if anything do you observe?
That is the tow truck transporting the defendant's vehicle, arriving at Canton PD. My vehicle with Trooper Proctor inside, me operating, are following closely behind as we did the entire way from Dayton all the way to Canton.
Gentlemen, if you could play that to the end. Thank you. Now, as far as the interior of the Sallyport garage, that
Put the lights, thank you.
as far as the interior Sallyport of the garage, you mentioned that that is a heated area. Is that correct?
That's correct.
And as far as the heat within that, do you know how that is produced or how hot it gets in there as far as the time that you spent within there?
I do not know, but it was a standard garage heating system that blows hot air. As far as temperature, when the doors were open, that day it was freezing cold. It was, I believe, like 18 degrees with, winds blowing. So inside the garage inside the Sallyport with the doors open, it was quite cold. Once the doors shut, the temperature rose above freezing, and the snow began to melt off of the vehicle.
And from the arrival of that vehicle into the Sallyport garage area, are you aware or have you reviewed video in reference to that?
Yes, I did.
And Your Honor, may I approach?
Yes.
Showing you another disc, sir. Just ask you to review that one when you finish. And do you recognize that, sir?
Yes, I do.
And does that contain the video that you were just testifying about as far as the arrival of the vehicle at the Canton Police Department Sallyport garage?
Yes, it is.
Thank you. May I approach, Your Honor?
Yes.
Come up and seek to introduce in the minutes of the next exhibit.
No objection, Your Honor.
Now, Sergeant, before we get to that video, if I could just ask, if you know, approximately what time was it that you left Dayton following that tow truck back to the Canton Police Department?
We left Dayton approximately 4:15, 4:20, and we followed the vehicle back to Canton, arriving probably around 5:30 or so p.m.
Thank you, sir. And Your Honor, with the court's permission, if we could publish that video for the jury.
Okay.
Ms. Gilman, if you could just pause there for a moment. Sergeant, direct your attention up to the video on the screen just for orientation purposes again. First of all, do you recognize what's depicted in this video?
Yes, I do.
What do you recognize it to be?
That is the Sallyport two-bay garage at Canton Police Department with the antique Canton Cruiser on the bottom of the screen, and the open spot for a vehicle in the middle of the screen with the four-wheel drive all-terrain vehicle at the top.
Now, as far as, again, for orientation purposes, the driveway that the jury just witnessed in the prior exhibit, is that to the left of the screen, the right of the screen, or something else?
The driveway is to the right of the screen.
And this vehicle, the defendant was sort of taken into the garage from the opposite side or from the left of the screen, is that correct?
Correct.
Ms. Gilman, if you could, please.
Your Honor, may we approach briefly?
Okay, could you pause that, Ms. Gilman?
Look at conspiring. I mean, yes. And who was saying why don't they have good cameras? I mean, because they bought their cameras probably 10 years ago or longer. Looks like a great place to preserve evidence. Yeah, it's not a very safe place, secured place. The antique police car does look neat. Yeah, it's one of their. They probably found one of their police cars from like the 70s, so or 50s. That's a freaking garage. Ain't nothing supposed to be in a Sally port. Yeah, I mean, not technically, but it's where you transfer your people in custody out of the car. I mean, actually, technically, I guess. The best kind of correct, the technically correct. All right. How do you spell this? Sorry, I got to trying to reach out to figure out who the hell this guy is here. Okay, sorry. Trying to find a guy who's in prison and I can't find him. Like, and I know he's 100% there because he's in prison. I'm trying to figure out what place I can send him information.
On our long days at about a half an hour, but I think the better use of our time is to give you a 10-minute break now. And then we'll go straight through till 4 o'clock. And if anybody needs a break,
interesting. I don't know what we're taking a break for. I don't know what we're taking a break for.
Jim.
Yeah, so somebody just brought up, and Jim Satala just brought it up to me as a message, and I think it's correct. That window, the light on the car looks very weird when they're trying to get it up on the flatbed. And I think it's funny, it's so damn snowy and shitty out, they can't get it up on the flatbed right away. But also, guys, remember, that corner side of the light was still there. So we're looking at it from the side, so we'll see that going up the ramp. Graxus, you actually asked a really good question. And like I said, guys, if you are new, my name's Sean, potentially criminal. I'm an attorney out in the Cleveland area, Cleveland, Ohio. If you have questions, throw them out there. Obviously, super chat, it's like guaranteed for me to notice it, but otherwise, I'll catch them when I see them. This is a good question. Oh, we're going back to something. Here we go.
John, if may the witness leave the stand just for a moment.
Sure.
Thank you.
Yeah, we'll see you back here in about 10 minutes, Sergeant.
You are unmuted.
Okay, so you want us to watch this now?
If you please the court, yes.
Ooh. So, like, they didn't even throw a tarp over this fucking thing, which is sad. They didn't, this has not been preserved. They didn't, tape a bag over it or a tarp or nothing. Nothing, chat. Amateur hour.
May I get just a little closer?
Sure. Can we turn out the lights, please, Dave? Thank you.
Oh, somebody almost busted their ass. A lot of fucking people wandering around this car now. A lot of Canton cops who shouldn't be dicking around with that car. I thought it was warm in the Sally Port. Well, when they close the garage doors, it'll be warm. This tape looks edited. No, it's just shitty quality, guys. EDW with 10 memberships. Thank you. Look at that. There's a whole gaggle of them hanging around the light. A whole gaggle of them. Is there a timestamp on this footage? No. Hold on. I wonder if we can see this timestamp at the bottom here. Yeah, there's a timestamp way down here. This is the timestamp. So 1:29:23 at like, it's hard to tell. Jim. Yeah, what did he just do with the bumper? Yeah, what are they doing with that? Like, yeah, let's go back to this. What the fuck are they doing? What are these guys doing here? Everybody's around fucking touching shit. This guy's looking, all these people are getting very close. Man, their old police car, they need to put a coat of fucking wax on that thing because it's like that's killing the paint. Someone should have swept it up before, or they would just raise the garage door at the right time. I don't understand why the garage door had the white stay open the whole time. Concerning all contamination, do we know if the hair is John's? No, we don't. It's a human hair, but that's it.
Is that the end of it, Mr. Lally? Or
I believe so, yes.
is that the end of it, Ms. Gilman? Okay. All right. Lights on, please, Dave. Thank you. All right. So I have a copy of the printed docket on 424. Paper number 347 was the Commonwealth's Notice of Discovery XL. I just asked Mr. McDermott to print it for me. Our printer up here doesn't work. All right, so that was before we impaneled. That was the day, I believe, of the long motion in limine trial. All right, so we'll take a 5-minute break, okay?
Thank you, Your Honor.
All right. So the judge is going to figure out what she's going to do. Did Chili DeCastro get to her printer? All right. With that being said, we got some stuff to get in the front of here, chat. All right. A couple things. Let's get back to that question that was asked, but in the meantime, EDW Raptor. Caw-caw. Although it's a raptor, it's only going to have 3 claws, so it's like caw-caw. Like he'll have 3 talons and then the back talon, so it's like ka-da-da. There we go. With 20 memberships. Thank you very much for your support and your generosity. 20 memberships, chat. Let's fucking go. Then EDW with another $10. Let's meet the goal, chat. Are we going all night? What is the goal? Well, we don't have a goal because we got the members only stream tonight. So nope, we don't have time for that. I appreciate it though. Thank you so much. And like I said, anybody who gets one of those, I know is going to be very appreciative of your generosity. In Amateur Iconoclast says, EDW purging the grays. I know. Just like in real life, we can't handle the gray men walking around here. The globalists have their grays running around Area 51. If I had my way, chat, we go in there and purge all the grays and all the reptile people, chat. We would make the globalists pay. They would have nobody to lord over them but us, real patriots. But I don't think he means those grays. Graxis, you ask a very good question. Now we can get to this. Can a witness, let's use Jen McCabe as an example. Could Jen McCabe take the stand, testify on direct, and then plead the fifth on cross? Now, here's what they can do. So I could ask Jen McCabe questions. So I'm up there. I'm the defense attorney, and it's my turn to cross-examine her. She can't just flat out refuse to answer any questions, period. That is not acceptable. That's not allowed. At that point, you might have to strike the previous testimony because now I'm being completely denied everything. That's a big, big problem. That's a big problem. You don't get to do that. That is not something we allow because now you're clearly just fucking around and gaming the system. You could get held in contempt for that possibly. Because that's not about if you wanted to remain silent, you shouldn't be testifying, period. If you're the party who offers that witness, oh my God, you might be catching a ration of shit as well. Because the court's going to be like, did you know this was going to happen? And if you did, God help you if you did. Now, I could be asking her questions, and after a while, I might ask her a question or two. She's like, I plead the fifth. I assert my right to remain silent. I decline to answer that on the advice of counsel. And I can hammer her on a couple questions, and she may do that. But no, she can't just stonewall like that saying, Mr. Martin, here's cross. And she'd say, fuck you, I ain't talking. That ain't good. That ain't good. It's never good. Duncan Ido gifted 5 memberships. Thank you, Duncan. Sean needs to have a House of the Dragon watch party. Yes. Yes. And as David says, literal vampire potbelly goblins hobbling around after us. Charlie says, do you have a topless goal like Rich from Review Tech USA? The only topless goal you're ever going to see from me is if I take this, or one of these, and put a top in the back of my skull. Otherwise, no. There is no top goal. Fuck a lot of Jurassic Park reenactments are where it's at. Yes. Clever girl. Forever get to sub, a dog is saved from the ATF. Yes. Defense has to do a heck of a job on cross for this. We'll see. I think there's when it comes to these like fact witnesses and the stories they're telling, there's only so many ways you could fucking go after Jen McCabe, and things like that. But with these guys, you're gonna have a bad day because they're stuck with the fact, like the actual physical evidence. So there's a lot of problems. They can't hide too well. Even though they're cops and they're trained to lie, and the forensic people are trained to be evasive, these guys are getting hammered right now. There's nowhere to run, baby. Nowhere to hide. Do. I mean, that's the thing. You can only hide so far when you're actually working for the state. And Bushmaster says, get wrecked, green names. Yes. Earl Ward said, so if the department allegedly killed their fellow officer, what was the motive? We don't know. And that's the neat part. You don't have to prove a motive. Offering a motive is very helpful, and I'm sure the defense is going to offer a motive. But I think they've kept that close to their chest because that gives the other side time to deny it. But I'm sure they're going to offer a motive. And like we were talking about, I'm sure there's been a lot of talk about the defense is going to bring up, maybe John was sticking his dick where it shouldn't have been. Why are we stream sniping a fan? Nick says, that's Celine Dion. Or it's Fannie Willis. Now, yes, chat, they do say this fan, and we covered this morning, just so you know. This fan right here, this fan, some say it dates back all the way to the Mayflower Compact. And Miles Standish crafted it himself with a draw knife, each blade. And he said, should this fan fail, then this Commonwealth shall crumble into the sea. So every day they watch it as it's on, having faith in it, but waiting for the day where if it stops, the state of Massachusetts will cease to be. Very, very dangerous. Very serious. Just tagged you on X. This video has not been shared with the defense team. I'll take a look at it in a second. We've got two other things to answer here. Graxis saying, thanks for helping me get through the workday. These streams have been entertaining. Well, they're helping me get through the workday too, Chad. Like I said, taking phone calls, doing my own, going through a transcript. It's all been all kinds of fun. So, getting ready to write a letter to a guy in jail, but I got to find out what prison he's at, and I can't figure it out. Duncan Idaho for 10 more subs. Let's go. That's right. Purging you grayskins out there. We're coming for you. And then Alexei muted. I think that's what we're going for. I love that. That's a very it's almost like a pencil sketch. It's very, very rustic. It really captures, is it pain or pleasure that man's going through right this second? Just I mean, you feel it. You feel it. It's like, ease his pain. What if it's always I don't recall? That's going to be the same thing. You were like, you just remember talking to him about that? Yeah, well, I have questions about that. What happened after that? I don't remember. You're fucked if you do that as a witness. I would be demanding everything stricken. And yeah, I'd be asking for a mistrial. I'd be asking for a lot of things. I'd be asking for you to get held in fucking contempt. I have jail pen pals? No, I have guys I'm writing appeals for, so I need to reach out to them. And I have to write them letters, and I have to write them through a special and then I have to get a special code for the letter that I put on the bottom. That way the letter doesn't get opened. Because it's legal mail, they don't have a right to inspect it. Got to do the jerky jerk making that face. Yes. Suffer not the great. Suffer not the great live. It's a pleasure of neglect. Oh my God, you guys are awful. Benjamin Lewis, could the jury sue Lally for habeas corpus? Not because the judge convened you, so you'd be pursuing habeas corpus at the federal district court level against the Superior Court of Dedham's, the Superior Court for Norfolk County. God, fuck my mom's language, and that the Cleveland accent is just running off on me there. The Norfolk County Superior Court, you'd be filing it against them, not the prosecutor. John C. says, if they keep pleading the fifth, could the judge hold a chamber and say, what the fuck's your deal? Yes. Mm-hmm. And do an in-camera review? Certainly. Certainly. Very true. Alexi is saying, I like my gray area muted, of course. My expertise. Ohio accents are the worst. No, it's just a little, there's really no accent in Ohio except for right along from like Cleveland to Toledo. There's a Cleveland accent. Sounds more like Parma, Sean. It's all Cleveland's accent. And then it like is blending into like the Chicago accent. It's really fucking obnoxious. And every time I hear it, I catch myself. Has any one of your former clients found guilty tried to hurt you? No. No, I mean, really, I mean, most of the times, like, yeah, I did what I did. We tried, it didn't work. I mean, and there's also the idea that, like, you come at me, you better come heavy because there's a good chance I'm rolling with a fucking gun. So, yeah. I've had victims' families threaten to hurt me. Oh, here we go.
Like I said, we gotta give them something.
Really think you family down. That is down there.
Thank you.
That's down there. That's down there in the holler.
All right, so we're ready to pick right up where we.
Do we know what happened in Akron? It was a gang shooting at a block party.
So I'll just be clear, the objection's overruled, Mr. Jackson.
Thank you.
It's my favorite concealed carry. Glock 19.
Sergeant, we're going to start up again with the video.
Your Honor.
Your Honor, for the record, I believe we're picking up where it was paused, which was 5:35:36.
Okay?
Pretty much. 290 people here, guys. Please give a like and subscribe if you enjoy this. Hello to everybody on Twitter, although you're probably all fake.
And Sergeant, as far as the condition of the vehicle as you observe it in this sort of pause still shot of the video, is that a fair and accurate portrayal of the condition as far as the snow or ice or anything you observed on that vehicle when it came into the Sally Port garage?
Yes, it is.
This gentleman, if you could right from there. Gentlemen, if you could just pause there for a moment. Sergeant's almost falling in video.
All right, so keep your voice up.
Sergeant Mechanic, with reference to any individuals you see in this video, do you recognize any of those individuals?
I can recognize Trooper Proctor myself. Other than that, I don't remember exactly who else was present at this moment in time.
If you could start using the laser pointer before you, just direct your attention to where you observe yourself and where you observe Trooper Proctor.
That's Trooper Proctor and myself. Then.
At any point in time when you were present with this vehicle in the Sally Port garage this evening of January 29, 2022, did either yourself or did you observe Trooper Proctor touch or manipulate in any way the right rear passenger side area of that vehicle?
No, we did not.
Ms. Gilman, if you could play it from here. I want to take a pause there just for a moment. Sergeant Mechanic, from what you're observing in this video, what you've seen or what you recall from this, what is it that you and Proctor and some of the other officers are doing now?
We're establishing a perimeter around the vehicle with yellow tape in order to prevent or alert and advise anyone in the area to stay away from the vehicle.
Who's going to be displayed to the end, please? Thank you. You can take that down, Mr. Officer. We can have the lights back on. Now, Sergeant Mechanic, are you aware of a warrant that was executed on that vehicle on February 1st of 2022?
I am aware.
And you yourself were not present for that, is that correct?
I was not present for the execution, no, sir.
Trooper Proctor was, as far as you're aware, is that correct?
That's correct.
Now, the next time that you were within the Canton Police Department Sallyport garage with the vehicle was on February 2nd, is that correct?
That's correct.
And on that day, where did the vehicle go from the police station?
From the Canton Police Station, I escorted the vehicle to the Milton Barracks for safekeeping.
And why was it taken from the Canton Police Station on February 2nd to the Milton Police Barracks? Or what had occurred in the intervening part between January 29th and February 2nd?
The Canton Police Department had recused themselves from interviews and in that portion of the investigation. And now that the vehicle had been processed, we needed to free up the Canton Sallyport so they can utilize that facility for transporting prisoners to their facility and booking. So we stored the now processed vehicle back at the Milton Barracks in a unheated garage.
And, Your Honor, if, with the court's permission, if I could publish just a very brief portion of what's been marked as Exhibit 34.
Okay.
Which is the Canton Police Department Sallyport garage camera.
Okay.
And Ms. Gilman, what you have up there, I'm sorry, February 2nd, 2022, approximately 8:09 a.m. And I'm just going to ask you to play that through till about 8:10:26. Sergeant, just for orientation purposes, again, this is another camera from within the same Sallyport garage, is that correct?
That's correct. That's the opposite view from what we just viewed in the previous video.
And as far as any of the people in this video, do you recognize any of the individuals in there?
I believe that's myself and then another officer. I don't know who that other officer is.
And just again, using the laser pointer, if you could, direct the jury's attention to where you see yourself. And as far as the condition of the vehicle from January 29th, when you saw it on that day, to February 2nd, when you saw it on that day, as far as the exterior of the vehicle, what, if anything, was different, or what, if anything, did you note or observe?
I noted the taillight removed and the evidence collected.
And as far as the snow and the caked on ice that you observed on that prior day, was that still present on February 2nd?
No, that had melted away.
And Ms. Gilman, if you could again, I'm sorry, just play through to 8:10:26. Ms. Gilman. And you can take that down. And Mr. Officer, we can have the lights back on. Thank you. Now, Sergeant Buchanan, with regard to Mr. O'Keefe's house at One Meadows Avenue in King, at some point did you become aware throughout the course of your investigation that there were exterior cameras affixed to that residence as well?
Yes, I did.
And those were Ring cameras, is that correct?
That's correct.
Now, with respect to investigation, what, if any, steps were taken in order to secure any of that footage from the exterior of the house from the Ring?
Objection.
No, I'll allow it.
We applied for multiple search warrants.
Objection.
All right, I'll see you at sidebar on this.
Muted.
And so, sir, during the course, let me ask you this, as far as this or any other investigation is concerned, how is it that members of your unit sort of work through an investigation or work on a case?
We,
Objection, Your Honor.
No, I'm going to allow that.
as a case comes in, we address each case on individual basis based on the evidence that is presented through testimony and physical evidence that is recovered. That is what guides our investigations, and we then develop leads and process information collected. Sometimes information needs to be collected from third-party holders of data or service providers, at which point to access that data, we apply for search warrants, which are guided.
Okay, so leave it, move on from that.
Thank you.
So you apply for search warrants, we'll move on from that.
So, Sergeant, my question is more geared toward as far as individual personnel within your unit. How is an investigation conducted as far as one trooper does everything, or is it a collaborative effort, or how is that?
The reason I say we is because every investigation takes the entire unit typically to put an effort in to conduct interviews, analysis, and so forth. So it's a team effort each and every time. No investigation is a one-man show. That's why we call it a case officer, not a lead investigator, because the case officer organizes the individuals to assign different tasks and collect and organize the data that comes back from the third-party providers and from the interviews that are conducted.
As far as the interviews that are conducted through the course of this or any other investigation, is there ever an interview that's conducted just by one trooper or one person in any investigation that you've done with this unit?
It is, no. We conduct interviews with two people, whether it's a trooper and a local detective, or two troopers assigned to our office, other state police agent unit within the agency.
Now, as far as the case officer, who was a case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
And Trooper Proctor works under your supervision, is that correct?
That's correct.
So as far as a search warrant for the Ring video from One Meadows Avenue, who specifically sat down, put pen to paper, and wrote the search?
Trooper Proctor was the affiant.
And as far as from that search warrant, are you aware of the materials that were provided by Ring in response to that search warrant?
Objection.
I'm going to allow it.
I am aware of it.
And have you reviewed both the material as well as the videos that were provided by Ring in response to that search?
I did.
Now, with reference to those videos, specifically, did you observe if you know, with respect to those videos, how were they sort of ordered sequentially, when in the manner in which they were provided as far as date, time, things of that nature?
Objection.
Ask it differently. Ask it differently, Mr. Lally.
So the videos that you received from Ring that you've reviewed, correct?
Yes, I did.
Objection.
No, I'll allow that. So he's reviewed videos from Ring. Next question.
What, if any, information did they contain as far as date or time?
The data provided back from Ring provided videos. There was no date and time on the labeling of the identifier, unique identifier for each video, but it was presented in a sequential order, knowing that the last video presented from the provider was the last video within the scope of our request, and the first one being the first in that timeline.
In the scope of your request, the scope of the request of the warrant, what time frame are we talking about?
Objection.
I'll allow that.
The first warrant we requested from January 24th at midnight through January 30th at midnight.
And with respect to those videos that were provided, you reviewed each of those, is that correct?
That's correct.
And Your Honor, with the court's permission, I would ask to publish certain of those videos for the public this time.
So are these, why don't we come to sidebar?
You are unmuted.
Ms. Gilman, if I could have from what's been previously marked as Exhibit 6, first video 119. If you could pause there, Ms. Gilman. Now, with reference to this particular video, number 119 in Exhibit 6, Sergeant, what, if anything, can you tell the jury as far as the timing of this particular video?
Based on the appearance of the driveway, we know that this recording took place prior to the blizzard of January 29th.
Sorry, guys. Sorry. Was on the phone. I'm back now. So wow, Karen drives like a woman. This car looks like it's been beat up. Damn.
And as far as anything that you observe in this video, as far as vehicles or people within those vehicles, what, if anything, did you observe within this video?
I observed Mr. O'Keefe's car parked in the same location as he typically parked it, and then
Objection.
I'll strike the as he typically parks.
and then a black SUV parked perpendicular to Mr. O'Keefe's vehicle, adjacent to the entryway to the garage.
That's fair. That's fair. Tukik, I'll explain what that's all about in a second.
Tell me if you could pause it. At some point in the course of your viewing of this video or the video surrounding it, were you able to identify the operator of the vehicle, black SUV?
Yes, that is the defendant operating her black and color Lexus SUV bearing Massachusetts plate 3 GC 684.
And if this gentleman, if you could play it. Now, Sergeant Mechanic, are you also aware from your review of the ring videos from One Meadows Ave, another video depicting the defendant leaving the house sometime shortly after 5 a.m. on January 29th?
Yes, I am.
And Ms. Gilman, if I could also from Exhibit 6 ask for, video 153. If you could just pause there for a moment. Now, Sergeant, with reference to this video and the one just previously from 119, where is Mr. O'Keefe's vehicle parked in relation to this video vis-a-vis the other video?
The vehicle's parked in the back corner of the driveway along the fence in the same location as it's parked in the previous video.
And at some point, do you see the defendant's vehicle back out of the garage in the same directionality that it did in the prior video 119?
Yes, you do.
And Ms. Gilman, if you could address it. Pause there for a second. Now, as far as the operator
There you
of that
go.
vehicle, are you able to observe who that operator is within that vehicle?
No.
I observed the vehicle being operated. I cannot identify who the individual is, and then from that shot right there.
From at any point in the shot of the video that you observed, were you able to recognize the operator?
Not from that shot, no.
Now, with respect to the timing of this video, what time in the morning is this video?
The time.
Chat, she hit John's car so hard, John died. That's what happened here. She hit John's car so hard, John was out standing at the party and just killed over dead. That's the story.
Timing of this video is approximately 5:07 a.m. when the defendant left the home through the garage via her vehicle.
Well, I think they're going to argue we didn't find any glass on the ground.
Now, from this particular pause portion of the video, Sergeant, what, if anything, of significance do you observe within the still shot of this portion of the video 153?
The portion of this video in the still shot presented identifies a missing, damaged rear right taillight, exposing the white light coming from the right side of that taillight.
And if you could, using the laser pointer, before you draw the jury's attention to what you're talking about as far as that area of the defendant's vehicle.
I'll move the subtitles. Hold on.
Now, earlier in that video, did you observe the defendant's vehicle coming close to or coming into contact with Mr. O'Keefe's vehicle?
Yes, I did.
And as far as Mr. O'Keefe's vehicle, at least from this video, what if any damage did you observe to Mr. O'Keefe's vehicle?
No damage.
And as far as the ground area around where Mr. O'Keefe's vehicle is parked, specifically the rear of that vehicle, what if any red pieces or anything do you observe on the ground around Mr. O'Keefe's vehicle?
Nothing was observed.
Ms. Gilman, if you could press play. And Ms. Gilman, from Exhibit 6, if I could have video number 165. You can pause there, please. And Sergeant, have you reviewed this video as well?
Yes, I have.
And when time-wise, in relation to January 29th, approximately is this video?
It's approximately like 12:30 in the afternoon.
And as far as the vehicles in the foreground area from this particular camera shot, you know whose vehicles those are?
Yes. The vehicle in the top left corner is Mr. O'Keefe's vehicle. Vehicle in the middle left is the defendant's vehicle. And I do not know who the other two vehicles are.
Ms. Gilman, if you could press play. Pause there just for a moment, Ms. Gilman. And Sergeant, from the two individuals exiting from that vehicle, do you recognize who those individuals are?
Yes, I do.
And if you could, just using the laser pointer, direct the jury's attention to whom you recognize and identify who that person is.
That there is the defendant, and that there is Mr. Reed.
Again, Mr. Reed, the defendant's father, is that correct?
That's correct.
And Ms. Gilman, if you could press play. Thank you. Ms. Gilman, if you could pull up video 166 from the same Exhibit 6. Ms. Gilman, if you could pause there just for a moment. Sergeant, do you recognize the person that just exited from that vehicle and behind the defendant's vehicle?
Yes, I do.
Who do you recognize that to be?
As a defendant's brother.
And Ms. Gilman, if you could press play. Ms. Gilman, if I could have from the same Exhibit 6, video 171. Ms. Gilman, you can take that down. Mr. Officer, we can have the lights back on. Sergeant, from your review of those videos, at various points you observed the defendant's brother cleaning off the defendant's car, correct?
That's correct.
At any point in time, did you observe the defendant's brother cleaning off the area of the right rear passenger side's taillight of the defendant's car?
I did not.
Now, Sergeant, turning your attention to February 1st of 2022, yourself and Trooper Connor Keith, is that someone you're familiar with?
I am.
And he works within your unit as well?
Yes, he does.
And at some point, did you and Trooper Keith on that day go to the C.F. McCarthy's establishment?
Yes, we did.
And what was the purpose of your visit to C.F. McCarthy's on that day?
The purpose of our visit was to retrieve surveillance video during the target time in question that we knew the victim and the defendant had visited that establishment. Also, any transaction receipts that we could collect from that location.
And were you able to retrieve both video as well as transaction receipts from that establishment?
We were.
And I'm sorry, my apologies. Before I get into that, may I approach the witness, Your Honor?
Yes.
And Sergeant, I'm showing you a series of 14 photographs or still shots. If you could just look at those and look up when you finish. And do you recognize those, sir?
I do.
And what do you recognize those to be?
I recognize these to be still photographs of the ring video that we just watched.
And that would be video 153, the one with the defendant backing out sometime after 5 a.m. on January 29th.
That's correct.
May I approach, Your Honor?
Yes.
Call Malta seek to introduce and admit as the next exhibit.
Okay.
No objection.
Thank you.
Thank you. Thank you.
Thank you so much. Your Honor, with the court's permission, may I publish just a couple of these photographs?
Okay.
Ms. Gilman, if I could have photograph number 30. And Sergeant, you recognize what's up on the screen now as Exhibit 456?
I do.
And Ms. Gilman, if you could just zoom towards the rear of the vehicle. Have a moment, Charlie.
Yes.
And Sergeant, what's up on the screen now? If you could direct the jury's attention with that laser pointer to the area of the rear passenger side taillight that you were describing damage. Thank you, sir. Okay. Ms. Gilman, you can take that too. Thank you, sir. Mr. Officer, you can have the lights back up. Thank you, sir. So Sergeant Mechanic, if I could take you again, I'm sorry, back on February 1st to CF McCarthy's. You secured video and receipts from that establishment on that day?
That's correct.
And as far as the video and receipts, were you then able to subsequently review those at some point?
Yes, I was.
Now, first, starting with respect to the video. Your Honor, may I approach?
Yes.
I'm showing you two photographs of still shots. Just ask you to look at those, look up when you're finished. And do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are still shots of the CF McCarthy's surveillance video that we collected from that establishment, from the dining room camera angle.
May I approach again, Your Honor?
Yes.
I'm about to sit to introduce in a minute as the next exhibit.
No objection. Your Honor.
Thank you.
461.
Thank you.
So that picture of her driving away with the taillights on, that is interesting. But until she's in reverse, you can't tell how much of that light's shining through and stuff. It's not clear.
Your Honor, with the court's permission, if I could ask that those be published to the jury at this point.
Nope, this
Okay.
is at speed because it's live.
And Sergeant Mechanic, you recognize what's up on the screen?
Yes, I do.
And if you could, using the laser pointer, draw the jury's attention to what, if anything, of significance you observed is still shot from the CF McCarthy's video.
We observe the victim, Mr. John O'Keefe, here. Appears to be communicating with the defendant here. Mr. Camarano is over here as well. Mr. Sullivan is down here as well. Mr. O'Keefe is wearing the gray light two-tone sweatshirt that I held up earlier, as well as the jeans.
And the next still shot is going to. And similar to this, similar to the previous one, excuse me, Sergeant, do you recognize what's depicted in this still shot here?
Yes, it's, again, the victim on the other side of the defendant, still dressed in the same outfit, and the defendant standing in front of him.
And as far as the bar area adjacent to the defendant, what, if anything, of significance do you know there?
The bar area is located near the taps, the draft beer taps at C.F. McCarthy's. So if you were to look at the bar from the street, that is the left side of the bar orientation on the way to the restrooms.
And I'm sorry, I should have been more specific. As far as the sort of shelf of the bar immediately adjacent to the defendant's left arm, what, if anything, do you observe that?
Here, I observe a cylindrical vase-style cocktail glass on the bar, as well as other beer bottles.
Okay. Ms. Gilman, you can take that down. With reference to the C.F. McCarthy's video, Your Honor, with the court's permission, I would ask to publish certain portions of that. It's already been marked as Exhibit 50.
Okay.
Ms. Gilman, if you could, from the first video. If I could ask you to pull it up to about 7 minutes and 50 seconds. And Ms. Gilman, if you could pause just for a moment, I'm just going to ask you to play from 7:50 to about 8 minutes and 20 seconds in, but I may ask you to pause it. Ms. Gilman, if you could pause there. Sergeant, as far as just, again, for orientation purposes, with reference to the entrance or exit, point of ingress, egress for this bar, do you observe that somewhere within this video?
Yes, at the top of the screen is the front door to C.F. McCarthy's bar. And as we just viewed, the two gentlemen walking in, they walked in through the front door, heading to the taps area, draft beer location of the bar.
And if you could, just using the laser pointer, direct your attention to that front door area that you're talking about.
The front door area is located right here.
And with respect to those two individuals that came in, do you recognize those two individuals?
Yes, that is the victim, Mr. John O'Keefe, dressed in the same outfit as before, and Mr. Camerano.
If you could play that till about 8:20. Ms. Gilman, if I could ask you from the same exhibits, same exhibit 50, from the third video now. If I could ask you to go to about 6 minutes and 10 seconds in. And I'm going to ask you to play that till about 6 minutes and 43 seconds. If I could ask you to pause just there. As far as the individuals around Mr. O'Keefe and Mr. Camerano, do you observe or recognize anybody else in the bar area around them at this time?
Mr. O'Keefe is sitting next to Mr. Camerano. I believe Mr. Kurt Roberts is there as well, next to Mr. Camerano.
Now, from this time, we're at about 8:51 p.m. or so within the video. Is that correct?
That's correct.
Now, as far has the timestamp on this video. What, if any, information were you provided when you retrieved this video on February 1st in relation to that time and its accuracy to sort of what time was?
During video surveillance extraction, we verify the time and date on the system, and that is to show us how far behind in the past or in the future. Sometimes devices are timestamped that's in the future. It hasn't happened yet in real time, but the video is stamped so. So what we do is, prior to extracting video, we identify the difference in time between real time and video time. In this case, C.F. McCarthy's video was 12 minutes behind real time.
And thank you. And Ms. Gilman, if you could play this to about 6 minutes and 40 minutes. Just pause there briefly, Ms. Gilman. As far as anyone else within the area of the bar, the area, Mr. O'Keefe, Mr. Cameron, Mr. Roberts, who, if anyone else, do you recognize in that area at this point?
I recognize the defendant walking in and interacting with the victim, Mr. John O'Keefe.
Ms. Gilman, if you could, within that same video 3, I would ask you to go to about 13 minutes and 15 seconds. And I'm going to ask you to play from here to about 14 minutes and 45 seconds. Pause there. Now, from your review of this video, what, if anything, of significance do you observe in this part of the video?
This part of the video, I observed the defendant reaching over and retrieving a cylindrical, tall cocktail glass from the bartender.
And again, given the understanding that the video is about 12 minutes off as far as the timestamp, the defendant entered about 8:51 p.m. and is receiving this drink about 8:58 p.m. Is that correct?
That's correct.
And if you could, just come and play that to.
This is punishment, chat. This is brutal.
Now, Ms. Gilman, if you could go up to about 32 minutes even in to the same video. Now I'm going to ask you to play that for the next 30 seconds or so to about 32 minutes and 30 seconds. And Sergeant, during that, about 30 seconds or so, what, if anything, of significance did you observe the defendant to receive at that point?
A cylindrical cocktail glass.
And so that would be the second drink, is that correct?
That's correct.
And that's at approximately 9:15, is that correct?
That's correct.
And Ms. Gilman, if you could go forward to about 37 minutes into this same video. If you could play that for about the next minute or so, for about 38 minutes. Now, Sergeant, again, from that about 1 minute portion from that video, what, if anything, of significance did you observe the defendant receive and do with any items?
She received the shot glass beverage and poured it into the tall cylindrical cocktail glass, and then Mr. John O'Keefe stirred it for her.
And so that would now be the third drink, is that correct?
That is correct.
And that's about 9:20 p.m., is that correct?
That's correct.
Ms. Gilman, if I could direct you to the fourth video, video number 4. And ask you to go about 50 seconds into into this video. And I'm going to ask you to play this, Ms. Gilman, from 50 seconds to about 1:30. Thank you, Ms. Gilman. So, Sergeant, from this particular video, what, if anything, of significance do you observe the defendant receiving during this time frame?
She receives another shot glass beverage and then places that liquid into her tall cocktail glass and stacks the second shot glass into the first shot glass into the first tall cylindrical cocktail glass she had previously received and consumed.
So this would now be the fourth drink, is that correct?
That is correct.
And per the video, that's about 9:33 p.m., is that correct?
That is correct.
And Ms. Gilman, within this same video, if I could ask you to go to about 26 minutes and 30 seconds. Ms. Gilman, if you could pause there for just a moment. I'm going to ask you to play this until about 27:40. Thank you, Ms. Gilman. During that period, Sergeant, what, if anything, of significance did you observe the defendant to receive during that time frame?
She received a tall cylindrical cocktail glass.
And in addition to that, what, if anything else, did she receive from the bartender during that time?
A shot glass size beverage.
And what, if anything, did she do with the shot glass in regard to the larger cylindrical glass?
It was placed inside the tall cylindrical cocktail glass.
So that would be drinks 5 and 6, is that correct?
That's correct.
And per the timestamp on the bar video, this is now about 9:57 p.m., is that correct?
Correct.
And Ms. Gilman, if I could direct you to video number 5. And if I could ask you to go to about 3 minutes in. And ask you to play that till about 3:30 or so. Thank you, Ms. Gilman. And if I could ask you to go to about 10 minutes and 30 seconds in. And I would ask you to play that for about a minute to about 11:30 or so. Thank you, Ms. Gilman. So Sergeant, sort of rounder shots during this portion of the video, is that correct?
That's
Yeah, sustained. You can ask it differently.
What, if anything, of significance did you observe the defendant and or the group that she was with do in this portion of the video?
in this portion of the video. The two gentlemen to the right of the defendant consume a shot-size beverage.
And as far as the shot glass that the defendant received, what, if anything, do you observe her to do with that?
Objection.
I'll allow it. Or strike that. Just what did you observe, not what she had.
What did you observe the defendant to do during that portion?
Prior to the shots being taken, a shot glass was poured into the cylindrical tall glass.
And again, so that would be drink number 7 at that point?
That would be drink number 6.
And I'm sorry, so the previous portion was a cylindrical drink and then a shot glass that was 5 and 6, is that correct?
Objection.
I think that was the testimony, but ask it differently.
As far as that drink during that portion, is that drink number 6 or drink number 7?
Objection.
Yeah, in that form, I'll sustain it.
At this point in time in the video, after watching what you watched, how many drinks has the defendant consumed at this point?
At this point, she's consumed or is in possession of
Objection.
I'll allow it.
6 drinks.
And this is at approximately 10:29 p.m., is that correct?
Yes, that's correct.
Ms. Gilman, if you could go to about 20 minutes and 30 seconds in. Actually, wait for the next 10, 20 seconds or so. So during that portion of the video, what, if anything, do you observe as to the drink the defendant has and how full it is at that point?
She has a cylindrical tall cocktail glass in her hand.
And can you observe, or did you observe how full that glass was?
Drink number 6 is empty, or near the bottom, almost empty.
And Ms. Gilman, if I could ask you to go to about 22 minutes and 40, I'm sorry, 22:40 or so within for the time stamp, I'm sorry.
This is borderline criminal rewatching all this crap again. Seriously.
Now, from this portion of the video, Sergeant, what, if anything, do you observe the defendant and Mr. O'Keefe doing in reference to C.F. McCarthy?
Once the defendant got drink number 7, the defendant and Mr. O'Keefe walk out of C.F. McCarthy's, the defendant holding the beverage, tall cylindrical glass in her hand.
Thank you, sir. Now, may I approach?
Yes.
Ms. Gilman, you can take that down. I'm sorry. So I'm showing you a 5-page document. Ask you to review that, look up when you finish. And do you recognize that document, sir?
Yes, I do.
And what do you recognize it to be?
I recognize it to be a series of transaction receipts from the tabs at C.F. McCarthy's.
And are these the transaction receipts or tabs that you received, you and Trooper Keefe received from C.F. McCarthy's on February 1st, 2022?
Yes, they are.
And with reference to those receipts or tabs, to whom, if anyone of significance, do those tabs pertain to?
The first one for 5280 was opened under the bar tab Karen A. Reed.
And is there also a receipt from John O'Keefe?
Yes, it is. The transaction through the credit card being a MasterCard for $52.80, was paid by Mr. John J. O'Keefe.
And with reference to the items listed within that particular receipt, what, if any, items of significance do you observe listed on the receipts?
Under Karen A. Reed's receipt, 1 Tito's, $10, 1 Tito's, $10, 1 Coors Light, $5.
Objection, Your Honor.
Sustained.
May I approach, Your Honor?
Yes.
Call them up to speak to introduce and admit as the next exhibit.
We probably should approach
Okay.
briefly.
Seriously, this is just. She could get $100 for these shots if she's a YouTube streamer. Yes, she probably could. These nudes. Was Abel says was let's go, Brandon, at the bar with Karen Reed. I don't know, Brandon. Brandon, were you there? Brandon, we've got questions, buddy. The glass don't look empty to me. Yeah. Anyone notice that since the Ricada fiasco, Brandon's been AWOL? Ooh.
You are unmuted.
Actually, I don't think he has been.
And so, Sergeant Mechanic, on those receipts from C.F. McCarthy's under both Ms. Reed's receipt and Mr. O'Keefe's receipt, there was Tito's Vodka listed on the receipt, correct?
Correct.
Now, also on February 1st, what, if any, other establishments did you go to in the town of King?
Myself and Trooper Keefe went up across the street to the Waterfall Bar and Grill and retrieved transaction receipts and video from there as well.
As far as the video is concerned from that establishment, have you reviewed that video as well?
Yes, I did.
And with regard to the receipts from that establishment, you reviewed those as well. Is that correct?
That's correct.
Your Honor, may I approach?
Yes.
So I'm showing you 4 photographs or still shots. If you could review those and look up when you're finished. And you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are still shots of surveillance video from the Waterfall Bar and Grill on the night of January 29th after midnight. And Mr. O'Keefe is depicted in the still shot.
And those are both interior as well as exterior camera shots of Mr. O'Keefe's sort of exit from the waterfall. Is that correct?
That's correct. Interior, him leaving at 12:11 a.m., which the timestamp on the surveillance video at the waterfall was accurate to real time. He is holding a beverage shorter cocktail glass in his right hand as he exits the establishment. He's seen on the exterior camera walking towards Washington Street.
Mm-hmm. I remember
May I
that.
approach, Your Honor?
Yes.
I'm about to seek to introduce and admit as the next.
No objection.
Thank you.
Thank you. Your Honor, with the court's permission, if I could ask that publish for the jury?
Yes.
And Ms. Gilman, if I could just have the first one. My apologies. Ms. Gilman, if I could have the first one from the interior. Thank you. And Sergeant, do you recognize what's up on the screen, which has now been marked as Exhibit 464?
I do.
And what do you recognize that to be?
That is the still shots presented to me and entered into the exhibit of Mr. O'Keefe walking out of the Waterfall Bar and Grill at 12:11 a.m. on the night of the early morning hours of January 29th, holding a cocktail glass.
And if I could have the second still from this set, Ms. Gilman. And again, do you recognize what's up on the screen, sir?
Yes, sir.
And if you could, using the laser pointer before you, just direct the jury's attention to where you observed Mr. O'Keefe and what, if anything, you observed Mr. O'Keefe holding as he was exiting the waterfall.
Mr. O'Keefe is observed here. He's holding that shorter, fatter cocktail glass as he's walking out of the establishment.
And Ms. Gilman, if I could have from the exterior, just the second one, please. And again, Sergeant, do you recognize what's up on the screen, which is now marked as Exhibit 467?
Yes, I do.
And if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed in this still.
This is Mr. O'Keefe walking out of the Waterfall establishment, holding the cocktail glass in his right hand as he walks towards Washington Street.
Thanks. Ms. Gilman, you can take that. Mr. Officer, we can have the lights. Thank you, sir. Your Honor, may I approach the witness?
Yes.
So I'm showing you what's been previously marked as Exhibit 54. Just ask you to look at that and look up if you could. And do you recognize what's contained in Exhibit 54?
I do recognize it, yes.
And are those the receipts that you received from the waterfall when you went there on February 1st?
Yes, they are.
Thank you. May I approach again, Your Honor? Just-
Yes.
Now, sir, with reference to the waterfall, in regard to the timestamp on that surveillance video, what, if anything, were you told as far as the accuracy of that timestamp when you retrieved that video?
That video was confirmed to be accurate in time, as in real time. No discrepancy.
And Your Honor, with the court's permission, if I could just publish 3 quick clips from what's been marked as Exhibit 53.
Okay.
Ms. Gilman, if I could ask from Channel 3, the second video down. If I could ask you to go from the timestamp on the top of the screen to 10:54 in 25 seconds. If you could play them. I could ask you to pause right there. So, Sergeant, from that particular portion of the video, what, if anything, of significance did you observe occur there?
That portion of video depicts Mr. John O'Keefe walking in with the defendant, defendant gesturing to a group of people at the top of the screen, and then Mr. O'Keefe walking over and giving a hug to an individual that's part of the group.
So from the same channel 3, Ms. Gilman, if I could have from the 4th video down. If I could ask you to go 11:39 and 40 seconds. Pause there, thank you. And in about 5 to 10 seconds or so, I'm going to ask Ms. Gilman if you could pause it, and I'm just going to ask Sergeant if you could direct your attention to sort of the top right corner of the screen. Thank you. Pause there. From that portion of the video, you observed the defendant in that portion of the video?
Yes, I did.
And what, if anything, did you observe her to be doing?
She retrieves a drink from the table and appears to consume it.
Now, as far as the drink and the tall cylindrical glass that you observed her walking out of C.F. McCarthy's with, what, if anything, did you observe from the glass that she's taking a sip of from this portion of the video, the waterfall?
It's a shorter, fatter style glass compared to the cylindrical tall style that she walked out of C.F. McCarthy's with.
Thank you, sir. Ms. Gilman, you can take that. And Mr. Officer, if we could have the lights. Thank you, sir.
Mr. Lally, why don't we end for the day? It's been a long day. Everybody ready to go home? Yeah, okay. All right, so Sergeant, we're gonna meet you back tomorrow, and I'll ask you to just follow the jurors out when they leave. So jurors, those same reminders, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. We'll see you tomorrow morning.
All rise for the court, please. Jurors, follow me.
And I will see counsel at sidebar about scheduling, please.
Sidebar, please.
All right. So where are we right now? I think it's still a pretty good day for Karen Reed and the team. And, well, it's already 4:30, so we're ending like 6 minutes ahead. Yeah, her attorneys are definitely telling her today was a good day. Look, Karen is fired up. That nice, airy, sun shirt. Karen's ready to get it on. Let's see here. We got a couple. Duncan says, I would not miss the defense examination of Proctor for the world. Neither would I. I bet the entire courtroom has their hackles raised at just thought him after the defense is opening. Oh, I want to see it. Oh, there's Turtle Boy. Good. He's being a good boy, not guzzling juice today. How many pieces of broken taillight fell off while being towed? Who knows? It's a black screen. How is it evidence? I mean, it's evidence, but it's up to the jury to decide the weight of the evidence. How much weight do they assign to it? We can't see anything on it. It's up to the jury to decide whether or not. Remember, it all has relevancy. This has relevancy. They were there. But it's up to the jury to decide the weight of that evidence and how much they use it. Tuck Tech has, don't they need to qualify what they're objecting for? A lot of times you have to state like a basic objection, but this is a case that has been going on for years now. There have been multiple motions filed. This case has been thoroughly briefed. Like all the issues and major contentions where the judge has just come on up, they've already addressed all this stuff in one form or another. So no, this is they've already done this. They know the problem with each one of these issues, and now they're to the point of now it's actually now the issue is ripe for argument. We're going to make our ruling. So no, a lot of these times they already seem to know what's going down. That's at least my interpretation of all this. MLP says that a lot of sidebars is that normal. Not this many, no. But this is a very technical trial. There's a lot of issues. There's a lot of issues with the rules of evidence that are going on here and procedure. Yeah, this is like in a hard trial like this, you're gonna have a million of them. So in a case like this, no, it's perfectly normal. In a regular case, like you drive down to your local courthouse and you go watch a trial, no, this your judge would most judges would be pissed if a regular trial was like this. And Duncan is saying, wait, is this Ollie establishing the extreme plausibility? She broke her taillight not on John, but on his car earlier. Kind of seems that way. I mean, I think they're trying to show that the taillight wasn't damaged, but it's hard to tell from that nighttime picture. And Duncan is claiming also, what an infuriating parking arrangement. Oh, I know, but you know what? John strikes me as the type of guy, like, I've got my way and it doesn't make fucking sense. It's my way. And Nick Kreuzer is saying, so why did these guys kill their fellow cop? What's the real info behind this massive sham? Thank you for the $10 super chat, by the way. Don't know. Well, the defense hopefully shows something. But for right now, who knows? I have no fucking idea. I don't know. I really don't know. And I don't know if we're ever going to know. We'll have a lot of theories. We will have a lot of theories for sure. Abel D's nuts. Says, what would happen to a juror if they object, comment, or question anything while on the juror box? Oh, while they're in the box in the middle of trial? Immediately stop. You're out. Probably get held for contempt. There might be a contempt issue because you might be in a mistrial setting. Depending on what they said, this might be grounds for mistrial, and your ass is getting a contempt hearing. Why shouldn't I hold you in contempt right now? So easily could have happened. Project Calm saying, wait, wasn't she surrounded by active law enforcement people? Yes, she was. There's just so much of this is so fucking weird. Just show the bar bill, job done. Yeah, why aren't we just seeing it? KRM said she could get $100 for these pictures if she was a YouTube streamer. Yeah, she could. Maybe that'll be after she gets done. Abel is saying, was Let's Go Brandon at the bar with Kara Reed? Brandon, we have questions, buddy. We have questions. And then Juror 13 says, you guys catch the part where he said, we don't have a lead investigator per se. Yeah, who's in charge? Well, nobody's in charge. That's what shitbags do to avoid accountability. But none of us are in charge. None of us can be held in trouble. I mean, that's a real asshole way of doing it, in my opinion. So, not a surprise. Let's see what you guys are talking about here. When's Proctor getting on the stand? I don't know. Ariel saying they're trying to set it up so they don't have to call him. Of course they are. It sounds like the trial's being dragged out. Yes. We'll see what they're talking about because it's still going. No one wants another redo on this trial. Oh, yeah, nobody wants to redo this. It'd be awful for both sides. So let's see. What are they sitting there doing? Like, I don't know, chat. And you guys, if you don't remember from before, this area right here is for the victims. This area right here is for Karen, the defendant. And then up here are the reporters. little retard section. And then the jury is down here. So that's how the courtroom is set up. So I don't know what they're talking about. This must be really important. Marika says, "What up, big dog? Not much. Not much. What percentage of the jurors are searching online? Probably all of them by now are definitely doing this. That's just the nature of it." Marika says, "Why is this courtroom so small?" I keep telling you guys this. Like, almost all courtrooms are this small or smaller. Like, this is normal for America. Most courtrooms are not meant for, like, being television presentation sets. You get some that are, but most aren't. This is normal. All over America, you're going to find small courtrooms. It also doesn't help this is like some sort of weird shape. But traditionally courtrooms are not massive. When in America, we tended to do trials in the summer outside so the entire town could watch. So tomorrow I will give you guys a heads up. We will have to start Karen Reed in the afternoon, probably around 2:30. And that's just because I have a hearing at 1 o'clock I got to get to, and I'll be taking care of some garbage in the morning. So, just doing that. Is that Karen at the center table? Yup. This is Karen. That's Karen Rudd. Karen Red. Karen can't read. We haven't established that yet, but yes, that's Karen Reed. That's Karen Reed. That's her. That's her. This is John O'Keefe's brother, the man she allegedly killed. That's the brother. So, we're just waiting. We're waiting with the... Waiting.
All right. What's the adjourned?
It's a goodbye. All right, guys. So, like I said, tomorrow, probably like 2:30 or so, 2:30/3. And that's going to be EST. We will start up, but I've got stuff to do tomorrow. So that'll be the thing to start there. And then also in addition, if you guys are new, tomorrow is Thursday. God, it's Thursday already. We have the Thursday night show. And with that, we've got a lot of subjects to talk about, all kinds of neat things and fun things out there. So if you guys would like to join us Thursday night at 9:30, we will be doing that and having a lot of fun. You say you're watching Turtle Boy right now? Is he live? Is he live right now? Is it tomorrow an off day? I thought tomorrow was a normal day. So, let me see here. Let's see Tutta Boy. Turt Boy. Turt Boy. TURTLE power. That's the turn the Ninja Turtles goes. Nope, he's not live right now. So, figured if you say something stupid, we watch it. If you actually love your blog, yes. So tomorrow, yes, we'll do the half day tomorrow like normal, so we'll be able to catch up and then have the 9:30 show. And we have, I think, a question or two left, and then we're gonna. Boy, does Kirsha know about Turtle Boy? Does she? Does she know about him? Is Kirsha on right now? She's one of the people I've wanted to talk to for a while because she's fucking hilarious. 10K views, explain how the jury can review evidence following their deliberations. Can they see all the evidence and testimony? Remember, they don't get transcripts of the witnesses. But if there's videos, they have the right to see them. They get physical things with them. They get all the pictures and reports. I mean, they get a lot of the junk that goes back in there with them. The forensic stuff, like the clothing, that might be like they'll have to ask for it and it'll get brought in for them. Or they'll have it presented to them. I think that's what you're asking, but following their deliberations, once they're done, though, it's done and they don't get to look at it ever again. But yeah, you give them almost everything you can give them and take them into the back room. Like the things that definitely don't go back are like guns. You definitely don't let them take guns back, even if they're safetied. You don't take ammunition back. And then if it's drugs, depending on the type of drugs, like if it's fentanyl and shit like that, you don't let them take that back because you know I'm accidentally contaminating a room. So they might have to come back out and take a look at it if they want it. So I thought you DM Kirsch. She probably began to chat. Oh, I have. Kirsch is she's very she seems like she's going a million miles a minute. So I talked to her. At some point I'll run into her. It'll be fun then. Oh, Kirsch is originally from Boston. She doesn't sound like it. Huh. Did not know that. In Cook County Criminal Court is a gallery glassed off. That's funny. Who the hell's Kirsha now? She's a VTuber. She's like Pippa's mentor. In a very based way. So, but with that said, chat, that's it for us today. We are all caught up and yeah. Like I said, tomorrow's starting late, but I think it will be fun and we'll go from there. And Adriana says a shot of vodka and a bump of Coke. That's one way to party. All right, chat. So like I said, I will see you guys tomorrow about that. Tonight, we will be doing the members only stream and we will be doing it at 8:30. Gonna look at some body cams and hang out and have some fun time. So if you remember, you will be welcome to join us. So I hope I see you guys there. And yeah, that's pretty much it for now. I'm giggling. Fine Fix Finish is going over the farms. Wait, who is? I've never heard of this guy. Fine Fix Finish. Who the fuck is this? So, I'll give them a look. Maybe I'll watch them in the afternoon for a minute. I choose you, Shanichu. Oh no. Nick Kreuzer with 5 memberships. Thank you. Thank you for your support, your generosity. And how many hours is that? Like 4. So. Now, guys, so we will do this. We'll be back at Karen Reed tomorrow afternoon, like I said. And until next time, even if she did it, she's still not guilty. I have not been convinced beyond a reasonable doubt Karen Reed is guilty. So that is it for me, chat. And I will see you guys tonight at 8:30 for the member stream. Good night.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. just don't talk to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was. He even knows he's fat.